ಮೈಕ್ ಉಪಯೋಗಿಸ್ಲಿಕ್ಕೆ ಹೇಳ್ಬೇಕು.
ಫಾರ್ ಮಂಡೇ
ಏನು ಅರ್ಜೆನ್ಸಿ ಏನ್ ಬ್ರದರ್?
2004 ಅಲ್ಲಿ ಅಬ್ಸಾರ್ಪ್ಷನ್ ಆಗಿದೆ. Now it is sought to be recovered and KAT went to KAT is dismissed. Now they are starting recovery.
Sorry.
Monday.
Serial number 17, my serial number 17, my lord. Pray for a week's time. I have to file statement of objections ready, Your Honor. My lord.
Ready.
The statement of objections is there. I will file it next 1 week.
21 matter.
17.
21 matter.
Yes, my lord.
Then no time will be granted.
Yes, my lord.
No time will be granted.
Next week.
ಎಷ್ಟು ವರ್ಷ ಹೇಳಿ? WS ಹಾಕ್ಲಿಕ್ಕೆ ಎಷ್ಟು ದಿವಸ?
ಸೆಕೆಂಡ್ ಸೆಟ್ ಒಂದು ಸ್ವಲ್ಪ
ನಾವೇನ್ ಮಾಡೋಣ ತೊಗೊಂಡದ್ನ? 2021 matter. Have you seen the writ proceeding rules 1977? Rule 39? You have adopted CPC for writ proceedings.
In fact, in this case, my lord, ultimately, even if any benefit to be extended, ಒಂದು 7-8 ಜನ ಮಾತ್ರ ಉಳ್ಕೋತಾರೆ. ಅದನ್ನು ಒಂದು ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ರೆ ಮುಗಿಸೇ ಬಿಡ್ಬೋದು ಇನ್ಸ್ಟೆಡ್ ಆಫ್ ಅದನ್ನು ಸಹ ಹೇಳಿದ್ವಿ ನಾವು ಯೂನಿಯನ್ ಹೇಳಿ ಕಳಿಸಿದ್ರೆ
ನೆಕ್ಸ್ಟ್ ಏನು ಯಾವ ಬೇಕಾದ್ರೂ ನೋಡ್ಕೊಂಡು ಹೇಳಿ. Finally, next week, at the request of counsel for the respondent, reluctantly granted 1 week.
Lordship, serial number
objection statement.
serial number 18, Lord, for this is regarding resignation, Lord. So after his resignation, he sought for pensionary benefit. Lord, suppose state has filed a petition, Lord. Suppose AG appearing this matter, Lord. 1 week.
All right.
Lordships kindly.
Only 1 week at the request of learned AG.
Serial number 18.
Your Lordship, with your kind request, kindly 2 matters listed on before the LGC court, Your Lordship. Framing of charges, Your Lordship.
ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಮಾಡಿ ನಿಂತ್ಕೊತೀರಿ ಓದ್ ಹೇಳ್ತಾರೆ ಹಿಂಗಿದೆ ಅಂತ.
1-4, Your Lordship.
ನೆಕ್ಸ್ಟ್ ಹಾಕಿ.
Lordship,
Lord, one
kindly
matter, Lord, my colleague is there with the memo.
We might not have much practice on criminal side, but we have read the criminal laws. Yes.
Lordship, my colleague is there with the memo, my Lord. From 2024, from 1 year I'm without job, my Lord. KSAT matter.
ಯಾವ್ದು?
My colleague is there with the memo, my Lord. 2000 KSAT matter.
ಯಾವ year?
24, my Lord. But from 1 year I'm without a job. Short matter, my Lord. It will not take 5 minutes for me to. I leave it to the Lordship. Earliest
Okay, 2 weeks. Yeah.
CC has opted for Vivad se Vishwas and appeal before filing Form 3. Lordship may post this matter tomorrow so that we have already filed the
ಯಾವ year?
2018, my Lord.
2018.
Yes, sir.
Next
It
week
is posted under final hearing.
next week final hearing ಗೆ ಟ್ಯೂಸ್ಡೇ ಬರುತ್ತಾ ಏನು? ನೆಕ್ಸ್ಟ್
It may be posted on Tuesday so that.
ಆಯ್ತು, ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡಬಾರ್ದು.
Yes.
ಅದರ ಮೇಲೆಲ್ಲ
Yes, ma'am.
Yes,
May I
Ramesh.
mention a matter, my lords?
Ah.
A case of extreme urgency, that's why I'm moving it, my lords. Staff
ಮೈಕ್ ಇಟ್ಕೊಳ್ಳಿ ಸರಿಯಾಗಿ ಎಲ್ಲರಿಗೆ
staff
ಕೇಳಬೇಕು.
nurse- The staff nurse who have been consistently working for 19 years were protected by the honorable tribunal and by this honorable court. The government, contempt was also filed against the government. In order to overcome both regularization and the continuation in service, all of a sudden in this month, 3rd of March, we have been intimated that all your posts are converted into some other post, you will be terminated, my lords. The situation has arisen because the state has filed one writ petition saying we cannot implement the High Court's order.
ನಾಳೆ
ನಾಳೆ ಇದೆ ತುಂಬಾ, ಯಾಕಂದ್ರೆ tomorrow, day after tomorrow, they will be terminated after 19 years of service without any notice, nothing. Only in an internal communication between the government, that is between the Secretary of Health and Family Welfare and
120 ಕರೀರಿ.
100. Grateful. So grateful.
My lords.
1 o'clock ಅಷ್ಟೊತ್ತಿಗೆ ಬಂದಿರಿ.
My lords is up.
my lord.
Go ahead.
ಹೇಳಮ್ಮ.
My lords, this is the petition of 2022, my lords. We are the respondent number 3 and 4 in this, my lords, and we are the allottees.
ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್. ಅವ್ರು ಹೇಳಿ ಮತ್ತೆ ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಅಂತ ಕರೀರಿ. ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ತೊಳಿಕ್ ಬರಲ್ಲ. ಅದನ್ನ ಹೇಳಲಿ ಅವರು. ಕರೀರಿ.
My lords, we are the respondent number 3 and 4 in this, my lords. We are the allottees and also the degree holders, my lords. In the execution petition, the impleading applicant has filed an application for impleading themselves itself, that is a bank, my lords, and their application has been
ಏನ್ ಬೇಕು
rejected.
ನಿಮಗೆ ಪೋಸ್ಟಿಂಗ್ ಆಗ್ಬೇಕಾ?
Yes, my lord.
ತೊಗೊಳ್ರಿ next after next ಕರೀರಿ. ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಅಂತದು. ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ತೊಗೊಳ್ಳಿಕ್ ಪರ್ಮಿಷನ್ ಆಫ್ ದ ಚೀಫ್ ಜಸ್ಟಿಸ್ ಬೇಕಾಗ್ತದೆ.
My lord, why it is pending? It's pending before my lords. The reason is this. They are using the pending matter to say that we will not continue.
Yeah.
That's why I moved an IA, my lords. I'm not on the merit.
ನಾಳೆ ಹಾಕೊಳ್ಳಿ.
ನಾಳೆ 1 ಗಂಟೆ ಆದ್ರೂ ಆಗುತ್ತೆ.
ಅಲ್ಲ ನಾಳೆ ಮಾರ್ನಿಂಗ್ ಲಿಸ್ಟ್ ನಲ್ಲಿ ಬರ್ತದೆ, ನಾಳೆ ಹಾಕೊಳ್ಳಿ.
ನಾಳೆ
ನಾನು ಇವತ್ತೇ ಅನ್ಕೊಂಡಿದ್ದೆ ನಿಮ್ಮ
ಇಲ್ಲ,
judge ಹೇಳ್ತಾರೆ.
29th they will be terminated.
ಹೌದು.
So tomorrow is.
But these are the fresh matters, my lord, pertaining to sub-registrar.
ಹಾ.
These are the matters, fresh matters, my lord, pertaining to sub-registrar. Against interim order, my lord, writ petition is filed. My lord, there is some urgency, my lord, against interim order, the present writ petition. ಅಲ್ಲಿ 2ನೇ ತಾರೀಕು ಹಾಕಿದ್ದಾರೆ. They will take, my lord.
2ನೇ ತಾರೀಕು ತೋತಾರೆ.
But they,
ಇಲ್ಲಿ ಸ್ಟೇ ಇದೆ ಹೇಳಕ್ ಬರಲ್ಲ ನಲ್ಲಿ. ಇಲ್ಲಿ ಸ್ಟೇ ಆಗಿದೆ ಸಮಯ ಇದು ಅಂತ ಅನ್ಕೊಂಡು.
but they will proceed, my lord.
ತೊಳಿ.
May I request, my lord, tomorrow, all fresh matters, my lord.
ನಾಳೆ ಆಗಲ್ಲ, ನಾಳೆ ಬೇರೆ ಬೇರೆ ಇರ್ತದೆ. ತೊಳಿ ಏನಾಗಲ್ಲ.
Monday, my lord.
ಮಂಡೇ.
Monday.
ಎಲ್ಲರೂ ಕುದುರೆ ಹತ್ಕೊಂಡ್ ಬರ್ತಾರೆ. ಎಸ್. ಯಾವ್ದು? 7 ಸೇಮ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಕನೆಕ್ಟೆಡ್ ಎಲ್ಲ ಹಾಕ್ಬಿಟ್ಟು ಮಂಡೇ ಹಾಕಿ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೊಳ್ಳೋಣ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರ್ಲಿ, ಏನಾಗಲ್ಲ. ಓಕೆ, ಅಲ್ಲಿ ಒಂದು ಡೇಟ್.
Last week I had moved, my lord.
ನೆಕ್ಸ್ಟ್
Wanted to withdraw this orders, appeals.
ಅಪೀಲ್ಸ್ ಯಾವ್ದು?
Want 556 of 2022 and 587 of 2022.
ಸೀರಿಯಲ್ ನಂಬರ್ ಇವತ್ತಿಲ್ವಾ?
No, sir.
ತೊಳಿ ನಾಳೆ ಹಾಕ್ಬಿಡಿ. ಎಸ್ ಮಂಜುಳಾ ಮೇಡಮ್, ಏನಿದು?
Rules copy what I have
Yes.
produced in
Yes.
annexure that I have
ಏನಾಗಿದೆ?
taken one more copy.
ಏನಾಗಿದೆ?
Lord,
What
this
has
is the matter, my lord, pertains to selection of excise guard. Lord, on 29th February 2024, my lord, the KT rejected the application of the applicant.
On what ground?
But on saying that, my lord, that is district wise is correct, that is state wise is correct. They are saying that, my lord. My lord, here, my lord, the question is that, my lord, they have selection process and in the only for the additional list, my lord, they have prepared state wise. That is also question, my lord, that they have not considered.
Requires consideration.
Yes, I'll get the instructions. KPSC is the
Learned.
main answering.
Learned panel council is requested to accept notice for KPSC, first respondent. Learned AGA for the second, emergent notice to 3 and 4, third and fourth respondents.
Great.
Next. Yes.
Objection is transcribed copy is not.
Solid. Translation not necessary. Third, dispensed it. ಏನಿದು ಮ್ಯಾಟರ್?
Village accountant has been trapped, your lordship, in the district trial court criminal case. He is honorably acquitted, your lordship.
ತೋರಿಸಿ, ಜಡ್ಮೆಂಟ್ ತೋರಿಸಿ. ಟಿ ವಿ ರುದ್ರಪ್ಪ.
Yes, sir. Page 85 to 122 is the. In the year 2010. And your lordship will kindly see was acquitted on 2012. 2012 they give a charge sheet. 2015 inquiry.
Emergent notice. Learned AGA is requested to accept notice for
Much of
respond. First respond ಗೆ ಲೋಕಾಯುಕ್ತ ಯಾರು? 3, Joseph Anthony. Panel council is requested to accept notice for.
much of.
Next.
Please. Lord,
Yes,
certain
Prashant.
please, my lord, may kindly turn to page 130.
ಮೈಕ್ ಅನ್ನು ಹತ್ರ ಇಟ್ಕೊಳ್ಳಿ.
Please.
ನಿಮ್ ಧ್ವನಿ ಎಲ್ಲ ಕೇಳಕ್ಕಿಲ್ಲ. ಸ್ಟೂಡೆಂಟ್ಸ್ ಬಂದಿರ್ತಾರೆ, ಇಂಟರ್ನ್ಸ್ ಇರ್ತಾರೆ.
Please. Lord, for certain omission and commission on the part of my lord, the petitioners, there was a charge memorandum, my lord, was issued.
ಏನು omission, ಏನು commission?
That when they were in the police,
Commission.
please, when they were in the police station, one of the thief, my lord, was in their custody. He went to, my lord, pass, my lord, urine, and during that time, my lord, he committed suicide. That was the charge against them. there was a departmental inquiry initiated, and the same was challenged, my lord, before the Karnataka Administrative Tribunal, my lord. Page 130, my lord, is the order.
Disciplinary inquiry ಏನಾಯ್ತು?
We were held to be guilty, and the same was challenged, my lord, before the Karnataka Administrative Tribunal. Page number 130, my lord, is the order.
130.
130.
ಎಷ್ಟು ಜನ ವಿಟ್ನೆಸಸ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡ್ಯಾರ?
My lord, 4 witnesses, my lord, were examined.
ಎಲ್ಲರೂ ನಿಮ್ಮ ಅಗೇನೆಸ್ಟೇ ಹೇಳಿದ್ದಾರೆ.
Against ಹೇಳಿದ್ರು.
4 ವಿಟ್ನೆಸಸ್ ಯಾವ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ನವರು?
All, my lord, from the police department.
ನಿಮ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ನವರೇ.
Please, page 130, my lord, page 130.
130. Accordingly, the applicant are
Please.
and bearing the points.
This was the order. This was set aside, and there was no liberty reserved, my lord, for the respondents, my lord, to initiate, my lord, fresh action.
Who?
The Karnataka, my lord, Administrative Tribunal,
Ah.
my lord, rejected, my lord, the whole proceedings and quashed it.
Correct.
There was no liberty, my lord, reserved to the respondents. Despite the same, my lord, on same set of cause of action, a fresh, my lord, departmental inquiry, my lord, is being initiated. It was hit by, my lord, doctrine of, my lord, finality and res judicata both.
You were parties earlier.
I was party. I was the one, my lord, who preferred, my lord, this application. They were parties. They were heard.
The tribunal has set aside only on the ground that competent authority has not issued charge memo. Hence it was set aside.
Liberty reserve ಮಾಡಿಲ್ಲಲ್ಲ.
Now the disciplinary authority has issued.
Yes, covered by Dharwad bench. Where
Yes.
the tribunal sets aside on the ground that incompetent authority has framed the charge. Or there is violation of principles of natural justice. But in Dharwad we have held, we are told that it is affirmed by the Supreme Court also. Dharwad we have held, in all such matters, it should be deemed that matter is remitted back.
It has attained finality. No challenge was made to it.
No, not necessary. We have already held.
And we were not even the in charges, my lord. We were only working there. I was the head constable, my lord. The second petition, my lord, was only a constable. And we were not given, my lord, custody of him also, my lord. He was in, my lord, the police station.
ಇರ್ಲಿ 4 ಜನ ಈಗ ಇದು ಮಾಡಿದಾರಲ್ಲ ಈಗ
This order, my lord, has attained finality. And there is no challenge to it.
ಇದು ಫೈನಾಲಿಟಿ in the absence of that order, which is that judgment which ವಿಜಯ್ ಕುಮಾರ್ ಯಾರು ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ದರು ಧಾರವಾಡದ myself and justice ಪಾಟೀಲ್ ವಿಜಯ್ ಕುಮಾರ್ ಪಾಟೀಲ್ ಯಾಕೆ ನೋಟ್ಸ್ ಮಾಡ್ಕೊಳಲ್ಲ ನೀವು ನಾವ್ ಹೇಳೋವನ್ನೆಲ್ಲ ನಾವೇನ್ ವೆಸ್ಟ್ ಹೇಳ್ತೇವ ಪರ್ಫೆಕ್ಟ್ ಆಗಿ ಹೇಳಿರ್ತೇವಪ್ಪ ಇಷ್ಟು ಇದ್ಕೊಂಡು ನೀವು ಯಾಕೆ ನೋಟ್ಸ್ ಮಾಡ್ಕೊಳಲ್ಲ ನೋಟ್ಸ್ ಮಾಡ್ಕೊಂಡು ಈ ಜಜ್ಮೆಂಟ್ ಕಣ್ ಚಕ್ ಒಂದು ಸೆಕೆಂಡ್ ಅಲ್ಲಿ ಬರ್ಬೇಕು ರೂಲಿಂಗ್.
Masil Mani and Rajit Singh both have held similarly. Supreme Court has held that if there is any violation in the procedure, then it should be remitted back to the disciplinary authority to be proceeded from the stage with, from which it stood.
ಅದು ರಿಮೆಟ್ ಆಗಿಲ್ಲ ಅಂತ ಅವ್ರ ಕಂಟೆನ್ಷನ್. ಅದಕ್ಕೆ ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತ ನಾವ್ ಹೇಳಿದ್ದೇವೆ. ವೇರ್ ಟ್ರೈಬ್ಯುನಲ್ ಡಸ್ ನಾಟ್ ಸೇ ದಟ್ ಮ್ಯಾಟರ್ ಇಸ್ ರೆಮಿಟೆಡ್ ಅಂತ ಹೇಳಲ್ಲ, ಅವಾಗ ಏನ್ ಮಾಡ್ಬೇಕು ಅನ್ಕೊಂಡು ವಿ ಹ್ಯಾವ್ ಸೆಡ್.
And also it is void ab initio because it was without.
Void ab initio ಅಂದ್ರೆ ನೀವು you can't ignore that. There is
Indeed,
rightly or
it has to
wrongly,
be
there is an
declared
order.
so by the court.
That
Thereafter
should be magistra dicta saying it is void ab initio. One cannot assume that it is void ab initio, therefore I will not challenge. ಹಂಗೆ ಹೇಳಿಕ್ ಬರಲ್ಲ. See that AR
declared so by the court.
1992 Supreme Court. Write down at least when we say AR 1992 Supreme Court page 111 paragraphs 5, 6, 7. After referring to Wade and Forsyth, the apex court has said, what is meant by void ab initio? Can party say it is void ab initio, therefore I will not go to court? Court said, still you have to go to court only. Just ಹಂಗೆ ನೋಡ್ಕೊಳ್ಳಿ. ಹಿಂಗೆ ನೋಡ್ಕೊಂಡು ನೋಟಿಸ್ ನೋಡ್ಕೊಂಡು ಹೇಳಿ ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತ. ಅದು ಆ ಜಡ್ಮೆಂಟ್ ಇದೆ ಮುಗಿದು ಬಿಡ್ತಿತ್ತು. ಮತ್ತೆ ಇದು 5 ವರ್ಷ ಇರ್ತದೆ ಇನ್ಮೇಲೆ ಇದು. Anyway. Learned AGA is requested to accept notice for respond first, second, third. All respondents. ಇದರಲ್ಲಿ KPSC ರೋಲ್ ಏನಿಲ್ಲ
ಇಲ್ಲ.
ಅವ್ರನ್ನ ಡಿಸ್ಮಿಸ್ ಮಾಡುವಾಗ ನಿಮ್ಮ ಪರ್ಮಿಷನ್ ಆಫ್ ದಿ KPSC ಅವ್ರಿಗೊಂದು ಏನೋ ಅಪ್ರೂವಲ್ ಏನೋ ತಗೋಬೇಕು ಅಂತಿದೆಯಲ್ಲ. ಮಾಡಿಲ್ಲ. ಏನ್ ಮಾಡಿ
ಒಂದು ಇನ್ಕ್ರಿಮೆಂಟ್ ಮಾತ್ರ ಕಟ್ ಮಾಡಿ.
ಒಂದು ಇನ್ಕ್ರಿಮೆಂಟ್ ಒಂದೇ ಜೀವ ಹೋಗಿದೆ ಅಂತ.
Earlier proceedings. ಈಗ fresh charge memo ಕೊಟ್ಟಿದ್ದೆ. That was set aside by the court. Fresh charge memo was issued. Articles of charges was issued. That was subject matter before this court.
All next week.
Lord, I had the benefit of interim order before the,
What interim order?
Lord,
We're not interfering, we are dismissing. Since they have not brought the
till-
ruling, we are just.
till such time, I had the benefit, my lord, before the tribunal, my lord.
Then no case made out. On appeal, we immediately ಮಾಡ್ತೇವೆ, ನಾವು ನೋಡ್ಕೊಂಡು, ನಮ್ಮ notes ನೋಡ್ಕೊಂಡು
Please,
ಬರೀತೇವೆ ಅಷ್ಟೇ.
next week. Some date, my lord,
Next week.
please.
Lords, I appear on NOC along with my lord.
Yes.
This is relating to motor vehicle inspector selection, my lord. Very short issue here is, this petitioner had the requisite qualification. He appeared, his name was shown in the merit list as well. There was one technical issue which was raised, saying that they had to give an experience certificate of having worked in a heavy goods vehicle with both petrol and diesel engines. They have worked on they should give a certification from the workshop. That is the experience certificate. He has the experience of having worked in heavy goods vehicles for diesel engine. For petrol engines, he doesn't have, because in India, nobody has. In fact, the government itself has clarified, saying that for
No petrol lorries at all.
petrol lorry silva illa. Kindly come to the government's own order at page 198. It says that, may I read that? I'll come straight.
Page number?
Page 198, ink page. Only that one para 3, my lords.
ಮೊದ್ಲೆಲ್ಲ just I was reading Ford's biography. ಮೊದ್ಲು ಆ ಎಂಜಿನ್ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಪೆಟ್ರೋಲ್ ಎಂಜಿನ್ ಇರ್ತಿತ್ತು, ಅದು ಡೀಸೆಲ್ ಎಂಜಿನ್ ಮಾಡ್ತಿತ್ತು ಅದರಲ್ಲಿ.
Piston.
ಅಂದ್ರೆ ಹಾ ಆ ರೀತಿ.
So here in India, we don't have heavy passenger vehicle or heavy good vehicle
With
in petrol engine.
ಎಲ್ಲಿ?
So nobody can have that. Kindly come to page 198. May I read that one?
ಹಾಗಾದ್ರೆ ಯಾರನ್ನು ಅಪಾಯಿಂಟ್ ಮಾಡ್ಲಿಲ್ವಾ ಅವರು?
ಇಲ್ಲ ಮಾಡಿದ್ದಾರೆ. ಅವ್ರು ಏನ್ ಮಾಡಿದ್ದಾರೆ? ಇನ್ಫ್ಯಾಕ್ಟ್ ಏನೋ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಇಲ್ಲದೆ ಇರೋರ್ನು ಎರಡರಲ್ಲೂ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಈಗ ಅವರೆಲ್ಲ ಬಂದು ನನ್ನ ಪೋಸ್ಟ್ ನ ಈಗ ಫಿಲ್ ಮಾಡ್ತಾರೆ, ನನ್ನ ಮೆರಿಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇದ್ರು ಕೂಡ. Therefore the interim prayer that let them not fill the posts till this is all considered, my lord. Kindly come to 198. May I just read that, my lord? Para 3, right at the top of the page. ಸರ್ಕಾರದ ಅಧಿಸೂಚನೆ ಸಂಖ್ಯೆ so and so 2210 ಮೋಟಾರು ವಾಹನ ನಿರೀಕ್ಷಕರ ನೇರ ನೇಮಕಾತಿ ಹುದ್ದೆಗೆ ಕ್ರಮ ಸಂಖ್ಯೆ ರಲ್ಲಿ so and so working experience of at least 1 year in a reputed automobile workshop which undertakes repairs of both light motor vehicles, heavy goods vehicles and heavy passenger vehicles fitted with petrol and diesel engine ಕನಿಷ್ಠ ವಿದ್ಯಾರ್ಹತೆ ಹೊಂದಿರಬೇಕೆಂದು ತಿಳಿಸಲಾಗಿರುತ್ತದೆ.
ಅಲ್ಲ, ಅದು ಅದರ ಅರ್ಥ ಏನು ಅಂದ್ರೆ ಫಿಟೆಡ್ ವಿತ್ ಪೆಟ್ರೋಲ್ ಇದೆಯಲ್ಲ, ಅದು ಲೈಟ್ ಮೋಟರ್ ವೆಹಿಕಲ್ಸ್ ಅಪ್ಲೈ ಆಗ್ತದೆ.
ಇಲ್ಲ ಲೈಟ್ ಮೋಟರ್ಗಲ್ಲ ಸರ್. It is for heavy passenger vehicles fitted with petrol and diesel engines. ಇದರ ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಅಲ್ಲಿ ಕ್ಲಾರಿಫೈ ಆಗುತ್ತೆ. ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾ ದಯವಿಟ್ಟು ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾ. ಆದರೆ ಹೆವಿ ಗೂಡ್ಸ್ ವೆಹಿಕಲ್ಸ್ ಹಾಗೂ ಅಂಡ್ ಹೆವಿ ಪ್ಯಾಸೆಂಜರ್ ವೆಹಿಕಲ್ಸ್ ಫಿಟ್ಟೆಡ್ ವಿತ್ ಪೆಟ್ರೋಲ್ ಎಂಜಿನ್ ವಾಹನಗಳು ಅಸ್ತಿತ್ವದಲ್ಲೇ ಇರುವುದಿಲ್ಲ.
ಅಲ್ಲ, ಇದು ತಪ್ಪು ಓದಿದ್ದಕ್ಕಾಗಿದೇನು ಅಂತ. ಅದು
ಇಲ್ಲ. They are insisting on that. They have insisted selectively.
ಹಿಂಗ್ ಹೇಳ್ಬೋದಿತ್ತು ಅವರು. ಅದು ಭಾಷೆಯನ್ನು ಸರಿಯಾಗಿ ಪ್ರಯೋಗ ಮಾಡ್ಲಿಕ್ಕೆ ಇಷ್ಟು ಸಮಸ್ಯೆ ಆಗಿದೆ. ಅಲ್ಲಿ ನೋಡಿ, ಅಲ್ಲಿ ಎಡ್ಜೆಕ್ಟಿವ್ ಇದೆಯಲ್ಲ,
ಪ್ಲೀಸ್
ಫಿಟೆಡ್ ವಿತ್ ಪೆಟ್ರೋಲ್ ಅಂಡ್ ಡೀಸೆಲ್ ಎಂಜಿನ್ಸ್ ಅದೆಯಲ್ಲ, ಅದನ್ನ ಲೈಟ್ ಮೋಟರ್ ವೆಹಿಕಲ್ಸ್ ಮಾಡಿ ಬ್ರಾಕೆಟ್ ನಲ್ಲಿ ಹಾಕಿಬಿಟ್ರೆ ಈ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ.
It may not be a language, it may not be an innocuous problem of the language. It is something that in the process of drafting they have overlooked it. Why? Because I would infer it because in the next paragraph they are specifically clarified that since there is no existence of heavy good vehicles in petrol, there is no necessity for satisfying that criterion.
ಅಂತಾನು ಹೇಳ್ಬಿಟ್ಟಾರೆ
ಅಂತ ಹೇಳ್ತಾರೆ. However, the honorable tribunal at page 32 says, even if the combined experience, kindly come to page 32, my lords.
ಅವು ಎರಡನ್ನು ಇಟ್ಕೊಂಡ್ರು ಲೆಸ್ ದನ್ ದಟ್.
It is no experience in HP fitted with petrol. Therefore, I am not fit, even though I have satisfied merit.
ಇಷ್ಟೇ ಕೇಸ್.
I'll get instructions on it. Matter has come for the first time.
Let them not fill the post. I am our status ಅಷ್ಟೇ.
ಫಿಲ್ ಮಾಡಬೇಡಿ.
ನಾವೇನು ಅಪಾಯಿಂಟ್ ಮಾಡಿ ಅಂತ.
The last appointee may be made subject to the outcome of this.
No.
In the same category.
ಏನಿಲ್ಲ. ಅಲ್ಲಿ in Maxwell's interpretation of statutes, where law or norm requires accomplishment of an impossibility, Maxwell says that should be deemed to have been accomplished. And Crawford says that shall be deemed to have been dispensed with. there is difference between these two. There is, in fact, they've used two different maxims for this, which they have borrowed from Broom's legal maxims. Both they have. One says deemed to have been complied with. Another says deemed to have been dispensed with. Either way, it will inure to your benefit. The tribunal should have seen that one. Record. Issue emergent notice. Learned DGA is requested to accept notice for respondents 1 and 2. First stop. APSA. Sri Madam M.R. Sinchana, panel counsel is requested to accept notice for respondent KPSC. First stop. Learned counsel Mr. Nitin Ramesh, appearing for the petitioner, draws attention of the court to the
annexure A31.
Sir, A31 dated 8/5/2023, which indicates that there are no heavy
Passenger
vehicles
and heavy good vehicle.
and heavy goods transport vehicles fitted with petrol engines.
And therefore,
The question of obtaining certificate of experience working in such vehicles would not arise. First up, there is force in this submission. Next paragraph. In the above circumstance, a case is made out for issuance of interim order. Apt in the circumstances. First up.
not to fill up the posts.
Yes. The
At prayer.
first and second respondents are restrained from issuing, not to fill up
Not
the
to fill
posts in question by issuing appointment order or otherwise.
Lord, keep one post vacant, my lord, instead of preventing all the appointments from being made. We'll keep one post vacant for him.
Alert, correct. No, not interim or limeribico, respond numbers 1 and 2 are directed to keep one post vacant.
In fact, we had filed 2 mallards. One of them got listed today. The other one is not listed. It may come tomorrow or on.
ಎಲ್ಲಿದೆ ಅದು ತರ್ಸಿ ಈಗ
It is
ತರ್ಸ್ರಿ ಅದು
Juliet.
ತರ್ಸಿ
Connected. Idena.
ಇದೆ.
In fact, your lordship has also directed 5483 of 2025.
ಒಂದು ಲಿಸ್ಟ್ ಮಾಡಿ
Juliet.
ಕಾಲ್ ಅಲಾಂಗ್ ವಿತ್ ಮಾಡಿ
A call along with 5483 of 2025.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಆಗಿದೆಯೇನು ಆಲ್ರೆಡಿ ಅಲ್ಲಿ ನೋಡಮ್ಮ 2 posts vacant.
2 posts.
That
So-
will do things.
So grateful. My lords, the office objection will be overruled.
Office objection.
Translation. So great.
ನಂಗೆ ನಿಮ್ಮ ಕಲೀಗ್ ಯಾರಿಗಾರ ಹೇಳಿ ಅದನ್ನ ಇದನ್ನ ಮ್ಯಾಕ್ಸ್ವೆಲ್ ಇದ್ದೊಂದು ಜೆರಾಕ್ಸ್ ಕಳಿಸ್ಬೇಕು ಲಾಸ್ಟ್ ಒನ್. ಎಸ್
My name may be shown, my lords. I am filing NOC along with.
ಯು ಆರ್ ಫೈಲಿಂಗ್ NOC.
Wait, not put up.
Registry to show name of Nitin Ramesh. Yes.
So great.
I am for the petitioner, my lordship.
Yes, Mr. Raja.
My lordship, it is a case of rejection of the compassion appointment to any group D post on the death of the mother of the petitioner. The mother died while in service due to COVID attack during 2021. Petitioner compassion appointment request for the compassion is rejected only sole ground of overage. At the time of death of her mother, she is a 41 years. She asked for the only for the group D post. For the group D post, 5 years exemption is there.
ಇದೆಯಾ?
Yes, my lordship, kindly see 130. Number 136, my lord.
ಇದೆಯಾ?
Lord, the age relaxation is only given for the persons belonging to reserved categories.
Yes, he is a
Age criteria prescribed under the general recruitment.
She scheduled trial.
scheduled trial. Lordship, kindly see page number 136 and 152.
130?
136.
6.
Page number 136, Annexure J. May I
Ah.
read it out, my lordship?
ಹಾ,
Relaxation up to 4 years in the lower age limit to.
ಯಾವ್ದಿದು? ಯಾವನಿಗೆ?
My lordship, 1987 order. That is not amended so far. That has not been taken into consideration by
Annexure?
the respondents.
Annexure ಯಾವ್ದು?
Annexure J, my lordship, page number 136.
Correct.
Relaxation up to 4 years in the lower age limit and up to 5 years in the upper age limit can be made in case of group D post for the compassion of any group D post. I am not asking for any group D post, my lordship. For that age relaxation is for the SC/STs.
I'll get instruction. Seems to be
Learned AG is
reasonable.
requested to accept notice for respondents. Call this matter up. It's a chick matter. Yesterday,
Yes, my lordship.
after 3 weeks. Okay.
Notice ಆಗಿದೆ, sir.
Since not short point is involved.
Please.
Okay.
Petitioner.
Ah.
Sir, the office objection is with regard to translation, my lords.
Ah.
My lord, case of
This
trap,
next.
case of trap, penalty of compulsory retirement has been imposed on the petitioner.
ಎಷ್ಟು ವರ್ಷ ಸರ್ವಿಸ್ ಆಗಿದೆ?
Now he has 17 years of service left.
ಎಷ್ಟು ವರ್ಷ ಸರ್ವಿಸ್ ಆಗಿದೆ?
He was appointed in the year 1992, my lords.
ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಏನಾಯ್ತು?
It is a case of honorable acquittal, my lords.
ಎಲ್ಲಿ ತೋರಿಸಿ?
Page number 124 is the operative portion, my lord.
124 ಆ?
Please, my lords.
ಎಲ್ಲಿದೆ?
It's paragraph number 32, my lords.
ಅಲ್ಲಿದೆ ಆನರಬಲ್ ಎಕ್ವಿಟಲ್ ಅಂತ ಅನ್ಕೊಂಡು. ಅಬ್ಸಲ್ಯೂಟ್ಲಿ ಆನರಬಲ್ ಎಕ್ವಿಟಲ್ ಪಿ ವಿ ರುದ್ರಪ್ಪದಲ್ಲಿ ಎಷ್ಟು ಎನ್ಲಿಸ್ಟ್ ಮಾಡಿದ್ದೇವೆ ನಾವು?
Please, my lord.
Read. Which is that paragraph?
And page number 13, my lords.
Huh. What will
A
come?
case of honorable acquittal may arise when, after the trial of the criminal court orders acquittal with any of the nearly following illustratives.
Correct.
The accused is falsely prosecuted to seek vengeance or for some
That
ulterior
is not
motive.
your case.
Please, my lords.
2.
That there is absolutely no evidence to implicate the accused in the proceedings.
That is also not your case.
There is very little evidence which is insufficient to connect the accused with the commission of the crime.
Where is the observation? All right, read other 2 or 3.
That the prosecution has miserably failed to prove the charges against the accused.
ಹಂಗೇನ್ರ ಹೇಳಿದಾರ?
Lord, the exact wordings are not used, my lords, but
ಅದಕ್ಕೆ ಇಲ್ಲಸ್ಟ್ರೇಟಿವ್ ಅಂತಂದು ಆ ಅರ್ಥ ಬರೋ ರೀತಿಯಲ್ಲಿ ತೋರಿಸಿ. ಬೆನಿಫಿಟ್ ಆಫ್ ಡೌಟ್ ಇದ್ರೆ ಬರಲ್ಲ.
but however, my lords, when the, as your lordships have held in PV Rudrappa, that the entire judgment has to be read, wherein the work itself was completed by the petitioner when the complainant approached the petitioner, and all these aspects were considered, and hence it was held that the prosecution has not led sufficient evidence to
ಅವಾಗ
prove the case.
ಅವಾಗ ಬರಲ್ಲ.
My lord, the entire judgment, if we read,
ಎಂಟೈರ್ ಜಡ್ಜ್ಮೆಂಟ್ ಓದ್ಕೊಂಡು ನಾವು ಹೇಳೋದು, ನಾವು ಮನೆಯಲ್ಲಿ ಬೇರೆ ಕೆಲಸ ಇಲ್ಲ ಏನಿಲ್ಲ, ಬೇರೆ ಓದೋದಷ್ಟೇ. ಆ ಕಾರಣಕ್ಕೆ ಇಮಿಡಿಯೇಟ್ಲಿ ನಿಮ್ಗೆ ನಿಮ್ಗೆ ಯಾಕೆ ಹೆಚ್ಚು ಆರ್ಗ್ಯೂ ಮಾಡಕ್ ಬಿಡಲ್ಲ ನಾವು ಅಂದ್ರೆ ವರ್ಕ್ ಮಾಡ್ಕೊಂಡ್ ಬಂದಿರ್ತೇವೆ ನಾವು. ನೀವು ಎಡಮೆಂಡಿ ವೇಟ್ ದ ಆಪಲ್ ಅನ್ಕೊಂಡು ನಾವು ಹಂಗ್ ಹೋಗಕ್ ಬರಲ್ಲ. ಇನ್ನು 50 ಲಕ್ಷ ಉಳಿತು ಕೇಸ್ ಅಷ್ಟು.
my lords, with respect to the finding of facts, my lords, the Sessions Court has clearly held that the work itself was already completed on 12/8/2018. And
might have been completed.
on the very same day, the petitioner met with the complainant and there was no demand made on that day.
Pink test is proved positive.
Yes, my lords, but however, the recovery was from under the table.
That's all right. Where you keep the money is money will be kept. As you know, we need not say much now. Money may be kept in outhouse or it may be kept in house, the dog's house, dog rest. Anyway, these are the tactics of storing money.
But
You
however,
are seeing everything nowadays, na?
my lords, however, it was on the very same day when the shadow witness was standing near the door.
Why your hand got soiled? Why you took that money?
Lord, that was thrust.
ಆಮೇಲೆ ಎಲ್ಲಿಟ್ಟು ಅನ್ನೋದು ಇಟ್ಟು irrelevant. ಆಮೇಲೆ money is currency. It is always in movement. It moves from one place to another place, from one hand to another hand, one person to another person, from one pocket to another pocket of other persons. Or it may go to outhouse also, anything may happen. We can't say.
But it was thrust upon me. That is my case, my lords. That is the money.
Dismissed. Agreeing with the reasoning of the tribe, P.V. Rudrappa is not applicable because of the observation at para 30 of the impugned order. ಅಲ್ಲಿ ಅವರ AG ಹೆಸರು ತೋರಿಸ್ಕೋಬೇಕು. Next.
My lord, I got the judgment of your lordship also. It is reported. And also the book of
Samaraditya Pal.
Samaraditya Pal regarding deputation, my lord.
Yes. What was the question? Question was, Samaraditya Pal refers to D.A. Desai judgment.
Correct.
In the chapter.
Short.
Ordinarily, deputation is a tripartite arrangement.
Correct.
Do you have that book with you?
Yes, my lord.
Read that first paragraph where he has called out Gujarat judgment.
Your lordship judgment
No,
after.
no, not that. Just read Samaraditya Pal. Always one should read standard books
Deputation.
like Rama Jaish, Samaraditya Pal, Kulasreshtha. Allen chapter is there.
Correct. Deputation and
Chapter ಇದೆ. He has reproduced on the right hand side Gujarat judgment. But the old, the first edition I was reading. This is now second edition has come. Third edition has come. Page number ಏನದು?
My lord, page number 621.
Deputation, chapter 21. Yes. Meaning of deputation.
621.
Gujarat High Court judgment, 141.2 paragraph, read that. So beautifully it said.
Definitely.
Justice D.A.
Deputation
Desai's
has a
judgment.
different connotation in service law, and the dictionary meaning of the word deputation is no help. In simple words, deputation means service outside the cadre or outside the parent department. Deputation is deputing or transferring an employee to their post outside his cadre. That is to say,
ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಿ?
ನಾನು 622 ಓದ್ತಾ ಇದ್ದೇನೆ.
622 ಅಲ್ಲ. 141.2 where Gujarat High Court judgment is reproduced.
20
Distinction between deputation and transfer. Justice D.A. Desai's judgment. 141.2.
ನಂದು ಇದು 4th edition ಆಗಿದೆ.
Okay,
ಈಗ ಲೇಟೆಸ್ಟ್ ಎಡಿಷನ್ ಇದೆ.
ಅಲ್ಲಿ distinction between deputation and transfer ಅಂತ D.A. Desai judgment ಇದೆ. Honorable Justice
Supreme
D.A.
Court,
Desai.
that is
No, Gujarat judgment.
3.
We are asking you because many youngsters sit in our court. And they should see, they should learn, and they should see your performance also. ಕೊಡಿ ಈ ಪುಸ್ತಕ ಕೊಡಿ.
I will read it.
ನಿಮ್ಮ ಪುಸ್ತಕ ಕೊಡಿ, ಒಂದ್ ನಿಮಿಷದಲ್ಲಿ ಹುಡುಕಿ ಕೊಡ್ತೇನೆ.
Yes, ma'am.
ಕೊಡಿ. Justice D.A. Desai ಅಂತ ಬಿಗಿನ್ ಆಗತ್ ನೋಡಿ.
Distinction between deputation and transfer.
That's what.
Deputation and transfer basically differ from each other in that
ನೋಡಿ ನಿಮ್ ತೊಳಿ page 623.
623.
ಕೊಡಿ ನಮ್ಮ ಪುಸ್ತಕ ನಮಗೆ ಕೊಡಿ. On the right hand side it is said.
Yes, ma'am. Deputation and transfer basically differ from each other in that transfer can be only to an equivalent post in the same cadre. Deputation must be department other than the parent department, where even equivalence may not have determined. Transfer is right of the master and it is an incident of service and can only be challenged on the grounds of mala fide or violation of statutory role. Relating to transfer, deputation can only be with the consent because the employee joined department to render service in that department and he cannot be made to serve somewhere else, maybe in the post much lower to his post. Your lordship, correct me. In this present case, They have not consulted the health department to which I am belonging to. On that basis, there are 2-3 judgments of this honorable court, my lord, kindly.
What they say?
They say, my lord, without consultation of the lending department,
But whether that question arises or not is the question, because on facts I found out, my lord, there has been a request, constant request including medical colleges as well as nursing colleges around between 2006 and 2008. Several colleges were made autonomous to meet the urgent requirement of teaching staff. The experienced staff from HFW were deputed for teaching, and for whatever reasons, my lord, they have
It
remained
just shows that her parent department requested. Give that copy.
My lord, 3 parties are involved, my lord, apart from the candidate herself.
Kodi, namಗೊಂದು copy.
Sir, there is one
Copy.
extra copy, sir, court officer.
What is it?
Lord, one is the health and family welfare department, which is the lending department.
Correct.
The borrowing department is not the medical education department, but the autonomous college.
Autonomous college, which was part of earlier medical department.
Indeed.
That's what Sridhar said.
Yes. Now, the order of repatriation has been issued by the dean cum director of the institution. That has not been challenged at all in this case. What has been challenged is an internal communication, which, my lord, it is well settled that internal communication is only a decision-making process and are not subject to challenge before the court. Now, my lord, may I just point out the first document, my lord. This is dated 12/8/2014. This is a communication by the Principal Secretary of the Health and Family Welfare Department to the Director and Dean, to the autonomous institution.
ಎಲ್ಲ ಶಿಷ್ಟರುಗಳನ್ನು ಕೂಡಲೇ ಜಾರಿಗೆ ಬರುವಂತೆ ಬಿಡುಗಡೆಗೊಳಿಸಬೇಕು. ಅದಾದ್ಮೇಲೆ ಮಾಡ್ಲಿಲ್ಲ.
ಅದಾದ್ಮೇಲೆ ಮಾಡಿದ್ದಾರೆ.
ಹಾ.
21/7/2014 ಮಾಡಿದ್ದಾರೆ. And Mamta is in this list also at serial number 14 in the next page, madam.
JC Mamata.
JC Mamta. She is the petitioner.
Yes. ಅದಾದ್ಮೇಲೆ
Well, this has never been challenged, but she doesn't go back.
No, but why this is not implemented, given effect at all?
Well, there is an order passed thereafter, my lord, again 13/8/2014
ಇಲ್ಲ ಅದೇನಾಗಿದೆ ಹೇಳ್ತೀನಿ.
by the Dean cum Director.
Let him complete.
Another order, my lord.
Yeah.
Annexure P.
ಹಾ.
ಈ ಸಂಸ್ಥೆಯ ಅಧೀನದಲ್ಲಿ ಬರುವ ಸರ್ಕಾರಿ ಶುಶ್ರೂಷ ಮಹಾವಿದ್ಯಾಲಯದಲ್ಲಿ
ಕೂಡಲೇ JC ಮಮತಾ
ಬರುವಂತೆ
ಕೂಡಲೇ ಜಾರಿಗೆ
ಇಲಾಖೆಯಲ್ಲಿ
ಬರುವಂತೆ
ವರದಿ
ಮಾತೃ
ಮಾಡಿಕೊಳ್ಳಲು
ಇಲಾಖೆಯಲ್ಲಿ ವರದಿ ಮಾಡಲು ಅಂತ ಬಿಡುಗಡೆ ಮಾಡಲಾಗಿದೆ.
This order was challenged, my lord,
ಹಾ.
in a writ petition. This being an autonomous institution, the order passed by it was challenged before the learned single judge of this honorable court, which came to be, the writ petition came to be rejected. And there is an appeal filed, writ appeal filed, inter-court appeal filed, but there is no stay order. Now, thereafter, this other order has come to be passed, 39/2020, next page, my lord.
39/20.
39/2024. This is also, your lordship will notice the signature passed by the Dean cum Director, my lord, of the autonomous college. And she is not the only person who is repatriated. She is
Others
one of
also.
them at serial number 2, my lord. Well, turning to the next page, your lordship will notice what is challenged. The impugned order challenge before the tribunal was the communication from the medical education department to the Dean cum Director. This is not amenable to challenge under writ jurisdiction, my lord, because this is just an internal communication pursuant to which the earlier order has been passed. My lord, what has happened is, I'm told that despite the parent department requesting for repatriation several times, they have continued without returning back. In fact, there was a stay order in the writ petition. That is how she continued from 2014 till this date. In the writ appeal, there is no stay.
No stay.
No stay. And several persons have gone back. The my lord, as per this order, the second order, my lord, several persons have gone back. Only she remains.
All others have gone back.
All others have gone back. That is I'm submitting on instructions. I very specifically put that question. You have to categorically tell me whether others have gone. They have stated that all others have gone.
Yes.
I'll make submission. With
Yes.
regard to the submission made by my learned friend, government advocate.
Yes.
My lord, in the last order, your lordship may kindly see, my lord, refer 39/24.
Ah.
Jayalakshmi, Mamta, Saraswati, Nagaratnama, Reddamma, Jyoti. These are the professors who are working in the department. My lord, only in respect of Mamta, they have passed an order of repatriation in the year 2014. That order I have challenged in writ petition number 49-151 of 14. And there was a stay, and stay order was continuing. Ultimately, the learned judge
Dismissed it.
dismissed on the ground that there was no rule for absorption. Against that, I preferred writ appeal 1875 of 25, which is pending. For admission, it is pending. The date is being given on 8/4/25. This is one aspect. What my learned friends said, all have been repeated. No, only remaining are 6. Out of 6, only they have chosen me in the year 2014, that was stayed. Till
Instruction,
There are
whatever.
14 of them. In the year 2014, there are 14 of them.
14 of them.
14 of them.
My
Because
lord,
it doesn't go, another order is passed.
I'm concerned with these 6 people, my lord.
Correct.
Out of 6, only I have been disturbed. No other remaining 5 have not been
Also
disturbed.
correct.
And the remaining 5 were continuing in the same college as a professor and head of the department. Not only that, my lord, the present order they have passed as per annexure A10.
Yes.
Kindly come to page number 212 in my paperwork, my lord.
212.
212. ಇದರಲ್ಲಿ 212 ನಲ್ಲಿ this is again from medical education department. ಮೇಲ್ಕಂಡ ಸಂಸ್ಥೆ 1ರ ಪತ್ರ ಕಡೆಗೆ ತಮ್ಮ ಗಮನ ಸೆಳೆಯುತ್ತ ಉಲ್ಲೇಖ 2 ಮನೆ ಡಾಕ್ಟರ್ ಸರಸ್ವತಿ ಇವರು ವಯೋನಿವೃತ್ತಿಯಾಗಿ 2 ವರ್ಷಗಳು ಬಾಕಿ ಇರುವಾಗ ಮಾನಸಿಕ ಆರೋಗ್ಯ ನರ್ಸಿಂಗ್ ಮತ್ತು ಮನೋರೋಗವನ್ನು ಕಲಿಸುತ್ತಿರುವ ಏಕೈಕ ಸಿಬ್ಬಂದಿಯಾಗಿದ್ದು ವಿದ್ಯಾರ್ಥಿಗಳಿದ್ದರಿಂದ ಸರ್ಕಾರಿ ಮಹಾವಿದ್ಯಾಲಯ ಮುಂದುವರಿಸಲು ಕೋರಿರುತ್ತಾರೆ. ಸರಸ್ವತಿ ಕ್ಲಿನಿಕಲ್ ಸೈಕಾಲಜಿಸ್ಟ್ ಇವರ ಮನವಿಯನ್ನು ಪರಿಗಣಿಸಿ ಸದೈವರಿಗೆ ಸೂಕ್ತ ಎಚ್ಚರಿಕೆ ನೀಡುವಂತ ತಿಳಿಸುತ್ತಾ ಸದರಿ ಇವರ ಸೇವೆಯನ್ನು ಸರ್ಕಾರಿ ಮಹಾವಿದ್ಯಾಲಯ ಮುಂದುವರಿಸಲು ಸಮ್ಮತಿಸಿದೆ. That means out of these 5 people, only in respect of Dr. Saraswati, they have asked to come back. On the ground that there is only one person working in that.
You simple questions we're asking now.
ಏನು?
You belong to X department.
Health department.
That is what. You are on Y department now, on deputation.
No, my lord, I am in the, that is a distinction I would like to make. I am in the health department only.
It's an autonomous institution. It is where you are working.
No, my lord, no.
It was part of department history.
ಅಲ್ಲೇ distinction ಇರೋದು.
ಅಲ್ಲೇ ಇರೋದು ಅದು distinction ಹೋಗ್ಬಿಡುತ್ತೆ ಅಂತ autonomous ಆದ್ಮೇಲೆ.
ಈಗ ನಾನು health and family welfare department is also having about more than 500 to 600 posts in the medical education department. They have not been transferred to the medical education department. And as and when sometimes they have been absorbed in the medical education department. Such procedure has not been followed in the case of nursing cadre, my lord. It does not belong to the institute, my lord. That is very much clear from annexure A11, page number. Kindly see, my lord.
Yes.
Page number A10, A11, page number 67, my lord. Kindly see, my lord. I will read this, sir.
Yes.
To factually submit that it does not belong to medical education department.
It's an autonomous body now.
No, my lord. I'm submitting with respect, my lord. Some post working in the medical education department.
If you are part of the same department,
Why
did you seek absorption?
Health department, in the medical wing, I am trying. In the medical wing, I am.
So it's a different department.
Medical wing.
Anyway, it's a different
ಇದೊಂದು ಆರ್ಡರ್ ಓದ್ಬಿಡ್ತೇನೆ ತಾವತ್ತು ಒಂದ್ ಸರಿ ಇವರ kindly see.
We are asking you simple question. If you belong to the same department, where is the question of seeking absorption?
My lord, what I am submitting is that, my lord, in the health department, medical wing is there. Medical wing ನಲ್ಲಿ ಕೆಲಸ ಮಾಡಂತ 500-600 ಜನ, the health department employees are also working. Therefore, it is not actually, entire thing has been transferred to the medical education. Still, it is health and family welfare department only. That is clear from page number
Then
67.
why did you seek absorption?
No, the medical education, because I have got a teaching experience of 12 years. Therefore, I should be absorbed ಅಂತ ಕೇಳ್ತೇನೆ.
Dismissed.
ಮಿಲಾಟ್ ಒಂದೆರಡು ಸಬ್ಮಿಷನ್ ಇದು ಮಾಡ್ತೇನೆ.
ನೀವು ಹೇಳಿದ್ದೆಲ್ಲ ಕನ್ಸಿಡರ್ ಮಾಡಿ.
ಅಲ್ಲ ಇನ್ನೊಂದೆರಡು ಪಾಯಿಂಟ್.
Dismissed on the.
ಅಲ್ಲ ಇನ್ನೊಂದೆರಡು ಪಾಯಿಂಟ್. ಅಲ್ಲ
employee has
ಒಂದು
no
judgment.
preventive and deputation.
ಮಿಲಾಟ್ one judgment, 1 second.
Number
One second.
There
One
are,
97 Supreme Court judgment.
there is a
my-
direction by the parent department.
My lord,
to seek
one submission,
repatriation.
I may
Number
permitted
two,
to make submission, madam.
three,
Kindly,
many-
kindly
many
permit,
have gone back
my lord,
pursuant to the repatriation.
my lord,
Four,
I have not completed.
you have been heard yesterday, day before. How many
ಇಲ್ಲ,
times you should
ಇಲ್ಲ,
be heard in the
ಇನ್ನೊಂದೇ-
matter?
ಇನ್ನೊಂದೆರಡು ಪಾಯಿಂಟ್ ಹೇಳ್ತೀನಿ ಆಮೇಲೆ ತಾವು ಮಾಡ್ಬೋದು.
Correct.
ಆಗ್ಬೋದು. In the 97 Supreme Court, my lord, this point is in my favor, my lord.
Yes.
2007, Part 1, ACC 331. Kindly see this.
ಕೊಡಿ. ನೀವು ಅಷ್ಟೆಲ್ಲ ಟೈಮ್ ತಗೋಬಾರ್ದು. ಪಾಪ ನಿಮ್ ಫ್ರೆಂಡ್ಸ್ ಎಲ್ಲ ವೇಟ್ ಮಾಡ್ಕೋತ ನಿನ್ನೇನೋ ಹಂಗೆ ಆಯ್ತು, ಅವತ್ತು ಹಂಗೆ ಆಯ್ತು. ಹಾಗೆ ಎಷ್ಟು ಸರಿ ನಾವು ಕೇಳ್ಕೊತ ಸಣ್ಣ ಸಣ್ಣ ಮ್ಯಾಟ್ರಸ್ ಇದೆಲ್ಲ. We have to ration our time for the litigants.
My lord, sometime we may have to do justice for our client. Yes, it's a heartburn case.
Correct. But ನೀವು
Heartburn case for about 12 years I worked.
ಶ್ರೀಧರ್,
ಹಾ.
ಅವ್ರಿಗೆ ಕ್ಲೈಂಟ್ಸ್ ಹೆಂಗಿರುತ್ತೆ, ನಾವು ಲಾ ಪ್ರಕಾರ ಡಿಸೈಡ್
No, no.
ಮಾಡೋಣ.
ಲಾ ಪ್ರಕಾರನೇ ನಾನು ಇದನ್ನ ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
ಹೇಳಿ.
My lord, the repatriation to lower post, rectification of mistake, natural justice principle, applicability, appellant transferred to another department and given promotion there, but later found that the promotion was mistakenly given to the appellant. Mistake sought to be rectified by repatriating appellant to his original department in the lower post in which he
ಲೋವರ್
had-
ಪೋಸ್ಟ್ ನಲ್ಲಿ ಮಾಡಿರ್ತಾರೆ.
ಈಗ ನನ್ನ ನರ್ಸ್ ಆಗಿ ರಿಪ್ಯಾಟ್ರಿಯೇಷನ್ ಮಾಡ್ಕೊಂತಾರೆ. ಬಟ್ ಇಲ್ಲಿ ನಾನು ಆಲ್ರೆಡಿ ಬಂದು ಇಷ್ಟು ವರ್ಷ ಸರ್ವಿಸ್ ಆಗಿ ನಾನು ಪ್ರೊಫೆಸರ್ ಅಂಡ್ ಹೆಡ್ ಆಫ್ ದಿ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಆಗಿದ್ದೇನೆ. ಐ ಆಮ್ ನಾಟ್ ಗೋಯಿಂಗ್ ಇನ್ ಟು ದಿ ಈಕ್ವಲೆಂಟ್ ಪೋಸ್ಟ್ ಇನ್ ದಿ ಹೆಲ್ತ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್. ಅದು ಇದು ಕೋರ್ಟ್ ಸೆಡ್ ದಟ್ ನೋ ಯು ಕಾಂಟ್ ಡೂ ಇಟ್ ಅಂತ. No departmental proceedings initiated, no offensive afforded to the appellant prior to passing of repatriation order. Held order bad for non-compliance with the principle of nationals. ಆ ಗ್ರೌಂಡ್ ಮೇಲೆ you cannot repatriate on a lower cadre.
You are repatriating to the lower cadre.
ಹಾ.
No.
No, she is.
Whichever cadre she was holding,
She
to
was
that she
holding.
will go back.
No, my lord, I was
Being
holding here professor and head of the department.
That is not on substantive holding. You don't have right of link to that post at all.
And I have been treated as a
You might have been treated. Where is your right of lien?
lean.
Suppose if you are posted to a higher post, unless you hold the right of lien.
ಲೀನ್ ಅಂದ್ರೆ ನನಗೆ ಹೆಲ್ತ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ನಲ್ಲಿ ಮೆಡಿಕಲ್ ವಿಂಗ್ ಅಲ್ಲಿ ಸರ್ವಿಸ್ ಮಾಡಿ ನಾನು ಸೀನಿಯಾರಿಟಿ ಬಂದಿದ್ರೆ
ಬರ್ಕೊಳ್ಳಿ.
Therefore, my lord, kindly,
Proceed into
ಕೆಲವು
service.
ಪಾಯಿಂಟ್ಗಳು ಆಗಿಲ್ಲ ಇದರಲ್ಲಿ.
ಹೇಳಿ.
My lord, in the present order.
No, you have to show
Hmm.
that you had right of lien to the higher post. Show that.
Right of lien andre, I am belonging to the health department. They have not obtained the consent of health department. That what they are referring is in 2014. Now the present order madakare illa, permission illa. Therefore, the judgment of this honorable court covers the point. That is one point. Amel then now who have been posted, kindly see the page number 96, my lord.
Yes.
My lord, page number 96 is the order appointing nurses in the institute, my lord, Bangalore Medical College and Research Institute. My lord, at page number 106, my lord, class 16. ಅಭ್ಯರ್ಥಿಗಳು ಈ ಸಂಸ್ಥೆಯಲ್ಲಿ ಕರ್ತವ್ಯಕ್ಕೆ ಹಾಜರಾದ ನಂತರ ಯಾವುದೇ ಸರ್ಕಾರದ ಸ್ವಾಯತ್ತ ಸಂಸ್ಥೆ ಅಥವಾ ಬೇರೆ ಯಾವುದೇ ಸಂಸ್ಥೆಗೆ ನಿಯೋಜನೆ ಅನ್ಯಪರ ಸೇವೆ ವರ್ಗಾವಣೆ ಕೋರಿ ಯಾವುದೇ ಕಾರಣಕ್ಕೂ ಅರ್ಜಿ ಸಲ್ಲಿಸುವುದಿಲ್ಲ ಎಂಬ ನಿಬಂಧನೆ ಕರ್ತವ್ಯಕ್ಕೆ ವರದಿ ಮಾಡಿಕೊಳ್ಳೋದು. These are the nurses appointed in BMCRI.
Are you there in that?
No, my lord, I am submitting. These persons have been now posted on part-time. That list of documents are produced Kindly see the order, madam. List of documents. List of documents. 27. Kindly see, madam. ಯಾರನ್ನಲ್ಲಿ ಪೋಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ BMCR ಅಲ್ಲಿ ಇರೋ ನರ್ಸಸ್ ಮಾಡಿದ್ದಾರೆ. That order, kindly see page number 14. ಇದರಲ್ಲಿ ಈಗ ಲಿಸ್ಟ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಸರ್ಕಾರಿ ಶುಲ್ಕ ತಾತ್ಕಾಲಿಕ ಸಿಬ್ಬಂದಿ ನಿಯೋಜಿಸುವ ಬಗ್ಗೆ ಇಲ್ಲಿ ಕೆಳಗಡೆ ತಾವು ನೋಡ್ಕೊಂಡು ನಯನ, ಅರ್ಚನಾ, ಮಾರ್ಷಲ್ಲು, ಅಲ್ವಿಟ ಇವರೆಲ್ಲ BMCR ಏನವರು ಪಾರ್ಟ್ ಟೈಮ್ ಇವರಿಗೆ ಪಾರ್ಟ್ ಟೈಮ್ ಪೋಸ್ಟ್ ಮಾಡಿ ಈಗ ದೇ ಆರ್ ಎಕ್ಸ್ಟ್ರಾಕ್ಟಿಂಗ್ ದಿ ವರ್ಕ್ ದೋ ದೇ ಡಸಂಟ್ ಹ್ಯಾವ್ ಎನಿ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್. ಈಗ ಆನ್ ಅಕೌಂಟ್ ಆಫ್ ದಿಸ್, ಮೈ ಲಾರ್ಡ್, the university has cancelled the recognition of examination center, which we were managing 5 people. Therefore, the benefit given to Saraswati also to be given to me, so that I will also work as a professor and head of the department of medical surgical department. But then the university requested me to kindly do the dissertation work, even though I have been repatriated. The university requested me, called me, and I have completed that work also. Because of that, hundreds of students have got examination completed, madam. Therefore, in the interest of service of the department, I have done my work. Now they cannot say, we are repatriating you. Repatriation, the present order, Annexure A10, is without support or obtaining approval of the health department. That is my submission. And page number 181, my lord.
Yeah.
181.
Yeah. Read.
In the kindly see on it.
Yeah.
A21. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಉಲ್ಲೇಖ ಇದು ಡೀನ್ ಅಂಡ್ ಡೈರೆಕ್ಟರ್ ಬರ್ದಿತ್ತು. ಅದರಲ್ಲಿ ಲಾಸ್ಟ್ ಪ್ಯಾರಾದಲ್ಲಿ ನಾನು ಹೇಗೆ ಪೋಸ್ಟ್ ಮಾಡಿದ್ರೆ ಎಲ್ಲ ಡೀಟೇಲ್ಸ್ ಬರೋದು. ಈ ಕಾಲೇಜ್ನಲ್ಲಿ ಈಗಾಗಲೇ INC 181 ಅಂದ್ರೆ ನೆಕ್ಸ್ಟ್ 182 ಮೈಲಾಡ್. ಅದಲ್ಲ ಬುಕ್ ಬರೋದು ಅದಲ್ಲ ಚೀಟಿ ಬರ್ಕೊಂಡು ಅಲ್ಲಿ 182ನಲ್ಲಿ ಲಾಸ್ಟ್ ಪ್ಯಾರಾದಲ್ಲಿ ಈಗ ಈ ಕಾಲೇಜಿನಲ್ಲಿ ಈಗಾಗಲೇ INC ನಿಯಮಾವಳಿ ಪ್ರಕಾರ ಬೋಧಕರ ಕೊರತೆ ತುಂಬ ಇರುವುದರಿಂದ ಇವರಿಬ್ಬರ ಸೇವೆಯು ಈ ಕಾಲೇಜಿಗೆ ಅತ್ಯವಶ್ಯಕವಾದ ಖಾಲಿ ಇದ್ದ ಉಪನ್ಯಾಸಕರ ಎದುರು ಹುದ್ದೆಗೆ ಒಬ್ಬರನ್ನು, ಕ್ಲಿನಿಕಲ್ ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಹುದ್ದೆಗೆ ಒಬ್ಬರನ್ನು ನೇಮಿಸುವುದರಿಂದ ಈ ಬಗ್ಗೆ ಪರಿಸ್ಥಿತಿ ಮುಂದಿನ ಮೂಲಕ ಕೋರಲಾಗಿದೆ. ವಾಟ್ ಹ್ಯಾಪನ್ ಮಿಲಾಡ್ ದೋ I have been transferred as a clinical instructor. Later I have been designated as a lecturer. And ಇದರ ಪ್ರಕಾರ ತುಂಬ 16 into 40, 50 staff ಬೇಕು. Only 9 people are managing this college. Even 9 experienced people, they want to shift away, which ultimately affected the college, and now it derecognized. I mean, in the sense, the university has not recognized it as a center. And last, yes, yeah, please. Then, my lord, these employees of Bangalore Medical College and Research Institute, employees cannot be posted in this because these posts are in the health department. It amounts to the institute employee being posted as a government servant. I am a government servant. If my service is experienced in the medical education wing, they cannot ask me to work elsewhere, work as a nurse. Therefore, now they are posting those employees of institute in the government post, which cannot be done.
Oh.
In respect of this, there is a writ appeal pending before this Honorable Court, not me, my lord. The government itself has filed a writ appeal. In writ appeal number 997 of 22, wherein the question was the institute employees sought for direction to fill up the post in the medical wing, which are to be filled up by the health department. Then court, a single judge gave a direction, you treat them as employees of institute. That was challenged by the government, and that issue is pending. In view of that, my lord, the employee of the BMCRI cannot be posted to the government post. What happens now? An employee of institute who doesn't have pension and other things as applicable to the government servant is made to work as a government servant in the medical education department, medical education wing of the health and family welfare department. This is a hard case, my lord. And CN, for my case, for absorption, it is at page number 244, C&R rules, provides for me to absorb in the present.
Your matter is
Of
pending
course,
there.
that matter is before the division bench, my lord. Now, if you go out of this post, my lord, my case will also dies, my lord.
ಯಾಕೆ ನಾವು ಹೇಳ್ತೇವೆ ನಿಮ್ನ ಇಂಡಿಪೆಂಡೆಂಟ್ಲಿ ಇಲ್ಲಿ ಡೆಪ್ಯುಟೇಷನ್ ವ್ಯಾಲಿಡ್ ಆರ್ ನಾಟ್, ರಿಪ್ಯಾಟ್ರಿಯೇಷನ್ ವ್ಯಾಲಿಡ್ ಆರ್ ನಾಟ್ ಇಷ್ಟೇ ನೋಡಿ ನಾವು ಇದ್ರ ಮೇಲೆ ನಾವು ಹೇಳುವಂತದ್ದು ಅಲ್ಲಿ ಇಟ್ ವಿಲ್ ನಾಟ್ ಕ್ಯಾಸ್ಟ್ ಎ ಶಾಡೋ ಆನ್ ಯುವರ್ ಪ್ರಾಸಿಕ್ಯೂಟಿಂಗ್ ಯುವರ್ ರಿಟ್ ಅಪೀಲ್. ಅದನ್ನ ಪ್ರೊಟೆಕ್ಟ್ ಮಾಡೋಣ.
ಏನಾಗಿದೆ ಲೀವ್ ಅಪಾರ್ಟ್ ಮೀ ಮೈ ಲಾರ್ಡ್, ಅಲ್ಲಿ ಆ ಕಾಲೇಜ್ನಲ್ಲಿ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಟೀಚರ್ ಇಲ್ದೇನೆ ಸಫರ್ ಆಗ್ತಾ ಇದ್ದಾರೆ. That is
government is the
and the student also have given a representation saying that all teachers have been transferred experience. We are suffering ಅಂತ ಹೇಳಿ. Based on that, university requested me to do work, my lord. Even though I have been repatriated.
You are not employee of the university.
Huh?
You are not employee of the university.
No, I am a teacher recognized by the university for doing examination work. And I have given a TIN number as that is teacher's identification number 7, my lord, out of 3,000. That means my seniority in the university as a senior most professor is recognized. ಏನಾಯ್ತು ಅಂದ್ರೆ ಎಕ್ಸಾಮ್ಗೆ ಇತ್ತಲ್ಲ ಹುಡುಗರೆಲ್ಲ ಕೂತಿದ್ರಲ್ಲ ಅವ್ರಿಗೆ PhD ಗೈಡ್ ಮಾಡಿದ್ದೆ ನಾನು. ಆ ಹುಡುಗರಿಗೆ they were facing problem of losing examination. Then university directed me to please do it this work. In the interest of students, I have done that work and they have got examination. Otherwise, there would have been a serious problem in the college itself. Now the persons who have been posted nurses are not having experience to teach the college nalli. PhD guide ಆಗ್ಲಿಕ್ಕೂ ಯಾರಿಗೂ ಇದು ಇಲ್ಲ. ಅಂಥವ್ರನ್ನೇ ಪಾರ್ಟ್ ಟೈಮ್ ಕೆಲಸ ಮಾಡಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. It's nothing but other than the killing the entire. There are 500 students in the different PBBSc, MSc and other courses. 500 students, it affects me. This aspect nobody wants to look in except taking view, against me, because I have challenged the earlier order in the year 2014. At Hook or Crook, they want me to go out of this. This is, I am fighting alone. I completed 12 years here, my lord, in the medical wing. Medical wing in the bit ನನ್ನ nurse ಆಗಿ ಹೋಗಿ ಕೆಲಸ ಮಾಡೋ ಅನ್ನೋದು, it is not only for me, it is for the interest of the students also effect. That you last may have to take lenient. And health department in ಈಗ ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ ಈ ಪಾಯಿಂಟ್ ಬಗ್ಗೆ. ದಟ್ ಈಸ್ ಕವರ್ಡ್ ಬೈ ಜಡ್ಜ್ಮೆಂಟ್, my lord. 2014 ಹೇಳಿದ್ದೀನಿ, ಹೇಳಿದ್ದಾರೆ. Your Lordship, the other day asked the government advocate whether before passing the impugned order, the health department concurrent ತಗೊಂಡಿದೆಯಾ ಅಂತೇಳಿ. ಇಲ್ಲ, concurrent ತಗೊಂಡಿಲ್ಲ. On that basis, that order goes. That is my responsibility.
Anything more you want to say?
Lord, insofar as the question of whether consent was taken is concerned.
ಬೇರೆ ಯಾವ್ದಾರ ಪಾಯಿಂಟ್ಸ್ ನಿಮ್ದು ಉಳಿದಿದೇನೋ? ಏನೋ ತೋರಿಸ್ತಾ ಇದಾರಲ್ಲ ಇನ್ಸ್ಟ್ರಕ್ಟಿಂಗ್ ಕೌನ್ಸಿಲ್, ಅದು ಹೇಳ್ಬಿಡಿ.
ಆ ಬುಕ್ ನಲ್ಲಿರೋದು ಹೇಳಿ ಅಂತಾರೆ.
ಹೇಳಿ ನೋಡ, ಏನೋ ಒಂದು ಹೊಸದಿದ್ರೆ ನಮಗೂ ಗೊತ್ತಾಗ್ತದೆ.
ಜೂನಿಯರ್
ಹೇಳಿ ಇನ್ನು ಟೈಮ್ ಬೇಕಾದಷ್ಟು ಟೈಮ್ ಇರ್ತದೆ ಎಲ್ಲರಿಗೂ.
ನೀವೇ ಹೇಳಿ. ಅದು ಪ್ಯಾರಾ 635 ನಲ್ಲಿ ಇಫ್ ರಿಪ್ಯಾಟ್ರಿಯೇಷನ್ ಎಫೆಕ್ಟ್ಸ್ ಸಿವಿಲ್ ಕಾನ್ಸಿಕ್ವೆನ್ಸಸ್ ಇಟ್ ಶುಡ್ ಬಿ ಇಂಟರ್ಫಿಯರ್ಡ್ ಅಂತ. ನನಗೇನಾಗಿದೆ ಅಂದ್ರೆ ನನ್ನ ರೈಟ್ ಇಲ್ಲಿ ಹೊರಟೋಗಿದೆ.
ಯಾವ ರೈಟ್? ಏನ್
ರೈಟ್?
5 ವರ್ಷ ಆದ್ಮೇಲೆ
ಅಲ್ಲ, ರೈಟ್ ಟು ರಿಮೇನ್ ಆಸ್ ಎ professor and head of the department.
Where is your right of lien? You are not answering the question. Any standard book on service jurisprudence will say,
correct,
unless right of lien is established, you have no right at all.
Correct. Right of lien ಬಗ್ಗೆ ಹೇಳೋದಾದ್ರೆ ನಾ ಹೆಲ್ತ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ನಲ್ಲೇ ಇದ್ದೇನೆ. ನಾನು ಹೆಲ್ತ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಹ್ಯಾಸ್ ನಾಟ್ passed any order. This medical education cannot pass orders. That is my respectful submission. A10 is passed by the medical education secretary. He cannot pass orders without consulting the health department. Annexure A11 ನಲ್ಲಿ the health department says, yes, ಅದನ್ನು ಒಂದೇ ನಿಮಿಷ ತೋರಿಸ್ಬಿಡ್ತಾನೆ. A11 page number.
ಹೇಳ್ತೇವೆ ಸಾಕಷ್ಟು ಟೈಮ್ ತೊಳಿ, ಒಂದೇ ನಿಮಿಷ
ಅಲ್ಲ,
ಆದಷ್ಟು ಟೈಮ್ ತೊಳಿ, ಎಲ್ಲರೂ ಕಾಯ್ಕೊತಿರ್ಲಿ.
A11 ನಲ್ಲಿ ಒಂದು ಸಾರಿ ನೋಡಿ ಹೇಳ್ಬಿಡ್ತಾನೆ.
ಹೇಳಿ.
Kindly see the A11.
ನಾವು ಡಿಸ್ಮಿಸ್ಡ್ ಆದ ಎಂಪ್ಲಾಯಿಗೂ ಇಷ್ಟೊಂದು ಟೈಮ್ ಕೊಟ್ಟಿಲ್ಲ. ನಿಮ್ಗವ್ರ ಪಾಪ ಪೇರೆಂಟ್ ಡಿಪಾರ್ಟ್ಮೆಂಟಿಗೆ ಹೋಗಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
ಅಲ್ಲ,
ಡಿಸ್ಮಿಸ್ಡ್ ಆದ
ಅಲ್ಲ, ಅದನ್ನು ಒಂದು ಪ್ಯಾರ ಓದ್ಬಿಡ್ತೇನೆ.
ಓದಿ.
ಒಂದೇ ಪ್ಯಾರ. A11 ನಲ್ಲಿ 27/9/23 ಮಾನ್ಯ ಆರೋಗ್ಯ ಸಚಿವರ ಅಧ್ಯಕ್ಷರಲ್ಲಿ ಮತ್ತು 5/10/23 ಮಾನ್ಯ ಆರೋಗ್ಯ ಸಚಿವರು ವೈದ್ಯಕೀಯ ಶಿಕ್ಷಣ ಸಚಿವರ ಜಂಟಿ ಅಧ್ಯಕ್ಷರ ಸಭೆಯಲ್ಲಿ ಚರ್ಚೆಗಳನ್ವಯ ಜಿಲ್ಲಾ ಆಸ್ಪತ್ರೆ ಮತ್ತು ಇತರ ಪ್ರಮುಖ ಆಸ್ಪತ್ರೆಗಳಲ್ಲಿ ಆರೋಗ್ಯ ಇಲಾಖೆಯಿಂದ ಮಂಜೂರಾಗಿರುವ ಹುದ್ದೆಗಳಿದ್ದು ಖಾಲಿ ವೈದ್ಯಕೀಯ ಶಿಕ್ಷಣ ಇಲಾಖೆಯಲ್ಲಿ ಇರೋದರಿಂದ ಅವುಗಳನ್ನು ಗುರುತಿಸಿ ಸರ್ಕಾರಕ್ಕೆ ಮಾಹಿತಿ ನೀಡುವಂತೆ ಸೂಚನೆ ನೀಡುತ್ತಾರೆ. In the health department itself, the posts which have been meant in the health department are working in the colleges and district hospital. They have yet to take a decision on that, whether it should be entire 500 posts to be given to the medical education or not. Suppose if they decide, all right, we'll give entire 500, 600 posts to the medical education department.
Yeah.
Then they have to take a policy decision with regard to the status of the employees who are working there for years together. Simply, they cannot say the post is given, post is sent without considering the case of the employees. Then what happens? The employees will lose. They have to come back to the health department because they are working in the medical education for so many years. Their cases have to be considered by the government. This aspect
ಓದಿ, ಏನೋ ಕೊಡ್ತಾರಲ್ಲ, ಓದಿ.
ಇದರಲ್ಲಿ ಇವತ್ತು ಒಂದು ನಾನು ಮೆಮೊ ಹಾಕಿದ್ನಲ್ಲ, ಲೀಸ್ಟ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ನಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 11 ನಲ್ಲಿ ಒಟ್ಟು ಮಂಜೂರಾದ 894 ಹುದ್ದೆಗಳಲ್ಲಿ 680 ಆರೋಗ್ಯ ಮತ್ತು ಕುಟುಂಬ ಕಲ್ಯಾಣ ಇಲಾಖೆಯಿಂದ ನಿಯೋಜನೆ ಸಂಸ್ಥೆಯಿಂದ ನೇಮಕ ಪ್ರಸ್ತುತ ಔಟ್ ಆಫ್ 894 ಸ್ಯಾಂಕ್ಷನ್ ಪೋಸ್ಟ್ 680 ಆರ್ ವರ್ಕಿಂಗ್. ನಾನು ಒಬ್ಬರನ್ನ ತೆಗೆದ್ರೆ ಈಗ ಆ ಥರ 680 ತೆಗೆದು ಕಳಿಸ್ಬೇಕು ವಾಪಸ್. ನೋ, ಯುವರ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಈಸ್ ಹೆಲ್ತ್, ಯು ಗೋ ಬ್ಯಾಕ್ ಅಂತೇಳಿ. In that event, it can't be, they can't run even the department. That is.
Yes.
ಹೇಳಿದೆ ನಾನು ತೊಂದರೆ ಆಗಿದೆ ಅಂತ ಹೇಳಿ.
ನಮಗೇನು ತೊಂದರೆ ಇಲ್ಲ, ನಮ್ಗೆ 12 ಗಂಟೆ ತನಕ ಟೈಮ್ ಇದೆ.
ಅಲ್ಲ
12ಕ್ಕೆ ನಾವು ಟೀ ಕುಡಿಯಕ್ಕೆ ಹೋಗೋದು. ಇವತ್ತು ಸ್ವಲ್ಪ ಬೇಗನೆ ಹೋಗ್ಬೇಕಾಗ್ತದೆ.
ಮೇಲೆ ಸರಸ್ವತಿಗೆ ನೀವು ಆಲ್ ರೈಟ್ ಕಂಟಿನ್ಯೂ, ನಿನಗೆ ಆ ಪೋಸ್ಟ್ ನಲ್ಲಿ ಯಾರು ಇಲ್ಲ ಅಂತ. ನನ್ನ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಮೆಡಿಕಲ್ ಸರ್ಜಿಕಲ್ ನನ್ನ ಬಿಟ್ಟರೆ ಯಾರು ಇಲ್ಲ. ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ಡ್ ಟೀಚರ್ ಕೇಟರ್ನಲ್ಲಿ ಇನ್ನು 4 ವರ್ಷ ಇದೆ ಸರ್ವಿಸ್ ನಲ್ಲಿ.
This dismissal will not come in the way of petitioner working out her petition seeking absorption of her services in the Deputation department in accordance with law.
Medical education.
First, all our observations herein above made are confined to validity of repatriation. Okay. Next.
Lords, an advocate is before the court, Lords, against the termination of his wakalat by the learned judge. But since the orders is passed, Lords, by Lords, a learned judge of this honorable court, in view of Chandrakumar's case, the matter has to be placed before the division bench of this honorable court. Your Lordship holds the roster for writ petitions not otherwise assigned.
Residuary ಎಲ್ಲ ನಮಗೆ ಇದೆ.
Please, Lords.
ಏನು ಯಾಕೆ ಹಿಂಗೆಲ್ಲ
Milords,
ಏನೋ ಒಂದೊಂದ್ಸರಿ ಈ ಜಡ್ಜಸ್ ನಾವೇನೋ ಒಂದ್ ಮಾತಾಡ್ತೀವಿ, ಬೇಡ ಲಾಯರ್ಸ್ ಒಂದ್ ಏನೋ ಒಂದ್ ಮಾತಾಡ್ತಾರೆ, ಅದನ್ನ ಪರ್ಸನಲಿ ತಗೋಬಾರ್ದು.
ಏನು ಅಲ್ಲ ಇದ್ರೊಳಗೆ
ಏನಾಗ್ತದೆ ಪ್ರೆಷರ್ ನಲ್ಲಿ ನೀವು ಒಂದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀವಿ, ನಮಗೂ ಪ್ರೆಷರ್ ನಾಗ ಇರ್ತದೆ. ಕೆಲವು ಸರಿ ನಾವು ಒಂದ್ಸರಿ ಏನೋ ತಪ್ಪು ಮಾತಾಡ್ಬಿಡ್ತೀವಿ, ಕೆಲವು ಸರಿ ನೀವು ತಪ್ಪು ಮಾತಾಡ್ಬೋದು. ಅದನ್ನ ಒಂದು ಫ್ಯಾಮಿಲಿ ಇದು
yes,
ತಗೊಂಡು
Milords,
ಅದನ್ನೇ ಹೈಲೈಟ್ ಮಾಡ್ಕೊತ ಹೋಗಕ್ ಬರ್ತದೆ.
certainly not.
ಆಯಾ
Milords,
ಕೇಸಿಗೆ ಸಂಬಂಧ ಪಡೋದೇ ಇರ್ತದೆ. ಏನೋ ಒಂದು ಈ ಜಡ್ಜ್ ಏನ್ ತಿಳಿಯೋದಿಲ್ಲ ಅಂತ.
Milords, I just want to say this, Milords. Milords, one GM Kumar is exposed to either prosecuting or defending several civil and criminal litigations. Milords, the advocate before your lordships, the petitioner, is representing him since 2020. I have produced the list of cases which has appeared at page number 10. He is consistent. He is his client. Milords, during only one period, during his daughter's wedding, I have stated so, Milords, if your lordships were to see, at paragraph number 11, page 13. Lords, every case, every single case, I am only appearing. The petition only is appearing for this person.
ಈ ಬಾಲಕೃಷ್ಣನ್ ಅಂದ್ರೆ ಬಾಲನ್
Balan. Lords, what happens?
ಗುಡ್ ಪರ್ಸನ್,
Yes.
ಗುಡ್ ಅಡ್ವೊಕೇಟ್ ಆಲ್ಸೋ.
Lords, now, the roster bench was His Lordship Justice Nawaz. Lords, an advocate filed an application before the concerned bench, who was otherwise disabled, to appear before him to assist the prosecution. Lords, matter came before the other bench, not that we chose the bench. It is because of the special orders which is passed by the Honorable Chief Justice. Matter comes, Lords, before the concerned judge. Lords, there a 438 petition is not prosecuted. They have withdrawn it. That is the point of time when it was my daughter's wedding. That's when what happened. Subsequently, 439 is filed by me. Page 52, I appeared before the magistrate for the very same accused. Page 52. They filed an application for cancellation of bail. Cancellation of bail, Milords, in view of the roster which was prescribed, it comes before the very concerned
ಅದರ್
court.
ಅಡ್ವೊಕೇಟ್, ಸೇಮ್ ಅಡ್ವೊಕೇಟ್.
Same bench.
ಬಟ್ ಅಪೆಕ್ಸ್ ಕೋರ್ಟ್ ಸೇ
Now, that's the reason, Milords. This is the problem which we are facing. But the court, the registry usually has listed the matter when the roster bench was His Lordship Justice Nawaz. The matter comes before him. Notice he takes an exception to the fact that the wakalat is filed by this petitioner in respect of the matter which is posted before him and disables him. It is not that I have appeared for the first time. I am consistent.
ಅವ್ರಿಗೆ ಹೇಳ್ಬೇಕು, ನವಾಜ್ ಸಾಹೇಬ್ರು ಒಳ್ಳೆ ಸಾಹೇಬ್ರು.
ಅಲ್ಲ,
ಅವ್ರಿಗೆ ಹೇಳಿ
ನಟರಾಜನ್ ಸಾಹೇಬ್ರು,
ಯಾರ ಮುಂದೆ ಬಂದಿತ್ತು?
ನಟರಾಜನ್ ಸಾಹೇಬ್ರು ಮುಂದೆ. ಅದು ರೋಸ್ಟರ್ ನವಾಜ್ ಸಾಹೇಬ್ರು ಇದ್ದಾಗ ಅವರು ಬೇರೆ ಯಾರೋ ಅಡ್ವೊಕೇಟ್ ಅವ್ರ ಮುಂದೆ ಡಿಸೇಬಲ್ ಅವ್ರು ಆಗಿರೋದು ಹಾಕಿದ್ರಿಂದ ನಟರಾಜನ್ ಅವ್ರ ಮುಂದೆ ಬಂದ್ರು. ಆರ್ಟಿಕಲ್ 22(1).
Why advocate should suffer?
Notice,
Balu is a good advocate.
Yes,
We have seen.
under order.
Vociferous advocate, good speaker.
But he's a very
Having
very good
concern.
speaker.
He's here. He's
Yes.
sitting here. ಯಾಕೆ ಇದನ್ನೆಲ್ಲ ಹಿಂಗೆಲ್ಲ ಮಾಡ್ಕೋತೀರಿ ನೀವು?
The wakalat filed before the roster bench, my lord, not before His Lordship. And only.
That's the, Lords,
He's a very
yes,
man having concern for downtrodden.
Lords, especially
We may not agree with his argument, but ಹಿಂಗೆಲ್ಲ
very astute, my lords, very astute lawyer.
ಹಂಗೆಲ್ಲ is a good person. ಡೈವರ್ಜೆಂಟ್ ವ್ಯೂಸ್ ನಮಗೆ ಭಿನ್ನತೆ ಇರಬೇಕು. ಅದೊಂದು ಯಾವುದೋ ಒಂದು ಇವ್ರ ಯಾರ್ದು ಗೋಪಾಲಕೃಷ್ಣ ಅಡಿಗರ ಒಂದು ಪೋಯಂನಲ್ಲಿ ಕಂಡೆ ಬೆಸೆದೆದೆಗಳನ್ನು ಭಿನ್ನತೆಯ ವಿಕಟ ಹಾಸ. ಇಬ್ರು ಜೊತೆಗೆ ಯಾಕಿದ್ದಾರೆ ಅಂದ್ರೆ ಅವರಿಬ್ಬರ ನಡುವೆ ಇರುವಂತ ಭಿನ್ನತೆಯಿಂದ ಜೊತೆಗಿದ್ದಾರೆ. ಐಡಿಯಾಲಜಿಕಲ್ ಡಿಫರೆನ್ಸಸ್ ಅದ್ನೇನ್ ಮಾಡೋದು ಬರ್ತದೆ. ಅಲ್ಟಿಮೇಟ್ಲಿ ನಂದು ಐಡಿಯಾಲಜಿ ನನಗೆ ಅವ್ರ ಐಡಿಯಾಲಜಿ. ಈಸ್ ಎ ಗುಡ್ ಪರ್ಸನ್. ವಿ ಹ್ಯಾವ್ ಸೀನ್ ಹಿಮ್. ಈಸ್ ಎ ಗುಡ್ ಪರ್ಸನ್, ಗುಡ್ advocate. They all work for some social cause. Maybe they may be critical of political dispensation, etc. But how can all that be irrelevant? And what fault he has done? He has filed his wakalat. As per that,
yes,
this judgment came only afterwards.
Yes, my lords.
That judgment of
the Supreme Court has come thereafter.
ಏನು ಅವ್ರಿಗೆ ಹೋಗಿ ಹೇಳಲಿಕ್ಕೆ ಬರ್ತಿತ್ತು ಬಾಲು.
ಅವರು
ಹೋಗ್ಕೊಂಡು ಸ್ವಾಮಿ ಯಾಕೆ ಹಿಂಗೆಲ್ಲ ಮಾಡ್ತೀರಿ, ಇದ್ರಾಗ ಏನಿದೆ ಅಂತದ್ ನಂದು ಅಂತ ಒಂದ್ ಮಾತು ಹೇಳಿದ್ರು. ಮಾಡೇ
ಜಡ್ಜ್ ಆದ್ಮೇಲೆ ನಾನು ಭೇಟಿ ಆಗ್ಲೇ ಇಲ್ಲ. I never met him moment. Prior to that, to 1 or 2 cases, we engaged together because I happened to be a senior to him. He engaged me in 2-3 cases. That's all my relationship. Never I met him. When even elevated, I didn't go and meet him.
More particularly, my lords.
ಆಮೇಲೆ ಹಿಂಗೆಲ್ಲ ನಾವು ಆ ರೀತಿ ಮಾಡಬಾರ್ದು. ಏನು ಓದ್ಕೊಂಬರ್ಲಿದ್ದಾಗ ಮಾಡಿದಾಗ ನಾವು ಏನೇನೋ ಒಂದೆರಡು ಮಾತಾಡ್ತೀವಿ, ಅದೇನು ಓದ್ಕೊಂಬರ್ಲಿ ಅನ್ನೋ ಕಾರಣಕ್ಕೆ ಅದನ್ನೇನು ಇದರಲ್ಲಿ ಇಟ್ಕೊಳಕ್ ಬರ್ತದ ಮನಸ್ಸಿನಲ್ಲಿ.
Lords, the learned judge has already said that he's in the disabled list.
ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ ಇಂದ ಬಂದಿಲ್ಲ. ಇಲ್ಲ, ನಮ್ದು ಆಲ್ ರೆಸಿಡ್ಯೂರಿ
No, no, all residuary matters.
ಏನಾಗಿದೆ? ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ ಇಂದ ಬಂದಿದೆ ಇದು.
ಇಲ್ಲ. Residuary ನಾನು ನೋಡಿದ್ನಲ್ಲ, ಬೆಳಗ್ಗೆ ನಾನು ನೋಡ್ಕೊಂಬಂದೆ. Writ petition not specifically assigned ಅಂತ ಐತೆ, ನಾನು ಬೆಳಗ್ಗೆ ನೋಡ್ದೆ.
Yes, brother, why advocate should suffer?
I agree with the view taken by the.
ಪಾಪ ಏನ್ ಗೊತ್ತಾ, ಆಮೇಲೆ ಎಷ್ಟೋ ಸಾರಿ ಇವ್ರು ನಾನು ಲಾಯರ್ ಇದ್ದಾಗ ಸಹಿತ ಹೆಂಗಾಗಿತ್ತು ಒಂದ್ಸರಿ ಇನ್ನೂ ಎಕ್ಸ್ಟ್ರೀಮ್. ನಾವು ಅಪಲೆಂಟಿಗೆ ವಕಾಲತ್ ಹಾಕಿದ್ವಿ, ಅದು 8 ವರ್ಷ ಆದ್ಮೇಲೆ ಹಿಯರಿಂಗಿಗೆ ಬಂತು. ಆಮೇಲೆ ಮತ್ತೆ ರೆಸ್ಪಾಂಡೆಂಟಿಗೆ ವಕಾಲತ್ ಹಾಕಿದ್ವಿ ನಮ್ಮ ಆಫೀಸ್. ಕೌನ್ಸಿಲ್ ಅಡ್ವೊಕೇಟ್ ಕೃಷ್ಣ ದೀಕ್ಷಿತ್ ಅಡ್ವೊಕೇಟ್ ಫಾರ್ ಪಿಟಿಷನರ್, ಕೃಷ್ಣ ದೀಕ್ಷಿತ್ ಅಡ್ವೊಕೇಟ್ ಫಾರ್ ರೆಸ್ಪಾಂಡೆಂಟ್, ಸೋಲ್ ರೆಸ್ಪಾಂಡೆಂಟ್. ಬಿಡಪ್ಪ, ಯಾವುದೋ ಒಬ್ಬ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇದ್ದಾರೆ, ಏನೋ ಆಗಿದೆ. ಆಮೇಲೆ ಅನ್ವರ್ ಸಾಹೇಬ್ರು ಮುಂದೆ ಬಂತು. ಅನ್ವರ್ ಸಾಹೇಬ್ರ ಮುಂದೆ ನಾವು ಹೋಗಿ ಹೇಳಿದೆ, ಇಲ್ಲ ಇದು ನಮ್ಗೆ ಗೊತ್ತಾಗಿಲ್ಲ, ನಮ್ಗೇನು ಭಾಳ ಪ್ರಾಕ್ಟೀಸ್ ಇಲ್ಲ ನಿಜ, ಆದರೂ ಸಹಿತ 100,000 ಕೇಸ್ ಇರ್ತಾವೆ, ಅದ್ರಲ್ಲಿ ಏನೋ ಹಿಂಗೆ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ, 2 ಕೇಸ್ನಿಂದ ರಿಟೈರ್ ಆಗಿ ಅದರಲ್ಲಿ ಇನ್ನೊಂದು ಸರಿ ಹೀಗೆ ಮಾಡಬೇಡ್ರಿ ಅಂತ. ಇಲ್ಲ ಮಾಡಲ್ಲ ನಾವು ಹೇಳಿದೆ. ಯಾಗತ್ತು ಒಂದೊಂದು ಸರಿ ಇದ್ದೇನೆ ಇಷ್ಟೊಂದು ಪರ್ಸನಲೈಸ್ ಮಾಡಿಕೊಳ್ಳು, ನಾಳೆ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡೋದು ಅಷ್ಟೆಲ್ಲ ಪರ್ಸನಲೈಸ್ ಮಾಡಿ ಬಿಟ್ಟು ಒಯ್ಯಬೇಕು. ಯಾವುದನ್ನು ಬ್ಯಾಗೇಜ್ ಕಟ್ಕೊಂಡು ಅಡ್ಡಾಡೋದಲ್ಲ. ಏನೋ ಒಂದು ನೀವು ಅಂತೀರಪ್ಪ ನಮಗೆ. ಈಗ ಒಬ್ರು ಸ್ವಲ್ಪ ಲಾಂಗ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾರೆ, ಕ್ಲೈಂಟ್ ಇರ್ತಾರೆ, ಅವ್ರನ್ನ ಕ್ಲೈಂಟಿಗೆ ಆನ್ಸರೇಬಲ್ ಇರ್ತದೆ, ಫೀ ಆಸ್ಪೆಕ್ಟ್ ಇರ್ತದೆ. ನಿಮ್ಗೆ ಇಷ್ಟೆಲ್ಲ ಫೀ ಕೊಟ್ಟು ಏನ್ರಿ 2 ಸೆಂಟೆನ್ಸ್ ಹೇಳಿ ಜಡ್ಜ್ ಹೋಗೋದಾಗಿನ ಬಂದ್ಬಿಡೋದ ನೀವು, ಹಿಂಗೆಲ್ಲ ಕೇಳ್ತಾರೆ ಅಲ್ವಾ, ಇದೆಲ್ಲ ಇರ್ತದೆ. ಹಂಗಾಗಿ ನಾವು ಒಂದು ಹೌಸ್ ಇದು ನಮ್ಮ ಲಾಯರ್ಸ್. ವಿದೌಟ್ ಲಾಯರ್ಸ್ ನಾವೇನು ಡಿಸೈಡ್ ಮಾಡಕ್ ಬರ್ತದೆ. ಏನ್ ನಮ್ಮ ಸ್ಪೀಚ್ ನಲ್ಲಿ ಲಾಯರ್ಸ್ ಅಂಡ್ ಜಡ್ಜ್ ವಾರ್ ಅಂಡ್ ದ ಬೆಂಚ್ ಆರ್ 2 wheels ಆಫ್ ದಿ ಸೇಮ್ ಚೇರಿಯಟ್. ಏನ್ ವಾಟ್ ಸೇಮ್ ಚೇರಿಯಟ್ ಈ ನಮನಿ ಮಾಡ್ಕೊಳೋದಿದ್ರೆ. ಅಂಡ್ ಫಾರ್ ಪರ್ಸನ್ ಲೈಕ್ ಹಿಮ್ ಈಸ್ ಅನ್ vociferous lawyer, he is committed lawyer. We don't agree with this view. Issue emergent notice.
This will be only between
ಏನಂತ ಕೇಳಿರಿ, ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಅಂತ ಕೇಳಿರಿ.
This will be only between the court and myself, my lords. Notice to respondent.
ಏನ್ ಬೇಕಿಲ್ವಾ?
ಏನ್ ಬೇಕಿಲ್ಲ ಅನ್ಸುತ್ತೆ that. Stay of continuation and operation of the orders which are impugned in this regulations. May I just draw your lordship's attention to Article 22(1).
ಇದನ್ನ ನಮ್ಮ ಇದು ಹೆಂಗೆ ನಿಮ್ದು ಪಿಟಿಷನ್ ಹೆಂಗ್ ಮೇಂಟೈನ್ ಆಗ್ತದೆ?
Lords, this is an order terminating the services of a lawyer. My rights to practice is affected. I am before your lordships. Any writ petition filed because it's by a
right to profession is affected.
My right to profession is affected.
And it avails against the judiciary.
Yes, and now
does it avail to against the judiciary?
Lords, it will. The reason is this, my lords. Under Article 22(1), so far this is a criminal case. Lords, choice of a legal practitioner is a fundamental right of a given accused. So if I am
but all right, ಆಗ್ಲಿ. ಈಗ ನೀವು ಅಲ್ಲಿ ಅಪಿಯರ್ ಆಗ್ಬೇಡ್ರಿ, ಅಲ್ಲಿ ಬೇರೆ ಯಾರ್ಯಾರ ಕೊಟ್ಟು ಕಳ್ಸಿ ಇನ್ನು ಸ್ಟೇ ಮಾಡೋಣ ಅಂತ.
Terminated my wakalat in 6 cases.
Lords, what happened in one case I can understand because that came up for cancellation of bail on the ground that the earlier bail petition had come before him. Lords, 7 other matters are brought before him for which he is not the roster judge, and he terminates the wakalat of the 7 matters where Justice Nagprasanna was the roster judge. Lords, this I'm really rendered without about 10 briefs because of this order.
This is too much. Notice to respondents 3 and 4. ಎಷ್ಟು ಸ್ಟೇಟ್ ಆಫ್ ಕರ್ನಾಟಕ ಮಾಡಬೇಕು ಅಂತ ಮಾಡಿರಿ ಈ ಕೇಸ್ ನಮ್ಮಲ್ಲಿ ಸ್ಟೇಟ್ ನಲ್ಲಿ? Go to cost item.
Yes, my lord. Sorry, my lords. Lords, two-
State of Karnataka ಮಾಡ್ತಾರೆ.
Lords, it should have been, Angalala, my lords, it should have been state by so and so police and the other one was so and so police. It
Correct.
should have been the cost item.
Change ಮಾಡಿ.
I'll correct it.
Change ಮಾಡಿ.
ಇದು 3 ಹೊಡೆದಾಗ.
ಮತ್ ಬೇರೆ ಮುನ್ನು ವಕಾಲತ್ತು ಟರ್ಮಿನೇಟ್ ಆಗಿದೆಯಾ?
Lords, in 7 other matters. On the ground that because this bail petition was there and there were other matters where 482 petitions were pending before a concerned bench.
No, this is
An
real.
order is passed.
We don't subscribe to that view. Lawyers and fearlessly argument ಮಾಡೋದು ಹೆಂಗೆ ಈ ರೀತಿ ಹಾಕೋದು? ಏನ್ ನಮ್ಮ ಮೇಲೆ ಯಾವ ಕಂಟ್ರೋಲ್ ಇಲ್ಲ, ಏನಿಲ್ಲ. Lawyers argue ಮಾಡೋದು ಬೇಡವಾ? Terminating is a very serious matter. And what impression that will give to the public? ಒಂದು ವಕಾಲತ್ ಕೋರ್ಟ್ ಕಿತ್ತಾಕಿ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡಿದೆ. ಈಗಿನ ಮೀಡಿಯಾ ಎಲ್ಲ ಗೊತ್ತಿದೆ ನಿಮ್ಗೆ. ನಾವು ಏನ್ ಮಾತಾಡಿರ್ತೀವಿ, ಅವ್ರು ಏನ್ ಹೆಡ್ಡಿಂಗ್ ಕೊಡ್ತಾರೆ ಇವನ್ನೆಲ್ಲ ನೋಡಿದ್ರೆ.
To your lordship's question, whether it is also part of the
Which
state,
is
one of the
that
wings of the
judgment?
state.
Mirajkar ತೆಗಿಯಮ್ಮ. 67 ಮಿರಾಜ್ಕರ್ ವರ್ಸಸ್ ಸ್ಟೇಟ್ ಯಾವ್ದದು?
I'll give
ಗೋಡಾ
it.
ಕೇಸ್.
Any-
Mirajkar
I'll give
ವರ್ಸಸ್
it, I'll
ಸ್ಟೇಟ್
give
ಆಫ್ ಮಹಾರಾಷ್ಟ್ರ.
Article itself says any person.
Eh?
The article itself uses the word any person.
No, fundamental right ಕೇಳ್ತಾ ಇರೋದಕ್ಕೆ, ರೈಟ್ ಟು ಪ್ರೊಫೆಷನ್ ಕೇಳ್ತಾ ಇರೋದಕ್ಕೆ.
Please.
ಸ್ಟೇಟ್ ಆರ್ಟಿಕಲ್ 12 ಬರಬೇಕಾಗತ್ತೆ. And which is that judgment? Mirajkar versus state of Maharashtra ತೆಗಿರಿ.
Mirajkar, just giving it. Mirajkar marketing. ಎಲ್ಲ ಇದ್ದದ್ದು.
60s ನಲ್ಲಿದೆ. 65 ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಪೇಜ್ 1. 67 ಸುಪ್ರೀಂ
7
ಕೋರ್ಟ್ ಪೇಜ್ 1.
Supreme Court, yes.
ಕೊಡಿ. ಕೂತ್ಕೊಳ್ಳಿ ಪಾಲನ್, ಕೂತ್ಕೊಳ್ಳಿ. ರೆಸ್ಪೆಕ್ಟೇಬಲ್ ಮೆಂಬರ್ ಆಫ್ ದ ಬಾರ್. ಬರೀ ಡೈಮೆಟ್ರಿಕ್ ಕ್ವಿಸ್ ಇದ್ದಾಗನೇ ಈ ರೀತಿ ಮಾಡಿದ್ರೆ ಹೆಂಗೆ ನಾವು? ಹಂಗೆಲ್ಲ ಮಾಡೋದು ಅಲ್ಲೇ ಇಲ್ಲ. ನಾವು ಎಷ್ಟೇ ಜಗಳಾಡ್ಕೊಳ್ಳಿದ್ದು ನಮ್ಮ ನಡುವೆ ಅಷ್ಟೇ ಅದು. ಅದನ್ನೆಲ್ಲ ನಾವು ಅದು ಆರ್ಡರ್ ಪಾರ್ಟ್ಸ್ ಎಲ್ಲ ಹಂಗೆಲ್ಲ ಮಾಡೋದು. ದಟ್ಸ್ ನಾಟ್, ವಿ ಡೋಂಟ್ ಸಬ್ಸ್ಕ್ರೈಬ್ ಟು ದಟ್ ವ್ಯೂ. ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದ್ರು ಸಾಕಾಗಿತ್ತು. ಏನ್ ಬಾಲನ್ಗೆ 7 ಕೇಸ್ನಾಗ ನಡೆಯೋದಿದೆ ಜೀವನ. He could have requested, Mr. Balan, don't appear in this.
But in that matter, if he had requested, probably, my lords, Mr. Balan wouldn't have had anything. But since he brought 7 other matters.
ಏನ್ ಬಾಲನ್ ಜೀವನ ಈ 7 ಕೇಸ್ನಾಗ ನಡೀತದ?
Lords, it is something like this.
He's having a roaring
I
practice.
understand.
Everybody knows that.
No, I fully understand, but to terminate the wakalat
Wakalat is a serious thing. We don't
for a
subscribe.
client, my lords, whom I am appearing from the past for 4-5 years consistently in relation to matters which is not with the same rostered judge. I can understand if it goes before him, he requests don't appear, that's a different matter.
No, it is terminating ವಕಾಲತ್ತು. ಆಮೇಲೆ ಆ ರೀತಿ ಏನೊಂದು ಯಾವಾಗೋ ಒಂದೊಂದ್ ಸರಿ ಸಿಟ್ ಬಂದಾಗ ನಾವೊಂದ್ ಮಾತಾಡ್ತೀವಿ, ನೀವೊಂದ್ ಮಾತಾಡ್ತೀರಿ, ಅದನ್ನೇ ಇಟ್ಕೊಂಡು ಅಡ್ಡಾಡಕ್ ಬರ್ತದ. That's not the point. We should respect the independence of the bar, fearlessness of the bar. These two things are great actually. Fearless of, if bar
It's fearless.
is not fearless, over.
Oh, that's 2 minutes.
Over. If judge is fearless or he is fearful, we can understand. If bar is, fearsome, that's bad. ಅವಾಗ ಮುಗೀತು, ಅವಾಗ ಇಂಡಿಪೆಂಡೆನ್ಸ್ ಆಫ್ ಜುಡಿಷಿಯರಿ
It's
ಮುಗಿದು.
gone, that's 2 minutes.
Immediately you are working for.
That's why.
That's true.
Working for the cause of others.
Cause of the, that's it, nuts.
ಯಾವ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅದು? ವೇರ್ ದೇ ಸೆಡ್, ತೊಳಿ, ಟೇಕ್ ದಿಸ್
May I just-
ಜಡ್ಜ್ಮೆಂಟ್. Just examine ಮಾಡಿ. I think as he rightly says, he comes with lot of very original
One
ideas.
Muthu
in the
Krishnan's
arguments.
case, in the case of Muthu Krishnan, my lords, what is the role of a lawyer is very
No, that's all.
succinctly described.
That's all right. What is, question is whether writ is maintainable against order of a single judge.
220.
Court writ ಇದು. Order of a single judge, as you rightly said, right to profession.
Yes.
And Article 12, that Professor Halswami ಏನಿದೆ position? Dr. Halswami. This is one judge, a lawyer who has doctorate and he does not write it in his wakalat. ಏನಿದೆ? Writ is maintainable?
Not maintainable is what say against the order of the judge. If he is exercising judicial function.
But termination of wakalat is a disciplinary function.
But when he
Yes, it is a disciplinary function because it casts stigma on the lawyer, which should never happen unless lawyer himself is like, we can understand. There may be such lawyers, there may be such judges. But he is not that, a tall lawyer.
Case what happened, there was an order, in fact, where there was an order saying that he should be hanged for killing. So that violates the fundamental right.
Correct.
There, official order, it violates fundamental rights.
Right. Then writ is made terrible. Okay. I think that was the case in, that was similar cases, the other. A.R. Antuli versus R.S. Naik. Right, you are.
Para 38 and 39 minutes in this.
Huh?
Para 38 and 39. Even against judicial orders. Once it violates Article 19, even by judicial orders, it can be, it's amenable under Article 32 and 226.
Okay. Yeah, read that paragraph.
May just please.
Read that. Many interns will be sitting.
Yes.
Many students will be sitting. They want to learn law. We also want to learn law. We are also eternal students. Read that paragraph. Thank you, doctor. Thank you. Yes.
Para 37 formulates the question.
Yes.
The next question which calls for a decision is, does the impugned order contravenes the fundamental rights of the petitioners under Article 19(1)? In dealing with this question, it is essential to bear in mind the object with which the impugned order has been passed. As we have already indicated,
That impugned order was blocking publication of an article.
Yes.
In
Article
Coda
19(1)(a).
Magazine. Okay.
Yes. Then para 38 minutes, I just read minutes. The question is, can it be said that an order which has been passed directly and solely for the purpose of assisting and discovery of the truth and for doing justice to the parties infringes fundamental rights of the petitioner under Article 19(1)? Argument that the impugned order affects fundamental rights of the petitioner under Article 19(1) is based on the complete misconception about the true character of the judicial process of judicial decisions. When a judge deals with the matters brought before him, his adjudication, he first decides questions of fact on which the parties are at issue and then applies the relevant law to the said facts. When the findings of the fact recorded by the judge are right or wrong, and whether the conclusion of law drawn by him suffers from any infirmity, can be considered and decided if the party aggrieved by the decision of the court takes the matter up before the appellate court. But it is singularly inappropriate to assume that the judicial decision pronounced by a judge of a competent court in or in relation to a matter brought before him for adjudication can affect the fundamental rights of the citizens under Article 19(1). What judicial decision purports to do is to decide the controversy between the parties brought before the court and nothing more. If this basic and essential aspect of the judicial process is borne in mind, it would be plain that the judicial verdict pronounced by the court or in relation to a matter brought before it for its decision cannot be said to affect the fundamental rights of the citizen under Article 19(1). The impugned order is, in a sense, an order of a collateral nature. It has no direct relation to the decision of the dispute which has been brought before the court in the proceedings before the parties.
Correct.
The learned judge, however, thought it in order that he should be able to do full justice between the parties, it was necessary to pass the impugned order. Thus, though the order in a sense is a collateral to the proceedings which is pending before the court, it was directly connected with the said proceedings inasmuch as the learned judge found that he could not do justice between the parties and decide the matter satisfactorily unless the publication of Goda's evidence was prohibited pending trial. The order is not collateral in the sense the jurisdiction of the judge to pass the order can be challenged otherwise than by a proceedings in an appeal. Just as an order passed by a court on merits of the dispute before it can be challenged only in appeal and cannot be said to contravene the fundamental rights of the litigant before the court, so could the impugned order be challenged in an appeal under Section 136 of the Constitution, but it cannot be said to affect the fundamental rights of the petitioners. The character of judicial order remains the same whether it is passed in a matter directly in issue between the parties or is passed incidentally to make an adjudication of the dispute between the parties fair and effective. On this view of the matter, it seems to us that the whole attack against the impugned order based on the assumption that it infringes on the petitioner's fundamental rights under Article 19(1) must fail. And having said that, then para 53, it is well settled that powers of this court to issue writs of certiorari under 32(2) as well as the high courts of the similar writs under 226 are wide. In fact, the powers of the high courts under 226 in a sense is wider than those of the court because the exercise of powers of this court to issue writs of certiorari are limited to the purposes set out in Article 32(1). The nature and extent of the writ jurisdiction conferred on the high courts under 226 was considered by this court in so and so. It would be useful to refer to some point elucidated in this judgment. The first point was made clear by Justice Mukherjee, who spoke for the court like this. In view of the express provisions of our constitution, we need not look back to the early history on the procedural technicalities of the writs in English law. nor feel oppressed of any difference or change of opinion expressed in particular cases by English judges. We can make an order to issue writ in the nature of certiorari in all appropriate cases and in all appropriate manner, so long as we keep to the broad and fundamental principles of relating to the exercise of jurisdiction in the matter of granting such writs. On one of the essential features, according to Mukherjee, then Lords, it discusses.
The Mukherjee and
Justice Mukherjee.
B.K. Mukherjee it was.
Lordships. The scope of writ jurisdiction of this court in dealing with the writ petitions on 32 was examined by the special bench under so and so. Then paragraph number 65.
There is one
We are
paragraph.
therefore satisfied that so far as jurisdiction of this court to issue writ of certiorari is concerned, it is impossible to accept the argument of the petitioners that judicial orders of the high courts or in relation to the proceedings pending before them are amenable to or corrected by exercise of the said jurisdiction. We have no doubt that it would be unreasonable so attempt to rationalize the assumption of jurisdiction of this court under 226 to correct the judicial orders on the fanciful hypothesis that high courts may pass extravagant orders or in relation to matters pending before them, that by a remedy by way of a writ certiorari should therefore be sought for and be deemed to be included within the scope of 32. The word Article 32, no doubt wide, but having regard to the considerations which we have set out in the course of this judgment, we are satisfied that the impugned order cannot be brought within the scope of this court's jurisdiction to issue a writ of certiorari under 32 to hold otherwise would be repugnant to the well-recognized limitations within which the jurisdiction to issue writs of certiorari can be exercised inconsistent with the uniform trend of these decisions in relation to this point. This is the final adjudication. Then, of course, 226 is again discussed.
Anyway, we feel the injustice is cost him. Therefore, let us see, we'll keep that point for consideration, deeper examination. But the points raised in this petition merit deeper examination. First, a learned single judge of this court learned senior advocate appearing for the petitioner complaints, has unjustifiably terminated the wakalat stroke power of the petitioner who again enjoys a great reputation. First, right to practice avocation, obviously being a fundamental right, apart from being a legal right guaranteed under the Advocates Act 1961,
please,
1961, while curtailing that right, one has to be circumspect, to say the least. It is more so when it comes to the members of the bar who are an integral part of the judicial institution. First, next paragraph. In the above circumstances, we request issue notice. First, we request learned AGA to accept notice for respondents 2 and 3. High Court we also request learned senior panel counsel Srimati Vidyulata to accept notice for the first respondent. In the first sentence, the second sentence. Interim order ಏನಂತ ಕೇಳಿ.
Stay of the orders impugned, my lords, before lordships.
But Mr. Balu, don't appear in those matters. The petitioner, Mr. Balakrishnan, who is present in the court hall, graciously submits that he would not appear as a counsel in the subject matters. We appreciate this. Well, interim order as prayed for. It should not happen to you. Yes, it should not happen to you. He's remember we have seen him. He's a very good person.
The most astute and from the grassroots levels till the Supreme Court, we find him everywhere.
Venkatesh, these are all my best. Really, I have great respect for them.
Yes.
Our Venkatesh also, he was a AAP, SP, additional SPP.
Yes.
Together we used to appear in some matters. Such gentle people. It should not happen to you. Should not happen to you. Don't feel bad. Let us see. When R4. R4 ಗೆ ಬೇಕಾ notice?
Can be dispensed.
Notice to ಬೇಡ ಕಳಿಸ್ಬಿಡಿ. ಅವ್ರಿಗೆ ಹೋಗ್ಲಿ ಅವ್ರು ಏನ್ ಹೇಳೋದಿದ್ರೆ ಹೇಳ್ಕೊಳ್ಳಿ. Issue emergent ಅಲ್ಲೇ notice to respond number 4 also. Yes. Issue of maintainability merits deeper consideration and therefore kept open.
Please.
ಯಾವಾಗ ತಗೋಬೇಕು? When we want to take up this matter. ನೀವಾದ್ರೂ ಹೇಳೋದು ಬೇಡವಾ ಜಡ್ಜಸ್ಸಿಗೆ?
ಅಲ್ಲ
ಏನೋ ಒಂದು ಸಿಕ್ನಾಗ ಮಾಡಿರ್ತಾರೆ. ಆಮೇಲೆ ಹೋಗ್ಕೊಂಡು ಮಧ್ಯಾಹ್ನ ಊಟ ಎಲ್ಲ ಆದ್ಮೇಲೆ ಮತ್ ಸ್ವಲ್ಪ ಕಾಮ್ ಡೌನ್ ಆಗಿರ್ತೇವೆ ನಾವು. ಅವಾಗ ಹೋಗಿ ಹಿಂಗೆಲ್ಲ ಮಾಡಬಾರ್ದು, ಆ ರೀತಿ ಅಲ್ಲ ಅಂತ ಅನ್ಕೊಂಡು ಅಂತ ಹೇಳ್ಬೇಕು. ನಮ್ ತಪ್ಪಿದ್ದಾಗ ಏನೋ ಒಂದು ಮಿಸ್ಕಮ್ಯುನಿಕೇಶನ್ ಆಗ್ತದೆ ಅದರಲ್ಲಿ, ಅವಾಗ ನಾವು ಹೇಳ್ಬೇಕು ಅವ್ರಿಗೆ. We will not mention the name of a senior advocate. He came and openly said in the open court, ನಮಗೆ ನಮ್ಮನ್ನ ನೀವು ರೆಸ್ಪೆಕ್ಟ್ಫುಲಿ ನಡ್ಸ್ಕೊಳ್ತಾ ಇಲ್ಲ. ಒಂದು ಎಕ್ಸಾಂಪಲ್ ಕೊಡಿ. ಅವ್ರು ಯಾವ್ದೋ ಒಂದು ಎಕ್ಸಾಂಪಲ್ ಕೊಡಿ. ಆಮೇಲೆ ನೀವು ಹಿಂಗ್ ಅಂದ್ಬಿಟ್ರಿ ಅವತ್ತು ಅಂತ. ಇಲ್ಲ, ನಾವು ನಿಮ್ಗೆ ಅಂದಿಲ್ಲ ಅಂತ. I touch my heart and say, we have not said it to you. We said it to some other counsel ಅನ್ಕೊಂಡು. And he graciously, and we told him, you can't leave the court till you smile here. He smiled and went. Yes.
The camaraderie between the bar and the bench is what ensures that there is an orderly conduct of the court proceedings.
Respectfully, ನಾವು ಇಬ್ರು ರೆಸ್ಪೆಕ್ಟ್ಫುಲಿ ಇರಬೇಕು.
Should be.
ನಾವು ಜಡ್ಜಸ್ ಬಿಗಿ ಇರಬೇಕು ಅರ್ಥ.
Correct.
ಅದೇನು ಬಿಗುಮಾನದಲ್ಲೇ ಇರಬೇಕು ಅಂತಲ್ಲ. ಸತತವಾಗಿ ನಾವು ನಗಬೇಕು. ನಾವು ಅಂತ ಕೇಸ್ ಬಂದಾಗ ನಮ್ಮ ಕಣ್ಣು ಹಸಿ ಆಗ್ಬೇಕು, ಹೃದಯ ಹಸಿ ಆಗ್ಬೇಕು. ಹ್ಯೂಮನ್ ಬೀಯಿಂಗ್ಸ್ ನಾವು ಏನ್ ಕಾರ್ಡಜೋ ಬರೆದಿದ್ದು ಜುಡಿಷಿಯಲ್ ಪ್ರೊಸೆಸ್ ನಲ್ಲಿ, ಅಲ್ಲಿ ಹೊರಗಡೆ ಆಗೋದು ಎಲ್ಲದನ್ನು ಯಾವುದಕ್ಕೂ ಇಮ್ಯೂನ್ ಆಗಿರಕ್ ಸಾಧ್ಯ ಇದೆಯಾ? ನಮ್
ನೋ ವೇಸ್,
ಇಂಪಾಸಿಬಲ್. ದೇ ಆರ್ ಹ್ಯೂಮನ್ ಬೀಯಿಂಗ್ಸ್. ಒಂದು ಎಷ್ಟು ಬ್ಯೂಟಿಫುಲ್ ಇದೆ ನಮ್ಮ GS ಶಿವರುದ್ರಪ್ಪನವರ ಒಂದು ಸ್ಟ್ಯಾಂಜಾ. ಹತ್ತಿರವಿದ್ದು ದೂರ ನಿಲುವೆವು ನಮ್ಮ ಅಹಂನ ಕೋಟೆಯೊಳಗೆ, ಎಷ್ಟು ಕಷ್ಟವೋ ಜೀವನ ಎಂಬುದು 4 ದಿನದ ಹೊಂದಿಕೆ ಎಂಬುದು 4 ದಿನದ ಬಾಳೊಳಗೆ. ಅಂದ್ಕೊಂಡು ಹೋಗ್ಬೇಕು. ಬೇರೆ ಏನೋ ಒಂದು ನೀವು ಒಂದು ಹೇಳಿದ್ರೆ ನಾವೊಂದು ಏನಾಯ್ತು ಅದರಿಂದ?
Nothing happens. Nothing falls out. So grateful for your lordship.
Yeah, ನಮ್ಮ ಡ್ಯೂಟಿ ಅದು. Our duty to do. It's not that we are doing some charitable work.
Yes.
When a lawyer comes and says it has happened like this, we take so many cases of litigants. Why not lawyer?
Yes.
That to person like Balu.
Yes.
That's what sport ಇದೆ. ಹಿಂಗೆಲ್ಲ ಆಗ್ಬಿಟ್ರೆ ನಾವು ಈ ರೀತಿ ಆಗ್ಬಿಟ್ರೆ ಹಿಂಗೆ ನಾವು ನಾಳೆ ಕೆಲಸ ಮಾಡೋದು.
Lords, I just wanted just one last sentence. Lords, Mr. Balan had absolutely no difficulty when the learned judge won't appear in this matter. So no difficulty. Lords, as a matter of fact, in one of the matters, he filed even the memo of retirement because the learned judge said. But the pain was, he is appearing in 7 other matters for which the roster, which is some other bench. Lords, without the administrative orders, all the 7 matters because after I filed the memo of retirement, these matters are brought before him. In that, he disables. So that is something which.
No, it should not happen.
That's where.
That's not appropriate.
So I filed memo of retirement. I have acceded to it. I have filed a memo of retirement.
ಈ ಕೆಲವು ಮ್ಯಾಟರ್ಸ್ ನಲ್ಲಿ ನಾವೇ ಹೇಳ್ತೇವೆ, ಇಲ್ಲ ಇದರಲ್ಲಿ ಅಪಿಯರ್ ಆಗುವ. I told you in one matter.
Yes.
I remember.
Your Lordships.
5-6 years ago. Ravi, don't appear in this matter.
Yes, please.
He just smiled and went away. Maybe he has given back that money to him. We don't know.
Sometimes it is so happen. When I was in Udupi, took it for the plaintiff called upon the defendant also to enter the witness box. I requested him to retire from the case itself. He is one colleague.
Yes.
They are making allegations against about that compromise.
Yes.
Summoning the defendant advocate to
Enter the box.
That's true.
It's not proper.
Should not.
Immediately retire.
Another lady advocate you had appeared for.
Yes, my lords.
Where the bank had removed her
Yes.
everything from office.
Yes.
In the afternoon, he came and said, the lady advocate, she was crying behind Ravi Shankar. Then we told the bank, and bank lawyer also said,
Yes.
no, it should not. We'll restore her. Immediately we restored her. That lady.
Your lords
Lions
had shown
protection
indulgence my lords. We moved at 1:30, your lordships took out the matter at 2:30 and had.
That lady was
directed-
right.
Yes,
And all her clothes were inside that.
yes,
Well, it was her house come office.
yes, house come office.
House come office. I remember that.
Yes, my lords.
It should not happen, all those things.
True.
Yes.
So grateful.
All.
Great.
ಇಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಬರ್ಬಿಟ್ರಾ? ಅದ್ರೂ ಸೋಮವಾರ ಅಂತ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತಂದ್ರೆ ಬರುತ್ತಾ ಮೇಡಮ್? ಅಲ್ಲ ಮೇಡಮ್, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಬರೆದ್ರೆ ಬರುತ್ತಾ? ಸೀನಿಯರ್ ಇರೋರು ಇದಾರಾ ನೋಡಿ?
Being demoted. ಎಲ್ಲ ನಡ್ಸ್ಕೊಂಡ್
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ರೈಸ್ ಮಾಡ್ಬೇಕಲ್ಲ. Excise inspector, C11, CL-07 license. ನೀವು ಕಷ್ಟಪಡಿಲ್ಲ ಮಿಸ್ ರಿಕ್ವೈರ್ಡ್. ಈ ತಿಂಗಳು ದಯವಿಟ್ಟು ಅವ್ರು ಯಾರು ಮಾಡಬೇಡಿ. ರೆಸಲ್ಯೂಷನ್ ಪಾಸ್ ಮಾಡಿದ್ರೆ ಮೊನ್ನೆ ರೆಸಲ್ಯೂಷನ್ ಪಾಸ್
Krishna, in this matter, my lord.
Yes,
There are
Mr.
some
Ray.
office objections in this.
Yeah, no.
This, an order which is challenged is the issuance of notice by the National Company Law, National Consumer Redressal Commission,
Hmm.
wherein another order of arrest was challenged before the NCDRC. Before the original proceedings before the Karnataka State Consumer Redressal Commission, the matter was set down for filing of objections by the petitioner, my lord. At that stage, on that very day, without any reasons, the state forum has issued arrest warrant.
Without any reason.
No reasons have been attached. Your lordship may kindly say.
The members of the commission are not drawn from kindergarten. They
Yes,
are
my lord.
retired judges. Show that.
That is that, if your lordship may kindly see, at internal page number 23 and 24, that is the order, handwritten order. 24 is the handwritten order. 7/3/2025. Both councils present issue arrest warrant to the JDR through Commissioner of Police, Bangalore, returnable by 6/5/2025.
When the order was passed in the consumer forum order was made, what was that order?
As far as the consumer forum order was passed on 18/1/2024, it was an ex parte proceeding. The reason it was ex
What is
parte.
that?
The order is directing me to pay a compensation because of rupees 15 lakhs.
Yes.
Along with 25,000 towards litigation cost and interest of 9% as interest on the amount which is levied. The case is that some amounts were paid as advance sale consideration for securing an apartment. It is a residential premises which was promised to be constructed. Unfortunately, when these proceedings were filed before the original court, that is the case, Karnataka State Consumer Redressal Commission,
Yeah.
the company that is the 100% owned subsidiary of this company was under liquidation process. And we were completely dislodged. The activities were all totally dislodged.
How much money will deposit in the registry?
5 lakhs, my lord, because we are completely in a situation, actually, to be fair.
50% of the amount deposit ಮಾಡಿದ್ರೆ stay ಮಾಡ್ತೀವಿ ಇಲ್ಲ notice ತಗೊಳ್ಳಿ. Will you deposit it?
I'll deposit, but some time may be given.
Very well. Okay. Petitioner to deposit, issue emergent notice, interim order,
Sought for stay of the order passed by the Karnataka State Consumer Redressal.
ಅದನ್ನೇ ಸ್ಟೇ ಮಾಡಬೇಕು. ಅರೆಸ್ಟ್ ಅಂಡ್ ಡಿಟೆನ್ಷನ್ ಸ್ಟೇ ಮಾಡೋಣ.
Yes.
ಅದು ನಡೀలేదు.
Yes.
ನೋಡಮ್ಮ. Issue emergent notice, stay of arrest and detention pursuant to warrant dated
7/3/2025, my lord.
7/3/2025. First, however, execution proceedings in EA number 55/2024 shall proceed in usual way. First, next paragraph. This relief is granted subject to petitioner depositing in the registry of the State Consumer Redressal Commission 50% of the amount payable under award.
Award is at 18/1/2024 award in CC number 233 of 22, my lord.
ನಿಧಾನವಾಗಿ ಹೇಳ್ಬೇಕು, ಇಲ್ಲಿ ಬರ್ಕೋಬೇಕು.
Yeah, CC number 233
Award.
of 2022.
Award dated
18/1/2024, my lord.
entered in CC number
233 of 2022.
as under. 50% of the amount directed within 1 week and the remaining 50% within next 1 week. Failing which, not only the interim order stands rescinded, but petition runs risk of dismissal on that ground per se. ಕೆಳಗಡೆ ಮಾಡ್ಕೋ. We make it clear that 50% what is required to be deposited under this order is only 50% of the amount in 2 installments as indicated above.
4 weeks time, because it's some difficulty.
He is a builder. Very difficult. Office of, in the meanwhile,
I will
office
comply.
comply ಮಾಡಿ.
I'll
Please.
comply office of it.
ಅಲ್ಲಿ ನೋಡಿ ಯಾವ ರೀತಿ ಸ್ಟಿಚ್ ಮಾಡಿರಿ.
No, I will have it complied today.
This order shall not be released unless office objections are complied with.
Much
Yes. 50%.
The petitioner was working as a excise inspector at Majili checkpost, my lord. He had intercepted a lorry, my lord, driven by one driver, Kumar. My lord, he refused to, my lord, cooperate for inspection of the vehicle. And my lord, he started threatening and abusing the officials. Lord, at that stage, my lord, he also approached the front of the vehicle to secure a weapon. At that stage, my lord, they took him inside the police station. And my lord, after verifying that he is not carrying any weapon, my lord, he was let off, and my lord, the vehicle was also checked. But thereafter, he called up the Lorry Owners Association, and a complaint was registered alleging that he has been physically assaulted. But based on the said report, my lord, based on the said allegation, my lord, the SP recommended to, my lord, depute him outside the district. But he was immediately deputed outside the district along with one excise guard also, my lord, who was sent to Raichur and he was sent to Hassan. At that stage, my lord, when he was working at Hassan, he is being placed under suspension without noticing, my lord, that he is working outside the mischief area. Merely on the, my lord, recommendation made by the, in fact, my lord, the SP first initially recommended for transferring him outside the district. Thereafter, my lord, once again, he is being placed under suspension. Now, that was challenged before the tribunal on the ground that he is working outside the mischief area and he has also initiated criminal proceedings against the complainant. But therefore, question of placing him under suspension doesn't arise. The tribunal initially granted an interim order. But similar application filed by the excise guard in Belgaum, my lord, came to be allowed, my lord, on the ground that he is
outside area ಇದಾರೆ ಈಗ.
ಸ್ವಾಮಿ ಇವ್ರ ಮೇಲೆ ಚಾರ್ಜಸ್ ಇರೋದು ಓದ್ತೀನಿ ಸ್ವಾಮಿ.
ಪೇಜ್
69 ಸ್ವಾಮಿ. ಮೇಲೆ ವಿವರಿಸಿದ ಎಲ್ಲ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸದರಿ ಪ್ರಕರಣದ ಆರೋಪಿ ಒಂದರಾದ ಸದಾಶಿವ ಪೂರ್ತಿ ಅಬಕಾರಿ ಅಧಿಕಾರಿಗಳು, ಹೇಮಚಂದ್ರ ಅಬಕಾರಿ ಇಬ್ಬರು, ಒಬ್ಬ ಜವಾಬ್ದಾರಿಯುತ ಕಾರ್ಯನಿರ್ವಾಹಕ ಅಧಿಕಾರಿ ನೌಕರರಾಗಿ ಗಂಭೀರ ಸ್ವರೂಪದ ಕರ್ತವ್ಯ ಲೋಪ ಎಸಗುವುದು ಮೇಲ್ನೋಟಕ್ಕೆ ಕಂಡುಬರುತ್ತದೆ. ಅಲ್ಲದೆ ಅಬಕಾರಿ ನಿರೀಕ್ಷಕರಾದ ಸೋಣಸು ಇವರು ಕರ್ತವ್ಯದ ವೇಳೆಯಲ್ಲಿ ಸಮವಸ್ತ್ರ ಧರಿಸದೆ ಸಮವಸ್ತ್ರ ಸಂಹಿತೆ ಮಾರ್ಗಸೂಚಿ ಸಂಖ್ಯೆ 11 ಉಲ್ಲಂಘಿಸಿರುವುದು ಕಂಡುಬರುತ್ತದೆ. ಅಬಕಾರಿ ನಿರೀಕ್ಷಕರು ಕಾರವಾರ ಉಪಯೋಗ ಖುದ್ದು ಘಟನಾ ಸ್ಥಳಕ್ಕೆ ತೆರಳಿ
ಸಿಸಿಟಿವಿ ಕೊಡಿ.
ಹೌದು
ಸಿಸಿಟಿವಿ ಕೊಡಿ,
ತರಿಸ್ತೀನಿ ಸರ್.
ಮ್ಯಾಟರ್ ನಲ್ಲಿ ಹಾಗೆ
ಮಾಡಿದ್ದೀನಿ ತರಿಸ್ತೀನಿ.
Lordship, kindly come to page 118, my lord, which I have filed a complaint, private complaint.
ಕರೆಕ್ಟ್. ಇಲ್ಲಿ ಸಿಸಿಟಿವಿ ನೋಡ್ರಿ ಎಲ್ಲ ಗೊತ್ತ. ಅದು ನೋಡೋಣ.
ತರಿಸ್ತೀವಿ.
Show emergent notice. Cabinet AG is requested to accept notice for the respondents. The ಯಾವ ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೊಡ್ಬೇಕಿದ್ನ
ಇದು
learned AGA is instructed
to
secure CCTV records mentioned in para 3 of either suspension order, no?
ಹೌದು ಸ್ವಾಮಿ,
Suspension order dated 21/10/2024.
Superintendent of respondent number 4 in the
Monday.
ತರಿಸ್ಕೊಡ್ತೀನಿ. Monday.
Call this matter on Monday.
Monday is a holiday.
Tuesday.
Let there be an interim order of stay.
No.
Please.
Penalty order is challenged. Penalty order is challenged. Report was submitted for grant, my lord. It's a hill and rocked land, my lord. They have submitted a report saying that it was cultivated anta.
Hilly area.
ಹೌದು ಸ್ವಾಮಿ. Page number 97 charge.
ಮತ್ತೆ ಅವ್ರು ಇಲ್ಲಲ್ಲ. ಪಾಸ್ವರ್ಡ್ ಮಾಡಿ ನೋಡ್ ಬಂದ್ರೆ ಬರ್ಬೋದು, ಗೊತ್ತಾಗಲ್ಲ. ಪಾಸ್ವರ್ಡ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ, ಬೇರೆ ಬೆಂಚ್ ಇದೆ. Call next week to enable counsel for the petitioner to come and argue.
Pension fixation, my lord, to the retired ARSI. He retired in March, my lord. 52,650 he was drawing. And they have fixed 50,150.
ಟ್ರೈಬ್ಯುನಲ್ ಏನಂತ ಹೇಳಿ?
Tribunal said, my lord, he was given the stagnation increment. And promotion is not counted. Meanwhile, he was 15, he was promoted, and 18 also he was promoted. And last pay draw.
Emergent notice.
But may I just point out, my lord, annexure A6 is the refixation of his last pay drawn, based on which his pension is fixed. A6, my lord, at page 34. 34. ಇದರಲ್ಲಿ ಏನ್ ತಪ್ಪಾಗಿದೆ ಅನ್ನೋದನ್ನ ಪಾಯಿಂಟ್ ಔಟ್ ಮಾಡಿದ್ದಾರೆ ಅಕೌಂಟೆಂಟ್ ಜನರಲ್ ಆಫೀಸ್ ಅವರು, which are in capitals at the bottom, my lord. Pay as on 1/4/1996 shall be fixed at 1370 and not at rupees 1400 on promotion, as the ASI official is in stagnation on 31/12/2016.
Hence pay shall
be at rupees 26,000 and the next date of increment shall be on 1/12/2017 and not on 1/4/2017. Hence LPD worked out at the rupees 50,150. This may be reviewed and reckoned at your end. But based on this, they have refixed his last pay drawn. And based on this, 50% is the pension.
Increment ಯಾವ ಡೇಟಿಗೆ ಅಕ್ರೂ ಆಗ್ತದೆ? Why 1/12/2017?
My lord, he was stagnated. Thereafter, he got promotion in 1/12/2017. But this order itself is not challenged, my lord. The prayer is only to give a mandamus to fix his last pension based on his last pay drawn. There is no prayer to quash this annexure A6 first.
ಅದಕ್ಕೆ ಕ್ವಾಶ್ಮೆಂಟ್ ಕೇಳಲಿಕ್ಕಿಲ್ಲ, ಬಟ್ ಏನೋ ಅವ್ರ ಪ್ರೇಯರ್ ಅರ್ಥ ಆಗಿದೆ ನಿಮ್ಗೆ, ಅದೇನೋ ಆ ರೀತಿ ಕೇಳೋ ಅಗತ್ಯ ಬೀಳಲ್ಲ. It's in the nature of the discussion on Article 32 in the Constituent Assembly debates. We are not constrained by the shackles of English law of writs. These are the words from the Constituent Assembly debates. Therefore, Apex Court granted relief in a case where prayer column was blank. ಏನಂತಾರೆ, ನಮ್ಮ ಲಾಸ್ಟ್ ಪೇ ಡ್ರಾನ್ ಏನಿದೆ ಅದರ 50% ಕೊಡಬೇಕು, ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಅದನ್ನೇ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರೆ that would have been great. But anyway, ಅವ್ರೇನು
Page number 25, my lord. 52,000.
ನೋಡ್ಕೊಂಡು ಹೇಳ್ತೀವಿ. Cabinet AG is requested to accept notice.
Year end ಗೆ ಆಗ್ಬೇಕು
2 days. He was appointed.
Recently, government has issued circular that increment has to accrue from the commencement of the year ಅಂತ ಏನೋ ಮಾಡೋದಂಗಿದೆ.
ಹೌದು ಸ್ವಾಮಿ.
ಅದು ಯಾವ ಡೇಟ್ ಇಂದ ಇದೆ?
Earlier it used to be on the
1/4 ಇತ್ತು.
ಹೌದೌದು. Now it is 2 dates, my lord. Those who are appointed in this one, second half of the year.
ಅವರಿಗೆ 1/12 ಆಗ್ತದಾ?
First half of the year 1/7.
ಇಲ್ಲ. It's not so.
ನೋಡ್ಕೊಂಡು ಹೇಳಿ, ಅಷ್ಟೇ ಪಾಯಿಂಟ್. 2 weeks ಆದ್ಮೇಲೆ ಕಳ್ಕೊಳ್ಬಾರ್ದು.
Similar matter at page serial number 14.
ಸ್ವಲ್ಪ ವ್ಯತ್ಯಾಸ ಇದೆ ಅದು, ಬಟ್ ಸ್ವಲ್ಪ ವ್ಯತ್ಯಾಸ ಇದೆ. ಓಕೆ, ಪೇ ಫಿಕ್ಸೇಷನ್ ಅಲ್ಲಿ.
ಬಟ್ ಇದು ಅಂತದೇನಾ?
ಅದೇ ಸ್ವಾಮಿ.
Annexure A3, my lord, refixation by Accountant General.
You appear for Accountant General also?
ಮಾಡ್ಬೋದು.
ಅಷ್ಟೇ ಪಾಯಿಂಟ್.
Connected ಬೇಡ, separate.
Call this matter when that matter is posted. Yes, separately.
And I may request lordship to direct from the date of initial appointment, let them give the pay fixation.
ನೋಡ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಂತ್ರಿ ಇದೆ ನಿಮ್ಗೆ.
ಸರ್
ನೋಡ. Yes. ಎ ಕುಲಕರ್ಣಿ. ಏನಿದು ಕುಲಕರ್ಣಿ ಅವರೇ?
ಇದು ಕವರ್ಡ್ ಮ್ಯಾಟರ್ ಇದೆ. ತಮ್ಮ ಜಜ್ಮೆಂಟ್ ಆದ್ಮೇಲೆ ಟ್ರಿಬ್ಯುನಲ್ ಮುಂದೆ ನಾನು ಕಂಟೆಂಪ್ಟ್ ಹೋದೆ ಫಾರ್ ನಾಟ್ ಕಂಪ್ಲೈಂಗ್ ವಿತ್ ದಿ ಆರ್ಡರ್ಸ್. And at that time, they filed one compliance report along with that one order copy they filed. And tribunal votes that order is in compliance, and that order is not in compliance is the claim by the petitioners in this writ petition. It is
ಏನಂತ ಆರ್ಡರ್ ಇತ್ತು ಮೊದ್ಲು?
pillars.
ಆರ್ಡರ್ ಕಂಪ್ಲೈ ಮಾಡುವಂತ ಆರ್ಡರ್ ಏನದು?
Those who came to be appointed, PU college lecturers came to be appointed after 1/8/2008. Those who came to be appointed prior to 1/8/2008, they were given some special allowance up to 2018 pay rules coming into force. They were not stopped. They were given that special allowance. As far as those who came to be appointed after 1/8/2008, in their case, they have not given. Tribunal and this court held that they are also entitled. What now the government comes and says in the CTA contempt petition is that it is only in reference of those whose notification was issued in the year 2007, but whose appointment came to take place after 1/8/2008. That special allowance. That is not the direction issued by the tribunal as conferred by this High Court in this case.
ಟ್ರೈಬ್ಯುನಲ್ ಆರ್ಡರ್ ಎಲ್ಲಿದೆ?
Tribunal's order is page 65. Operative portion is page 79.
On or after 1/8/2008?
Yes, my lords. It is not controlled order.
ಸೊ ರಿಕವರಿ ಆರ್ಡರ್ ಮಾಡಿದ್ರಾ?
ಅದನ್ನು ಸ್ಟೇ ಮಾಡಿದ್ದಾರೆ, ಅದನ್ನು ರಿಕವರಿನೂ ವಾಪಸ್ ಕೊಡಿ ಅಂತ ಬರೆದಿದ್ದಾರೆ. This honorable court confirmed that. Page 120, page next this thing.
Entitled to grant of special allowance from the date of their appointment until the clubbing of special allowance in terms of order dated 19/4/2018, though they have been appointed after 1/8/2008. Consequently, the recovery of special from the will not arise. ಇದು ಅಫರ್ಮ್ ಆಯ್ತೇನೋ?
This order is affirmed by this clerkship, by this court.
ಎಲ್ಲಿದೆ ಅದು?
ಅದು operative portion is page 146. Government came in writ petition.
Writ petition dismissed.
And before the content petition, they file the order, page 166. Page 167 is the operative portion.
So recovery could not have been made ಅಂತ.
Recovery
ಆಮೇಲೆ ಈಗಾಗಲೇ ಮಾಡಿದ್ದೇನು ವಾಪಸ್ ಕೊಡ್ಬೇಕು ಅಂತ.
ಮಾಡಿದ್ರೆ ಇಲ್ಲ ಅಂದ್ರೆ 1/8/2008 ನಂತರ ಅಪಾಯಿಂಟ್ ಆದವರು ಅಂಟಿಲ್ 2018 ಅವ್ರಿಗೆ ಯಾಕೆ ಕೊಟ್ಟಿದ್ರಿ ಇವ್ರಿಗೂ ಕೊಡಿ ಅಂತ ಬರ್ದಿದ್ದಾರೆ.
ಇವ್ರೇನ ಈಗೇನ ಕಂಟೆಂಪ್ಟ್ ಆಕ್ಟ್ ಡ್ರಾಪ್ ಆಯ್ತು?
ಅದರಲ್ಲಿ one order they filed there, government order, page 167.
167.
Operative portion.
67.
Therefore, the extension of the special allowance, your lordships are perusing that. Page 167.
Therefore, the extension.
The extension of the special allowance to the government PU college lecturers appointed after 1/8/2008 is restricted to those PU college lecturers who are coming within the GO dated 5/12/2023. Accordingly, the principles of concern.
1 second. ನಿಧಾನವಾಗಿ ಓದಬೇಕು, ಅವಸರ ಮಾಡಬಾರ್ದು. 5/12/2023. Accordingly, the principals of the concerned PU colleges are hereby direct to take action to grant special loans only to those. ಹಂಗೆಲ್ಲಿದೆ ಆರ್ಡರ್ಸ್ ನಲ್ಲಿ? KAT ಆರ್ಡರ್ ನಲ್ಲಿ ಮತ್ತು ಹೈಕೋರ್ಟ್ ಆರ್ಡರ್ ನಲ್ಲಿ, ಹೆಗಡೆ ಅವರ ಆರ್ಡರ್ ನಲ್ಲಿ ಆ ರೀತಿಯಲ್ಲಿದೆ.
I'll take notice, my lord, and
issue emergent notice. Learned AGA is requested to accept notice for respondents. ಆ ರೀತಿ ಇಲ್ಲ, ಅದು ಹೊಸದು ಕ್ರಿಯೇಷನ್ ನಿಮ್ದು. You could have taken it as a ground to resist his application or to allow your petition. You can't add all that.
ಅಲ್ಲ, ಒಂದು ಡೇಟ್ ಕೊಟ್ರೆ ಬರುತ್ತೆ, ಅದಿಲ್ಲ ಅಂತ.
Call after 2 weeks. 2 weeks ಆಯ್ತು ಒಂದು objection. Yes, doctor.
My lord, on a complaint filed by one.
We want to know why you do not write doctorate, doctor, so many people will put a doctor, professor, whether they are professor or not. These things we have been seeing. Why you do not put your doctorate in your wakalats?
I do, my lord, but the problem with the
Computer.
branch there, my lord,
Ah.
they borrow it from the Karnataka State Bar Council.
As it is, they will.
As it is
correct
there.
Okay.
Hence, my lord, it is full name as it is appearing in my sanad.
Yes, yes, Professor.
Yes.
What is the point here?
On a complaint made by one lady at page number 39, my lord, Annex A2, saying that, my lord, that she has given a complaint, but police are not registering FIR. And my lord, the complaint is made to the Lokayukta. And Lokayukta, my lord, entertains the complaint and gives a toll-free report saying that it is dereliction of duty. And my lord, disciplinary inquiry was conducted. And my lord, the government has, my lord, imposed a penalty of, my lord, withholding of 10% pension for 5 years. My lord, the complaint, my lord, is
To emergent notice. Learned AG is requested to accept notice for respondents 1 and 2.
Lokayukta.
Lokayukta, Arbatti.
Arbatti.
yes,
Arbatti for response number 3. Yen entry model in
entry model, my lord, at page number 106.
Hello.
That is the order of the, my lord, the government, my lord, imposing 10% penalty.
Stay of impugned order.
Annexure 12, Annexure A12,
Stay of the government order dated.
dated 5/8/2023.
Stay of punishment order dated 5/8/2023.
At Annexure A12,
Kadlishtel baralla. Yes. All.
at Annexure A12.
All. At annexure 812.
12.
812. Okay.
Grateful.
Yes.
This court
Ah.
granted interim order suspension.
Ah.
Page 41, my lord, in the IA.
What?
My lord made certain observation while staying suspension order. Observation is, my lord, this interim order shall not come in the way of government taking independent decision as to the petitioners being transferred to some other places in normative way.
Correct.
Lord, I have joined duty pursuant to this on 19/3. On the same day, my lord, kindly see annexure P. Lord, I am shifted to Kumta. To overreach the court order, my lord, this one.
Normative way ಅಂತ ಹೇಳಿದೆ ನಾವು. As per the rules ಅನ್ನೋ ಅರ್ಥದಲ್ಲಿ. ಅವ್ರದ್ದು ರಿಟೆನ್ಷನ್ ಪೀರಿಯಡ್ ಎಷ್ಟಿದೆ?
ಕೌನ್ಸಿಲಿಂಗ್ ಸ್ಟೇ ಇದೆ, ತಾವೇ ಸ್ಟೇ ಮಾಡಿದ್ದೀರಾ? ಇನ್ಸ್ಪೆಕ್ಟರ್ ದ ವೆರಿ ಪೆಟಿಷನರ್.
Age will come.
Age will come.
Age. Age, Rubin will come. I have it on Monday, Tuesday.
Tuesday. ಏನಾರ ಒಂದು ಆರ್ಡರ್ ಮಾಡಿಬಿಡೋದು ನಾವು ಆ ರೀತಿ ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ವಿ ಮೋಸ್ಟ್ಲಿ. ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡಿದ್ದಕ್ಕೆ ಮಾಡಿದ್ವಿ. ನಾರ್ಮೇಟಿವ್ ವೇ ಮಾಡ್ರಿ ಅಂತ ಹೇಳಿ ಅವಾಗ ನಾರ್ಮ್ಸ್ ಆಫ್ ಟ್ರಾನ್ಸ್ಫರ್ ಇವೆಲ್ಲ ಅಪ್ಲಿಕೇಬಲ್ ಆಗಿ ಅದನ್ನ ಮಾಡ್ಲಿಕ್ಕೆ ಕೊಟ್ಟು ಆಮೇಲೆ ಇದನ್ನ ಸ್ಟೇ ಮಾಡಿ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್
ಆ ಕೌನ್ಸಿಲಿಂಗು ಸ್ಟೇ ಆಗಿದೆ.
ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಇವರು ಅಲ್ಲಿ
ಏಜ್
yes
ಅಲ್ಲ ಇಫ್ ಯು ವಾಂಟ್ ಟು ಆರ್ಗ್ಯೂ ವಿಲ್ ಟೇಕ್ ಅಪ್ ಮ್ಯಾಟರ್
no age will come and address is that application of the copies ಕೂಡ
don't precipitate the matter till next date of hearing. Learned AG is requested to accept notice for the respondents. ಆಗಿದೆ. The impugned orders of transfer
let it be passed over my lord.
Shall not.
Let it be passed over my lord.
ಯಾಕಂದ್ರೆ ಮತ್ತೆ ಬೇರೆ ಬೆಂಚ್ ಇದೆ ಅದಕ್ಕೆ.
ಅಲ್ಲ I'll bring him.
I'll
bring him.
Yes. ಏನಾಗತ್ತೆ ಬ್ರದರ್? ಟ್ಯೂಸ್ಡೇ ಬನ್ರಿ. Not to precipitate the matter till next date of hearing, call on Tuesday.
Annexure P, my lord.
ನಿಮ್ದು ಅವ್ರದ್ದು ನಿಮ್ಮ annexure ಎಷ್ಟು?
Annexure P dated 24/3/2025.
ನೋಡಪ್ಪ.
ಅಲ್ಲ ಕಾಪಿನೂ ಕೊಟ್ಟಿಲ್ಲ, ನಮ್ಗೆ ಕಾಪಿ ಬಂದೇ ಇಲ್ಲ.
ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಾ?
ಕೊಟ್ಟಿದ್ದೀನಿ.
Copies.
ಬಂದೇ ಇಲ್ಲ ಸ್ವಾಮಿ ನಮ್ಗೆ.
ನಿಮ್ಗೆ ಕೊಡ್ಲಿದ್ರೆ ಅವ್ರಿಗೆ ನಿಮ್ಮ ಮೇಲೆ ಆಕ್ಷನ್ ತೊಳಿ, ನಿಮ್ ಕೆಳಗಿನವ್ರ ಮೇಲೆ ಎಷ್ಟು ಕೊಡ್ಬೇಕು ಕಾಪಿ ನಿಮ್ಗೆ? ಒಂದು ರೂಲ್ 4 ಕೆಳಗಡೆ ಒಂದು ಸೀಲ್ ಕೊಟ್ರೆ ಮುಗಿ. ಸೀಲ್ ಇದೆ ಇಲ್ರಿ, ಮತ್ತೇನ್ ಮಾಡ್ತೀವಿ? ಏನ್ ಅವ್ರು ತಗೊಂಡ್ ಕೊಡ್ಬೇಕಾ ನಿಮ್ಮತ್ತಿಗೆ? ನೀವು ಹೋಗಿ ಇಸ್ಕೊಂಬರ್ಬೇಕು ಅವ್ರ ಆಫೀಸಿಗೆ. ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ಸ್ ಅಂದ್ರೆ ಹಂಗೆ ಕೊಡೋದಿಲ್ಲ, ಆಫೀಸ್ನಲ್ಲಿ ಸೀಲ್ ಹಾಕ್ಸೋದು ಮುಗೀತು. ದಟ್ ಈಸ್ ದ ರಿಕ್ವೈರ್ಮೆಂಟ್ ಆಫ್ ರೂಲ್. ನೀನ್ ನಾಟ್ ಗಿವ್ 16.5 ನೋಡ್ಕೊಳ್ಳಿ.
PNG.
Not to precipitate the matter till next date of hearing, call on Tuesday.
ಅವ್ರ ಮೇಲೆ ಚಾರ್ಜಸ್ ಇರೋದ್ರಿಂದ ನಾವು ಅಲ್ಲೇ ಇಟ್ಕೊಳಕ್ ಆಗಲ್ಲ ಅಂತ.
ಯಾವ ಚಾರ್ಜಸ್ ಇದೆ ಅವ್ರ ಮೇಲೆ?
ಸಸ್ಪೆನ್ಷನ್ ಮಾಡಿದಾಗ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇದೆಲ್ಲ ಇದೆ.
ಕರೆಕ್ಟ್, ನಾವು ರೂಲ್ ಇಶ್ಯೂ ಮಾಡಿ ಸ್ಟೇ ಮಾಡಿದ್ವಿ ಬಿಕಾಸ್ ಆಫ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್.
ಎಸ್ ಮೈ ಲಾರ್ಡ್, ವಿ ಆರ್ ಅದೇ ಆ ಕಾರಣಕ್ಕೆ ತಾವು ತಮ್ಮ ಹತ್ರ ಪರ್ಮಿಷನ್ ಕೇಳಿದ್ವಿ, ಪರ್ಮಿಷನ್ ತಗೊಂಡಿದ್ವಿ.
ಕರೆಕ್ಟ್,
ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡ್ಲಿಕ್ಕೆ ಪರ್ಮಿಷನ್ ತಗೊಂಡಿದ್ವಿ. ಪರ್ಮಿಷನ್ ವಿ ಹ್ಯಾವ್ ಟ್ರಾನ್ಸ್ಫರ್ಡ್.
ನೋಡೋಣ. ಎಸ್
ಲಾರ್ಡ್, ಇನ್ ದಟ್ ಮೈ ಲಾರ್ಡ್ ಮೇ ಮೇಕ್ ಒನ್ ಸ್ಮಾಲ್ ಸಬ್ಮಿಷನ್.
ಹೇಳಿ.
ಅದ್ರಲ್ಲಿ ಏನಾಗತ್ತೆ ಅಂದ್ರೆ, ಈ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಅಂತ ಬಂದಾಗ ತಾವು ನನ್ಗೆ ಒಂದ್ಸರಿ ಇದು ಹೇಳಿದ್ರಿ, ನಿಮ್ಮ VAOಗಳು RIಗಳು ಕೆಲಸ ಮಾಡೋದಿಲ್ಲ, ರೈತರನ್ನೆಲ್ಲ ಇದ್ ಮಾಡ್ಕೊಂಡು ಹೋಗ್ಬೇಕಾಗತ್ತೆ, ಅವ್ರು ನಿಮ್ಮ ಆಫೀಸ್ ನಾವೇ ಅಫಿಷಿಯಲ್ಸ್ ಅಂತ ಇದ್ ಮಾಡ್ತಾರೆ ಅಂತ ತಾವು ನನಗೆ ವಾರ್ನ್ ಮಾಡಿದ್ರಿ. ನಾನು
ಪ್ರೀತಿಯಿಂದ ಹೇಳಿ
ಅಲ್ಲ ಸುಮ್ಮನೆ ಅದನ್ನ ಹೇಳಿದೀನಿ. ಅಲ್ಲ ಸುಮ್ಮನೆ ನಾವು ಅದನ್ನ ಅವ್ರಿಗೆ ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡೋವಾಗ ಹಿಂಗಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ ಬಿಟ್ರೆ ಅವ್ರು ಮಾಡೋದಿಲ್ಲ. ಇದ್ರಲ್ಲಿ ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ, ಸುಮ್ಮನೆ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಮಾಡಿದಾಗ ಈ ಆಸ್ತಿ ಮತ್ತೆ ಈ ಖಾತಾ ಮತ್ತೆ RTC ಇವೆಲ್ಲ ಕ್ಲಬ್ ಮಾಡಿರೋದ್ರಿಂದ ತಾವು ತಮ್ಮ ಕನ್ಸರ್ನ್ ಏನಿತ್ತು ಅದು ಫುಲ್ಫಿಲ್ ಆಗತ್ತೆ. ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಮಾಡಿದ ತಕ್ಷಣ ಇವರು ಇದರಲ್ಲಿ ನಮ್ಮ ಫಾರ್ಮೆಟ್ ಏನಿದೆ ಅದರಲ್ಲಿ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ರೆ ಈ ಆಸ್ತಿ ಅದೆರಡು ಕ್ಲಬ್ ಆಗಿರುತ್ತೆ ಆಧಾರ್ ಜೊತೆಗೆ. ಇಲ್ಲಿ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ ತಕ್ಷಣ ಸ್ಲಿಪ್ ಡೈರೆಕ್ಟ್ ಆಗಿ ಇದಕ್ಕೆ ಹೋಗುತ್ತೆ BBMPಗೆ. ಇಲ್ಲಾದ್ರೆ RTC ಆದ್ರೆ ಇದಕ್ಕೆ ಹೋಗುತ್ತೆ, ಯಾರಿಗೆ VAO ಹೋಗುತ್ತೆ, ವಿಲೇಜ್ ಅಕೌಂಟೆಂಟ್ಗೆ ಹೋಗುತ್ತೆ. ಈ ಖಾತೆ ಆದ್ರೆ PDOಗೆ ಹೋಗುತ್ತೆ. ಹೋಗಿದ ತಕ್ಷಣ 5 days ಟೈಮ್ ಇರುತ್ತೆ ಅವ್ರಿಗೆ. ಅದನ್ನ ನೋಡಿ ರಿಕ್ವಿಸಿಟ್ ಫೀಸ್ ಏನನ್ನ ಇದ್ರೆ ನೋಟಿಫಿಕೇಶನ್ ಯಾವ ಮೊಬೈಲ್ ನಂಬರ್ ಇಂದ ಬಂದಿರುತ್ತೆ ಅದಕ್ಕೆ SMS ಹೋಗುತ್ತೆ. ಅವ್ರಲ್ಲಿ ಕಟ್ಟಿದ ತಕ್ಷಣ ಇವ್ರ ಆಫೀಸ್ಗೆ ಹೋಗ್ಬೇಕಾಗಿಲ್ಲ, ಅಲ್ಲೇ ಖಾತೆ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗ್ಬಿಡುತ್ತೆ, ಆಟೋಮ್ಯಾಟಿಕ್ ಆಗಿ ಆಗ್ಬಿಡುತ್ತೆ. ಇವತ್ತಿನ ದಿನ BBMPಯಲ್ಲಿ ಅದೇ ನಡೀತಿದೆ. ಎಲ್ಲಾದ್ರಲ್ಲೂ ಖಾತೆ ಟ್ರಾನ್ಸ್ಫರ್ ತಾನೇ ಆಗ್ಬಿಡ್ತಿದೆ. ಇವ್ರೇನ್ ಮಾಡ್ತಾರೆ, ಅದನ್ನ ರಿಜಿಸ್ಟರ್ ಮಾಡುವಾಗ ಅದರ್ಸ್ಗಂತ ಹೋದಾಗ ಅದರ್ಸ್ ಅಂತ ಏನು ಇದು ಕೊಟ್ಟಿದ್ದಾರೆ ಅದರಲ್ಲಿ ಹೋಗಿ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ರೆ ಇದರಲ್ಲಿ ಯಾವುದು ಖಾತೆ ರಿಜಿಸ್ಟರ್ ಆಗಿರಲ್ಲ. ಈ ಆಸ್ತಿ ಅಂತ ಏನು ನಾವು ಪ್ರಿಸ್ಕ್ರೈಬ್ ಮಾಡಿದೀವಿ ಅದರಲ್ಲಿ ಹೋಗಿ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ರೆ ಮಾತ್ರ 5 ದಿವಸದಲ್ಲೇ ಅವ್ರಿಗೆ ಖಾತೆ ಬಂದ್ಬಿಡುತ್ತೆ. ಅವ್ರಿಗೆ ಯಾವ ಆಫೀಸು ಅಲಿಯೋಂಗಿಲ್ಲ. ಆಮೇಲೆ ಅನಾಥರೈಸ್ ಲೇಔಟ್ ಅನ್ನೋ ಪ್ರಶ್ನೆನೇ ಬರೋದಿಲ್ಲ ಇದರಲ್ಲಿ. ಯಾವ್ದ್ಯಾವ್ದು ರೆಗ್ಯುಲರೈಸ್ ಆಗಿರುತ್ತೆ, ಯಾವ್ದ್ಯಾವ್ದಕ್ಕೆ ಈ ಖಾತೆ ಇರುತ್ತೆ ಅವೆಲ್ಲ ಅವ್ರ ಹೆಸರಿಗೆ ಬಂದ್ಬಿಡುತ್ತೆ. ತಾವು ಕನ್ಸರ್ನ್ ತೋರಿಸಿದ ಪ್ರಕಾರ ಇವ್ರ ಆಫೀಸ್ಗೆ ಅಲಿಯೋ ಪ್ರಶ್ನೆನೇ ಬರೋದಿಲ್ಲ. ಈ ಖಾತೆ ಬಿಟ್ಟು ಬೇರೆ ಯಾವ್ದ್ರಲ್ಲಿ ಮಾಡಕ್ ಹೋಗ್ತಾರೆ ಇವರು. ಈಗ ನಾವು
ಸಮಸ್ಯೆ ಆಗತ್ತೆ,
ಬರೀ ಸಮಸ್ಯೆನೆ. ಅದೇನಾಗುತ್ತೆ, ಇಲ್ಲಿಗಲ್ ಲೇಔಟ್ಸ್ ಎಲ್ಲ ಕಡೆ ಫಾರ್ಮ್ ಆಗೋಗ್ಬಿಡುತ್ತೆ. ಯಾರೋ ಒಬ್ಬ ಬಿಲ್ಡರ್ಗೆ ಫೇವರ್ ಮಾಡ್ಲಿಕ್ಕೆ ಇವರು ಅದರ್ಸ್ ಅಲ್ಲಿ ಖಾತೆ ಇಲ್ಲದೆ ಇದ್ರು ಯಾವುದೋ ಒಂದು ಖಾತೆ ಕ್ರಿಯೇಟ್ ಮಾಡಿ ಅದನ್ನ ತಗೊಂಬಂದ್ ಹಾಕ್ತಾರೆ. ಅದು ನಮ್ ಲೆಕ್ಕಕ್ಕೂ ಬರಲ್ಲ, ಇವ್ರು ಟ್ಯಾಕ್ಸು ಕಟ್ಟಂಗಿಲ್ಲ. ಆಮೇಲೆ ಇದನ್ನ ಈ ಆಸ್ತಿ ಮಾಡಿ ಅದನ್ನ ರೆಗ್ಯುಲರೈಸ್ ಮಾಡಕ್ಕೂ ಬರೋಂಗಿಲ್ಲ. ನಮ್ಗೆ ಇಷ್ಟು ಸಮಸ್ಯೆ ಆಗ್ತದೆ ಇದರಿಂದ. ಇದ್ರಲ್ಲಿ ಏನಾಗ್ಬಿಡುತ್ತೆ,
ಮೇನ್ ಮ್ಯಾಟರ್ ಪೋಸ್ಟ್ ಮಾಡಿಸಿ,
ಆ ನಾರ್ಮಲ್
ಪೋಸ್ಟ್ ಮಾಡಿಸಿ
ಆಗ್ಬೋದು.
ಪ್ಲೀಸ್.
Yes,
Professor.
Petitioner before your lordship is the excise inspector.
Yes, your lordship, one submission, your lordship, the Lokayukta conduct inquiry and submitted report. On the basis of report, your lordship, Lokayukta, the disciplinary authority imposed penalty, your lordship. Lokayukta is the necessary party, has not been made a party since.
Lokayukta is not necessary.
Well, on the recommendation of Lokayukta, they have done.
Oh, yes.
Oh, yes, my lord.
Lokayukta party ಮಾಡಿ. I'll direct you to, so that you need not file.
KT ಕೂಡ ಮಾಡಿಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ ತಮ್ಮ ಮುಂದೆ ಮಾಡಲಿ. ಇಲ್ಲದೆ ನಾನು ಅಲ್ಲಿ ಮಾಡಿದ್ರೆ ಇಲ್ಲೂ ತಮ್ಮ ಮುಂದೆ
KT
ಮಾಡ್ಬೇಕಿತ್ತು ನೀವು.
ಮಾಡ್ಬೇಕಿತ್ತು.
Is a necessary party ಅಂತ hold ಮಾಡಿ.
They are not challenging the order of the
No.
Because I understand, because on the recommendation of that,
ಅದಕ್ಕೆ ಮಾಡ್ಬೇಕಾಗತ್ತೆ.
ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ. ಒಂದು ಸಬ್ಮಿಷನ್ ಏನಂದ್ರೆ, on the face of it, the whole thing is not maintainable because
ನಿಮ್ಮ ವಾಯ್ಸ್ ನೋಡ್ರಿ, ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಎಷ್ಟು ಚಂದ
because your lordship will kindly say License was granted on 23/10/2002. The complaint was given on 23/9/2010, Your Lordship. Section 8B ನಲ್ಲಿ ತಮಗೆ it is more than 5 years, that itself was not maintainable.
ಯಾವುದು? Complaint was?
Complaint is on 23/9/2010.
23/9/2010 complaint.
The excise license was given on 23/10/2002, my lord. That is the incident, license granting.
8 years ಮೊದಲು.
ಹೌದು. 5 years ಆದ್ಮೇಲೆ ತಾವು ಅದು ಆಗೋಂಗಿಲ್ಲ ಅಂತ ಅಲಿಗೇಷನ್. That is what section 8 says, Your Lordship.
Section 8 ordinarily.
ಅಲ್ಲ, ಆರ್ಡಿನರಿ ಅಂತೇನಿಲ್ಲ.
Compulsory.
Compulsory. I read, Your Lordship.
ಓದಿ. Invariably ಇದೆಯಾ?
Any complaint involving an allegation made after the expiry of 5 years from the date on which the action complaint against is alleged to have taken place.
ಅದ್ನ ಹೆಂಗ್ ಟ್ರೀಟ್ ಮಾಡಿದ್ದಾರೆ ಇವರು ಟ್ರೈಬ್ನಲ್?
Matters not subject to investigation, that is not considered by the tribunal.
Where have you taken up that contention in your application?
Yes. Yes, ತೆಗೆಯಪ್ಪ ಬೇಗ.
Which paragraph?
Yes, Your Lordship. Page 76, Your Lordship.
ಎಲ್ಲಿದೆ?
Clause E, my lord. It is submitted that the complaint of Srimati Suma be dated 23/9/2009 is hopelessly barred by limitation as per the provision of section 8(2)D of the Karnataka.
Did you file that objection to the Lokayukta? In your reply to the Lokayukta notice, where have you stated?
This is the contention I have taken before the KAT. Your Lordship.
No, that you should have taken up before the authority to whom that bar applies. You should have told him, see, Honorable Lokayukta, you cannot take up the matter because section 7, it comes in the way. Where is that contention taken up?
And complaint is against not me. It is against the excise commissioner.
But notice was issued to you.
Yeah, what happened, Your Lordship? The report was given against the commissioner. And the 12/3 report, the Lokayukta recommended that 6 officers are involved.
Whether
But
notice was issued, you were heard in the matter? You must be.
You must be, sir. Yes, Your Lordship.
Where have you taken up that contention? Because limitation is a mixed question of law and facts.
Facts.
Hanಗಾಗಿ where you initially, if you had taken up,
Yes.
then that's all. If you had not taken up, after thought ಮಾಡ್ಕೊಂಡು ಉಪೇಶ್ವರಿಗೆ ಬರಲ್ಲ.
Can I not make a submission, Your Lordship, which being a question of law which goes to the root of
No
the
question
matter?
of law and facts.
Allala, root of the matter. When I made a submission on this point, KAT should have considered it, Your Lordship.
All right, we'll see that. Now, KAT should have considered one thing. We'll consider it now. We are not in appeal.
Yes.
After all, we are a supervisory jurisdiction. Where did you say, idu very stale matter, Honorable Lokayukta cannot look into this? Where have you stated to him in your stand?
In the party being not a law, that question is not taken. And in another aspect, Your Lordship, has
That
to-
amounts to saying, for ignorance of law, he should be rewarded.
Sometimes, in fact, some other case where I have appeared before Lordship, that question, that proposition, that ignorance of law is no more excess. Sometimes it is, Your Lordship.
Provided law provides that. For example, section 72 of the Contract Act, which it says, money paid in ignorance of fact or law. To that extent, we agree. This is what
I am
Apex
make
Court said in
submission.
Mafat law. Your submission is considered by 5 judges of the Supreme Court in Mafat law, 1997 Supreme Court, where
And
ignorance of law ordinarily is no excuse. Unless law itself recognizes as a defense.
And
Section 72.
In fact,
71,
license is not given to by me. It is the deputy commissioner who has given the license. No inquiry against the deputy commissioner.
License was given by Deputy Commissioner.
Yes, madam. 103 page, Your Lordship.
Where is your reply? First time you have given to the Lokayukta. Where is that contention you have taken up?
158 ನಲ್ಲಿ
158. ಇದು ಆರ್ಟಿಕಲ್ಸ್ ಆಫ್ ಚಾರ್ಜ್ ಆಯ್ತು.
152.
ನಿಮ್ ರಿಪ್ಲೈ ಎಲ್ಲಿದೆ?
ನೋಟಿಸ್. First time, I think no explanation is given.
Thing is given. All right. After second shock of notice, you give the representation, come to page 217.
217, Your Lordship.
Where have you taken up that contention?
Page 221 ನಲ್ಲಿ that contention is taken, Your Lordship.
221.
3. It is submitted that the complaint of Srimati Suma dated 23/9/2010 is hopelessly barred by limitation as per the provisions of section 82D of the.
Now, this was after the inquiry was conducted.
Second so-called notice my reply.
That is after report came to you.
Yes, Your.
But at the earliest point of time, where did you take? The limitation, point relating to limitation should be taken at the earliest point of time. At least in one judgment which you have argued by before Justice A.B. Murgod, there is a reported judgment wherein you appeared for this and you canvassed this contention.
May I make a submission when the second so-called notice before the.
ಇವ್ರನ್ನ ಮಾಡಿ ಉಪಲೋಕಾಯುಕ್ತನ ಲೋಕಾಯುಕ್ತ ಯಾರು?
ಲೋಕಾಯುಕ್ತ.
Lokayukta. The
Nay.
petitioner is directed to.
My lord, if your lordship permits a tree.
ಆರ್ಭಟಿ. ವೆಂಕಟೇಶ್ವರ.
Page 158 ಅಲ್ಲಿ.
158 ಬನ್ನಿ, A14.
Said year till the year 2008 time, there is no complaint whatsoever filed either against the said Venkatesh or against any person to whom the files are passed. Passing and.
ಇಲ್ಲ. I have taken this. I am very grateful to your lordship.
What do you say? They have taken up that contention, though loosely. He is not a Harvard product.
ಖಂಡಿಸಿ ದಿ ಚಾರ್ಜ್ ಮೆಮೋ ಲೋಡ್ಶಿಪ್.
No, how? Where it goes to? Because after that particular lapse of the period, you could not have proceeded because he has taken up that contention. In a little loosely he has taken it. All right.
He has not taken.
Why tribunal has not considered? No, he has taken up that contention. Kindly come to 158.
ಲೋಕಾಯುಕ್ತ he has not.
Enquiries ಮುಂದನೆ ತಗೊಂಡ written reply ದಲ್ಲಿ, written statement ದಲ್ಲಿ. He has taken, though he is not a Harvard product, therefore we said. He has, by and large, he has said, ಇಷ್ಟು ವರ್ಷ ಆದ್ಮೇಲೆ ನೀವು ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ, ಆವಾಗ ಮಾಡಿದ್ದದು ಒಂದು. And he is not the authority who issued that. He is not the person who issued that.
He conducted spot inspection of lordship of the allegation on the basis of forged document, the
ಯಾರು ಇಶ್ಯೂ ಮಾಡಿದ್ರು?
commissioner,
ಮತ್ತೆ ಇವ್ರ ಮೇಲೆ ಯಾಕೆ?
is also involved in.
ಹೌ ಅದೇನು ಓವರ್ ಟ್ಯಾಕ್ಟ್ ಏನಿದೆ?
In fact, complaint is against the commission.
Forgery ಮಾಡಿ, witness signature forgery ಮಾಡಿ, document forgery ಮಾಡಿ ಇವರು ಇದು ಮಾಡಿದ್ದಾರೆ.
It is, the complaint is against the commissioner himself. ಅವರು
ಡಾಕ್ಯುಮೆಂಟ್ ಫೋರ್ಜ್ ಮಾಡಿದಾರ?
ಅದೆಲ್ಲ ನನ್ನ ಮೇಲೆ ಏನಿಲ್ಲ ಸ್ವಾಮಿ. There is nothing like that.
ನೀವಲ್ಲಿ ಅವಾಗ ಯಾವ ಡೇಟಿಗೆ ಬಂದ್ರಿ ಅಲ್ಲಿ?
ಏನ್
ಆ ಪೋಸ್ಟಿಗೆ ಯಾವ ಡೇಟಿಗೆ ಬಂದ್ರಿ?
In fact, I was there at that time. What happened was, when the license was applied, DC and myself and other superior officer went for an inspection, submitted a report. The commissioner did not accept for, asked for a second report. When the second report, I was not the member of that second report team.
In the first report, you recommended for the grant.
I did not recommend. It is the DC and other superior officer who inspected the spot. Along with me, they recommended it.
What is your designation?
I excise inspector.
Huh?
Excise
Excise
inspector.
Inspector, you also go along with them, your committee went there.
Yes, Your.
And you have signed the first report.
First report I have signed, it is rejected by the commissioner.
No,
License,
he rejected all right, but you recommended for the grant.
not I recommended, it is
Ah.
the team, as a team we went, it is the DC who recommended.
He's one
Anyway,
of the.
It's an institutional decision.
Yes,
Institutional decision.
Yes.
3-member committee will do that.
yes.
Where is that?
Your lordship before that, draw your lordship attention to page 50, your lordship.
50.
Yes, your lordship. It is the Joint Commissioner of Excise gives a reply to the Additional Registrar of Karnataka Lokayukta inquiry, your lordship. Page 50, your lordship. 8 or 11. I read two paras, my lord, para 8 and 11. 8, it may please noted that the recommendation made in my note through the District Deputy Commissioner was not accepted by the Excise Commissioner. The Excise Commission on 14/8/2002 rejected my note with the following observation. After examining the points in the note, it is found that though the arrangements would be made to provide for a liquor counter in the ground floor of the proposed building and also to run a top-roof restaurant in the first floor, and there are 22 single rooms in the building, it is not permissible to grant CL-7 in accordance with the rules. Further, the Excise Commissioner directed me to spot verification once again along with the District Deputy Commissioner and submit a clear report.
Then you did that.
Then I did not. Para 10, your lord.
Who is this I?
I is the
Joint Commissioner.
Joint Commissioner. my lord.
You are not that.
Not that. Para 10, I read, your lord. It is important to note that inspection of the spot on 5/9/2002 and verification of requirements in accordance with the Karnataka Excise License General Condition Rule 19, the District Deputy Commissioner made the following recommendation. There is an industrial workshop behind the hotel, subject to removal of the same and subject to providing a parking space for vehicle. It is recommended to issue the license. Our Kotira Swami. And para 11, I read, my lord. Another significant point to be noted is that certificate dated 8/7/2002 issued by the Secretary Bommasandra Grama Panchayat Secretariat Attibele Hobli Anekal Taluk before Bangalore City District stated to be found in the file of the Excise Department. It attached to the notice dated 7/3/2004. Referred above, it is certified.
Who issued that certificate mentioned in para 11?
Parallel certificate is Gram Panchayat, and Joint Commissioner says neither it was not in the files. It is significant, it is certified in the said certificate that as per 2002 census, the population of Bommasandra village and Bommasandra industrial area is more than 20,000. This certificate was neither produced by the excise inspector nor by me, but still the said certificate is stated to be in the file, and I have no idea as on the source of the certificate. This certificate could also be one of the grounds on the basis of which CL-7 to run a bar restaurant in the premises. And
What are the charges against you?
There's 152 loss.
This time 30
Pickapa. Loan for ಏನಿಂತ ನೀವು ಹಾಕಿದ್ದೀರ ಏನು ಹಾಕಿದ್ದೀರಲ್ಲ ನೋಡಿ ತಗೊಂಡು ನಿಂತು ಹ್ಞೂ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಆಗಿದೆ, ಏನ್ ಮಾಡಿದೀರಾ ನೋಡಿ? ಅದೇನಾದ್ರು ಹೋಗಿದ್ರೆ ಅವ್ನು ದೇವರಾಜ್ ಸರಿ ತಗೋದು. ಎಕ್ಸಿಕ್ಯೂಷನ್ ನಮ್ಮ ಕೊಟ್ಟಿದ್ದಾರೆ, ಈ ಕಂಟೆಂಟ್ ಆಗಿದೆ, ಏನ್ ಡೈರೆಕ್ಷನ್ಸ್ ಕೊಟ್ಟಿದೆ, ಏನ್ ಮಾಡಿದೀವಿ ನಾವು? ಹಾ ಸರ್, ನಮಸ್ಕಾರ. ಹೇಳಿ, ಯಾರಾದ್ರು ಗೊತ್ತಾಯ್ತಾ? ಹ್ಞೂ, ಆಯ್ತು. ಹಾಂ, ಇಲ್ಲ ಮೇಡಮ್ ಈಗ ಬಂದ್ರು. ಈಗೇನೋ PRS ಬರ್ತಾರೆ, ಇವರೇನೋ ಓಡಾಡ್ತಾ
We hope they are.
Settle the matters will settle as well directed. Not this maybe post. For settlement maybe posted on 4th minute.
ತಮ್ಮುಂದ
ಅಲ್ಲ,
ಇನ್ನೊಂದ
ಹೌದು.
ತೊಡ್ರಿ.
Settlement ಮಾಡಿ.
Okay. ಹಾ. Yes, Mr. Age.
Make things easier, your lordship.
But
We formed a team with three
Very-
ages because of wider ramification with my
Correct.
brother Vikram and all. These two booklets.
if all AGs are in our court, what should other courts do?
Wider ramification ಇದೆ ಮತ್ತೆ ಬಹಳ ಇದಿದೆ ಅಂತ ಹೇಳಿ.
But
This is pertaining to triple benefit and all the rules and the judgments you have complied. ಎರಡು ಸೆಟ್ಟಿ. Regard to this compilation, we need some time to submit it. ಮಾಡಿದೀವಿ ಈಗ. ಇದು ಎರಡು ಸೆಟ್ ಮಾಡಬೇಕು.
Gist of the matter. ಹೇಳಿ.
Yes, sir. Now, the you have been asked to demonstrate the basis of the
Pre-aid
yes,
period.
the service rendered before admitting into granting aid, whether it is admissible or not. The petitioners were before this honorable court with a contention that it is admissible, and if it is not admissible, it is discrimination among the same class. On that basis, I have submitted.
Mr. Ahmad Saab,
Yes.
kindly have a mic also. Yes.
Lordship may kindly peruse
Ah.
that index, that compilation what I have submitted. Now, today we are going to submit with respect to the history of the aided schools, how it is evolved.
Yeah.
What was the concept behind that? We were starting from the gazetteer, we made it, Your Lordship. It took, because officers also have got changed, secretaries and all. Because it all started in 1944.
1944, before advent of freedom.
Yes, Your Lordship. When our Maharaja was there, 1944, and Madras Education Act was there also. So we started with the gazetteer, working with my brother Kiran, and
Yes.
so now what we are going to submit is how it is evolved, why the grant in aid and aided institutions, that concept has been evolved. Later, after the constitution came into force, how the laws have been made and regulated. Then ultimately, at the ending up at the Education Act and the rules therein. So I'll put a brief background of this, Your Lordship, before getting into this. I'll start with Your Lordship so that with the judgments which have been rendered by this Honorable Court, where this Education Act and the earlier rules have been discussed, so that it will throw some light to understand the background.
Correct.
I'll start with this, Your Lordship. At page number 7 to 16, that is Writ Appeal 291 of 2007.
You
Yes, yes, Your Lordship. Because it is become so bulky.
Volumes on card.
For the soft copy.
291.
290.
Ivrde documents ella.
Judgments ಇದು. Judgment, nothing else. And also we will share with them also. ಎಲ್ಲ soft copies ಎಲ್ಲ ಕೊಡಿ. Writ Appeal 291 of 2007, which starts from page number 7, Your Lordship.
Correct. Sabhat Saibru, Pachapure Saibru.
Yes, yes, Your Lordship. My Lordship would bear with me. ನನಗೆ ಅಷ್ಟು ವೇಗವಾಗಿ ನಮ್ಮ ಕಿರಣ್ ಅಷ್ಟು ಮಾಡಕ್ ಬಿಟ್ರೆ I will go very slow, Your Lordship.
Whichever.
Yes. This appeal is filed by the respondent state in WP number so and so, being aggraved by the order dated 1/9/2006, wherein the learned single judge of this court has allowed the writ petition and directed the respondents in the writ petition appellant hearing to compute to compute the pensionary benefits of the respondent number 1 herein, the writ petitioner with reference to the period of service from 1/6/1995 to 31/3/1984.
This is the relevant period.
ಈಗ ಈ period, it was, as per the state submission, it was the non-grant period. Non-grant period. So it was not admitted. Period of service from 1/6/1995 to 31/3/1984, and to grant the benefit to the same with arrears thereof within a period of 12 weeks from the date of receipt of the order, if not earlier. Respondent number 1 herein filed writ petition so and so. He was working as a teacher in the 6th respondent institution from 1/6/1959. It was a recognized institution. It was a recognized institution. The appointment of the petitioner was approved from
Yes.
approved from 1/6/1965 by order dated 28/6/1984 as per Annexure A to the writ petition. However, while computing the pensionary benefits, the period rendered by the writ petitioner prior to admitting the sixth respondent to grant in aid by order dated 28/6/1984 was not reckoned, and wherefore the writ petitions was filed for a direction to include the said period also for the purpose of the computing the pensionary benefits and to pay the consequential arrears thereafter. The respondent state did not file any objection statement to the writ petition, though sufficient opportunity was given to enable government to file statement of objection. The learned single judge, after hearing the learned counsel appearing for the writ petitioner and the learned government advocate appearing for the respondent 1 to 5 held, though order admitting the sixth respondent to grant in code is 31/3/1984, benefit was given from 1/4/1984, and wherefore directed them that for the purpose of computing the pensionary benefit of the writ petitioner, the period of service which was not taken into account from 1/6/1965 to 31/3/1984 was also to be taken into account, and the writ petitioner was to be paid arrears of the pension on the said basis and granted 12 weeks time to do the needful, and accordingly allowed the writ petition by order dated 1/9/2006. That being aggraved by the order of the learned single judge dated 1/9/2006, the Karnataka state has preferred this appeal. Now I'll come to paragraph 5, Your Lordship. The learned government advocate vehemently argued that the period of service rendered by the writ petitioner period to 31/3/1984, the date on which the institution was admitted to grant in aid, could not be taken into account for computing the pensionary benefits of respondent number 1 as ordered by the learned single judge, and same is contrary to Rule 52 of the Karnataka State Aided Schools Employees Contributory Provident Fund Insurance Pension Rules 1963. That also I have given Lordship, and then I'll go to that.
Yes.
Which was in existence when the writ petitioner retired from service on 31/1/1993. Since the writ petitioner retired on attaining superannuation on 31/1/1993, in view of the Rule 52 of the above referred to as the rules, only period of service rendered after institution was recognized and admitted to grant in court would be taken into account, and wherefore the order passed by the learned single judge has to be set aside. Would you want to show Rule 52, Lordship, or would complete this?
Is it not discussed in this?
It is not discussed, Your Lordship.
Not discussed.
Not discussed, Your Lordship.
Oh.
I'll complete this, Your Lordship.
You are right. It's not discussed.
Not discussed, Your Lordship.
Let us see the rule, how rule is worded.
I have given it there. At page number 44.
Attention is how rule is worded.
Lordship,
Let us see the rule, how rule is worded.
rule provides, the rule quoted here is Rule 52 of the tribunal.
Page number?
It is not there, Your Lordship. We could not, it is a legible copy ಇರ್ಲಿಲ್ಲ, ಈಗ ಮಾಡ್ತಾ ಇದ್ದು, ಇದು ಹಳೆಯ ಡಾಕ್ಯುಮೆಂಟ್ ಇತ್ತು, ಒಂದು ಕಾಪಿ ಇದೆ ನನ್ನ ಹತ್ರ.
Which rule?
Rule 52, Your
Read,
Lordship.
read.
Your Lordship?
Read.
Read.
ಓದಿ. 1963 rules ತಾನೆ?
ಹೌದು. ನಾನು ಏನ್ ಮಾಡ್ತೀನಿ ಸರ್? I'll do one thing. 4 relevant judgments are there. I will.
No.
Correct.
Your whole case is founded on the premise of rule position. Let us see how rule is, because judgment does not accept referring to this. It does not discuss the rule at all.
Correct.
So let us see what the rule says. ಆ ರೂಲ್ ನಿಮ್ಮಲ್ಲಿ ಇದೆಯಲ್ಲ
ಅಲ್ಲ, ಇಲ್ಲಿ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಇದು ಒಂದೇ ಇತ್ತ
ಅದು ಒಂದು ಅದು ಸಿಕ್ಕಿ-
ಅಥವಾ ಓದಿಬಿಡಿ ಒಂದ್ಸರಿ ಓದಿಬಿಡಿ ಕೊಡಿ.
In computing the length of qualifying service, all previous service, whether temporary, officiating or permanent, either in one or more than state aided institutions, shall be taken into account. This is A.
So it contemplates service in aided institution.
Earlier service in another aided institution.
No, one or the other. The
One
words
or-
will- one or the other. Maybe he was working in X, it was aided institution. Then he joined B. Y, it is also aided
Yeah, then
institution.
it is
His
complete.
period spent in A will be tagged
B, C.
to the service rendered in B.
Yes.
Okay.
That
So
is
thumb rule is in that rule, which rule defines the qualifying service? What for it is, the definition is.
in the
Qualifying service definition.
ಅದು ಅದೇನಾಗಿದೆ ಒಟ್ಟು
ಹಾ.
ಒಟ್ಟು ನಾಲ್ಕು ರೂಲ್ ಇದೆ. ಒಂದೊಂದು ಕಡೆಗೆ ಒಂದೊಂದು ಹೇಳ್ತಾರೆ. ದಟ್ ಐ ವಿಲ್ ಡೆಮಾನ್ಸ್ಟ್ರೇಟ್ ಲೇಟರ್. ಒಂದೊಂದು ಅದನ್ನು ಕೂಡ ಬುಕ್ಲೆಟ್ ಮಾಡಿದೀವಿ. 1999 ಒಂದು ರೂಲ್ ಇದೆ. ಕಾಲೇಜಿಯೇಟ್ ಎಜುಕೇಶನ್ ಒಂದು 2001 ರೂಲ್ ಇದೆ. ಎಜುಕೇಶನಲ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ 2003 ಒಂದು ರೂಲ್ ಇದೆ.
ಈ ರೂಲ್ ಅನ್ನು ಯಾವ್ದ್ರ ಕೆಳಗೆ ಮಾಡಿದ್ರಿ? 63 ರೂಲ್ಸ್ ಅನ್ನ ಅಂಡರ್ ವಿಚ್ ಆಕ್ಟ್?
ಟ್ರಿಪಲ್ ಬೆನಿಫಿಟ್ ಸ್ಕೀಮ್.
ನೋ, ವಿಚ್ ಆಕ್ಟ್?
ಅಲ್ಲ, ಆಕ್ಟ್ ಇಲ್ಲ.
ರೂಲ್ಸ್ ಹೆಂಗ್ ಮಾಡ್ತೀರಿ?
ಅಲ್ಲ, ಇಲ್ಲಿ ಏನಾಗಿದೆ, ದಟ್ಸ್ ವಾಟ್ ಐ ಟೋಲ್ಡ್. ಆಕ್ಟ್ ಕೇಮ್ ಇನ್ ಟು ಫೋರ್ಸ್ 16/1995, ಎಜುಕೇಶನ್ ಆಕ್ಟ್.
83 act came into force in 1995.
95. Prior to that, all on the executive orders, all this.
Are you sure about that?
Yes, adana iga granting.
Ron, are they relatable to 309? Because 78 act has not yet come. Civil Services Act 1978 had not yet come.
Yes.
Is it relatable to 309? May not be, because employees working in aided institutions are not civil servants. 309 speaks of civil service.
Yes.
Under which act these rules are promulgated? ಹಂಗೆ ನೋಟ್ ಮಾಡಿಕೊಳ್ಳಿ. ಮಾಡ್ಕೊಳ್ಳಿ.
Grant in code and the triple benefit scheme. That's what our discussion. Prior to the act. Yes, it is here.
ರೂಲ್ಸ್ ನಲ್ಲಿ ಇಲ್ಲನು, we have promulgated this under the provisions of ಅಂತ ಹಿಂಗಿರುತ್ತಲ್ಲ ಬಿಗಿನಿಂಗ್ ನಲ್ಲಿ. ಹೆಬೆಂಡಮ್ ಕ್ಲಾಸ್ ಓದಿ.
This says, Lordship, introduction of contributory provident fund. At present, employees of the state aided schools run by, this came into force from 24/8/1963. GO ED S65 SCS 62 dated 24 August 1963.
Promulgated under which act?
Introduction of, this is by government order.
No, order, all right. Is it, since you are calling them as a?
No
rules?
act,
No act.
no act, executive order.
These are all executive
Yes.
instructions.
At present, I'll read this, Your Lordship. Yeah. At present, employees of the state aided schools run by local bodies or private managements are entitled only to the benefits of Mysore State Aided Schools Contributory Provident Fund. They are not entitled to any pension, nor they are required to insure their lives compulsory to provide the herewithal to sustain them in their old age or their family in the event of their untimely death. The question of improving the service conditions of such employees in this respect has been engaging the attention of the government for some time past. While introducing the budget estimates for 1962-63 in State Legislative Assembly on 22nd March 1962, an announcement was made on behalf of the government that it was proposed to extend a triple benefit provident fund cum insurance cum pension scheme to such teachers. This was followed by an announcement in March 1963 budget session that government has taken a decision to introduce a scheme with effect from 1/4/1963. This scheme as now sanctioned is appended to this order. It will come into force on 1st April 1963. The outlines of the scheme are briefly as under: teaching and non-teaching staff, other than menial servants, permanent as well as temporary, serving in state-aided schools, whether run by local bodies or by private managements, will not only be entitled to contributory provident fund benefits, but also to pension, except in cases of overage or certified ill health. They would also require to insure their lives in the Life Insurance Corporation of India to a minimum extent. The amount of policies to be taken varying with the status and age of employees. The subscription paid by the employees and the contribution made by the managements monthly will be half at their credit in contributory provident fund account, and the accumulations including government contributions and interest will be paid to them.
Got the point. What are the triple benefits?
Triple benefits are that, your lordship.
Pension is one.
Provident, contributory provident fund, insurance,
Fund,
pensions.
pension plus insurance.
Right. Then
Just whether there is a definition clause in these rules?
in the chapter 1, your lordship,
Huh.
these rules may be called the Mysore State Aided Schools Employees Contributory Provident Fund Insurance Pension Rules. They shall be, they shall be deemed to have come into force on 1st April 1963. These rules shall apply to employees of the state-aided schools of the following categories, whether run by local bodies or private managements. So, Ali,
So they apply to schools run by
state-aided schools of the following categories, whether run by local bodies or by private.
they should be aided institutions.
Yes.
To non-aided institutions, these rules will not apply.
Not up.
Whether there is definition of qualifying service?
Yes, that I'll come.
Where is that?
And I'll go ahead with the.
Yes.
One is pre-primary, nursery.
So this was an assurance made to the people through the house.
Correct.
When budget was presented. This was an assurance made from the house itself, not just government. The legislature.
As
ಸ್ವಲ್ಪ ನೋಡ್ಕೊ ಫೈನರ್ ಆಸ್ಪೆಕ್ಟ್ ಇದೆ ಅಲ್ಲಿ ಒಂದು ಆಸ್ಪೆಕ್ಟ್.
So that was pertaining to, as your lordship has said, aided institutions.
Aided institutions.
Aided institution. Not anything. Aided institution. Non-aided. Provided, the provision says, provided that they shall not apply to employees of the state-aided schools of Madras area to whom pensionary benefits have been extended in GOs also.
Madras area means which area?
Madras adu act ಕೆಳಗಡೆ ಮಾಡಿದ್ರು ಆ ಕಡೆದೊಂದು ಅದು we didn't get it, your lordship. Madras area Education Act 1920, that is the oldest act. ಅದ್ರ ಕೆಳಗೆ ಕೂಡ ಎಸ್ಟಾಬ್ಲಿಷ್ ಮಾಡಿದ್ರು. Now we are on collecting everything to complete.
ಇವ್ರದೆಲ್ಲ ಬರ್ತಾ ಇದೆ ಇದು ಮಡ್ರಾಸ್ ಏರಿಯಾದ
ಬರೋದಿಲ್ಲ.
ನಾನ್ ಮಡ್ರಾಸ್ ಏರಿಯಾ.
ಅದೊಂದು ಸ್ವಲ್ಪ ಕ್ಲಾರಿಫೈ ಮಾಡ್ಕೋಬೇಕು. Because at about about
other than the Mysore province area, Madras.
No, sometimes Chamranagar, that Kollegal falls into Madras area. So assert ಮಾಡ್ಕೋಬೇಕು. I'm not so sure. We are making effort on that. In the here today, your lordship, about 190 matters are there. 190 matters are clubbed together with this lead matter. So each petitioner across the state idare. And
ಅಲ್ಲ ಈಗ ಉದಾಹರಣೆಗೆ ಕೂರ್ಗ್ ಏರಿಯಾ ಈಸ್ ನಾಟ್ ಮಡ್ರಾಸ್ ಏರಿಯಾ.
correct. Absolutely.
But now we have some people from Coorg area also.
Correct.
Bellary is not Madras area.
Madras.
Or it was. It was. Bellary was a Madras area. Entire Hyderabad, Karnataka. No, Hyderabad, Karnataka was part of Nizam.
Nizam, Hyderabad.
Bellary was part of Madras. Udupi was part of Madras. Correct. That we had that case, na? University of Madras versus Shantabai. Whether university is a state under Article 12 or not. So that's why.
So that has to be ascertained, your lordship.
ಹೇಳ್ಕೋಬೇಕು.
ಅದನ್ನ individually case to case basis assert ಮಾಡ್ಕೊಂಡು we will lay the facts before this honorable court. That is one aspect.
Because why we are saying this is in that Chikavira Rajendra by Masti Venkatesh Iyengar, which earned him Jnanapita.
Jnanapita.
In that he has written and another book, the Swami Aparampara. These two books say that Coorg is not a part of Karnataka. It was not part of Karnataka. In that famous book, Chikavira Rajendra.
Jnanapita Prashasti.
Jnanapita Prashasti Vijeta. Yes.
And school boards of Bombay area, which are entitled to pensionary benefits from the pensionary fund constituted under Bombay Primary Education Rules 1949. Notwithstanding anything contained.
To them also it does not apply.
Does not apply.
Bombay. Bombay province ಅಂದ್ರೆ in 4 districtಗಳು.
ಇದು ಬರ್ತದೆ.
ಧಾರವಾಡ, Karwar, Dharwad, Belgaum, Bijapur. Now they are split into many other districts.
So
also.
the fund was created. Bombay Primary Education Rules were existence then, and the pension fund was constituted under that
act.
That rule. So this triple benefit scheme has been kept out of that. Notwithstanding anything contained in sub-rule 1, these rules shall apply to the employees specified in the provision to the said sub-rule if they exercise their option to be governed by these rules before 31st March 1969.
31/3/1969.
1969. So,
why? What is the significance of this date?
Later I will demonstrate before Lordship. That option was given to the employees. That they can opt for this also, and another scheme was also there. In between, your Lordship, with your Lordship leave, I had an occasion to argue the similar matter. This in the writ appeal, state writ appeal. If your Lordship permit, I will pass this judgment.
What was the point involved?
Yes.
What was the decision on that?
Now, the crux of the matter here is, your Lordship. Just I am visiting it now. This is two different set of employees. One is private aided employees and the government employees. Now, the whole.
Yes. They constitute two different classes.
Now, the judgments which have been rendered, which resulted in the enactment, which is also later quashed now, on which we are before your Lordship, says that it is, they form the single class. It is between them we have created the class. As because it attracts rigor of Article 14. So in this judgment, your Lordship, the employees were university employees who were drawing the UGC pay scale. They were drawing the UGC pay scale as per the UGC regulation. Their pay revision, everything was to be regulated as per, till they are in the employment. After retirement, they came before this honorable court. On 1/6/1996, there was a pay revision was there. Their grievance was that, as because we have retired a day before, 31/5/1996. We have lost an opportunity for the revision of pay just because of a day. And as because all along we are being under the UGC regulation, that regulation has to be comprehensively has to be adopted even for the purpose of pensionary benefit. So what I was able to demonstrate before their lordships was that though they were drawing they relied upon the Nakara judgment, which says you cannot.
DS
Yes.
Nakara versus 84 Supreme Court.
Yes, Your Lordship.
No classification
No
amongst the
classification.
pensioners.
Yes. Our submission on behalf of the state was that it is not classification among the class. They form different class because they are governed by the Karnataka civil service rules. Their point of appointment, their service conditions are regulated. Everything has been decided.
Those working in the government school,
Yes.
those working in the aided
Aided.
institution, they constitute two different classes.
Different.
Let us go to section 30, some section in the Education Act. What is
87, Your Lordship?
83 Act,
Are
1983 Act. There is one section, I don't remember the section, which says the emoluments of employees in the aided
87,
institution.
87.
I do not remember the
80,
section.
correct, 87.
87. Let us see how it is.
That is amended subsequently.
No.
They have amended it to suit this act. Earlier provision may be seen. Earlier, it was on
80
par. 87 amendments proviso.
87.
Yes. Qualifications, conditions of service of the state government may, after previous publication, make rules regulating recruitment and conditions of service, including rights as regards discipline matters of the employees in recognized private educational institution, provided that the minimum qualifications for recruitment, age of recruitment, the employees in receiving maintenance grant from the state government shall be the same as those applicable for the corresponding category of employees, if any, in state institutions, unless otherwise
Prescribed.
One second. Proviso. Provided further that the conditions of service of employees working in aided institution shall be such as may be determined by the state government from time to time.
That is
So
amended
it's a
subsequent to the act.
amended,
In 2015.
okay.
That is the amended.
Provided also that since 1974, no employee of the aided institution is required to appear and pass any service examination or Kannada language examination. 74. And no such employee shall be eligible for be granted any additional increment for having passed or deemed to have been passed the said examination from the date of commencement of said rules. First proviso,
Your Lordship,
the
bare,
95 amendment.
yes, bare provision is that
Ah,
provided that minimum qualification for recruitment, comma,
age of recruitment
age of recruitment and retirement
for employees
in educational institutions,
Retirement and benefits of retirement.
that
was
is
also
omitted.
not there.
It's-
It's
That's
omitted.
deleted here.
That is deleted.
95.
90. Yes,
Before that, that existed.
it was there. In the unamended provision, it was there. And the retirement benefits for employees in educational institutions receiving maintenance grant from the state government shall
ಯಾವುದು amended ಓದ್ತಾ ಇದ್ರೆ unamended, please be seated. We will hear you.
unamended.
Unamended. These two, which is deleted afterwards. So there is a legislative deletion of retirement benefits.
ಅದಕ್ಕೆ ಆಮೇಲೆ ಹೋಗ್ತೀವಿ. ಫಸ್ಟ್ ಇದು unamended ತಮ್ಮ ಗಮನಕ್ಕೆ ತಂದು. This says basically it can be otherwise prescribed.
If rules prescribe otherwise, then the rules will prevail over this general
ಅಲ್ಲ,
principle.
ಇಲ್ಲಿ ಈಕ್ವಾಲಿಟಿ ತಂದ್ರು, ಪ್ಯಾರಿಟಿ ತಂದ್ರು. ಬೇರೆ ಪ್ರಾವಿಷನ್ ಒಳಗೆ ಪ್ಯಾರಿಟಿ ತಂದ್ರು. shall be same as those applicable for the corresponding category of the employees.
In the government schools.
Government, ಅದು ಒಂದು. Later, if any state institution unless otherwise prescribed. So if there is a prescription,
So they constitute different class. Anta.
yes. ನಾನು ಇದನ್ನ ತಗೊಂಡು
Kindly come to first proviso and the language of second proviso. First proviso uses the word prescribed.
Yes, your lord.
Prescribed means prescribed by rules ಅಂತ ಹೇಳ್ತದೆ General
Rules.
Clauses Act.
Correct.
Kindly come to second proviso.
Provided further that conditions of service of employees working in aided educational institution shall be as such as may be determined by the state government from time to time.
Determined ಅಂದ್ರೆ ಏನು?
Determined.
ಇಲ್ಲಿ
Determined.
ಪ್ರಿಸ್ಕ್ರೈಬ್ಡ್ ಅಂತ ಹೇಳಿದ್ರು ಹಂಗಾಗಿ ರೂಲ್ಸ್ ಅನ್ನೇ ಮಾಡ್ಬೇಕು ನೀವು. ಈಗ ನೀವು ಓದಿದ್ದು ರೂಲ್ಸ್ ಆಗಲ್ಲ ಅದು. Of course, it was prior to this act.
Prior to this, ನಾನು ಅದು now, your lordship, what my effort is, at first instant, what we have discussed, we will put forth the basis.
Historical basis.
No, that is background as well as the basis found in the judgment which resulted in the enactment. Then we will revert back to all those correcting. ಅದನ್ನ ಮಾಡ್ಕೊಂಡ್ಬಿಡೋಣ. So
distinguish that the employees of the state government and employees of the private aided constitute class by
Different
themselves,
class.
different class by themselves.
Please give us a
So I'm giving it, I'm coding. One copy, I'll streamline everything and give it, my lord.
ಎಲ್ಲ ಸಾಫ್ಟ್ ಕಾಪಿ ಮಾಡಿಕೊಡಿ.
To show, my lord, as to how nearly about 25 heads have been noted, my lord, under which mode of recruitment, service type.
So anyway, his contention that they are
Just to show
treated as
here.
two different classes
That's
by
all,
the coordinate
that's all.
bench, which he has argued. Now law is settled on that. Anta.
Yes, your lord.
That the employees of government schools are different from the employees of government aided schools.
No, that is only for the purpose of recording the service prior to granting aid.
That was prior to granting.
Granting aid.
Once grant ಆಯ್ತು ಅಂದ್ರೆ they stand on par with each other.
ಅದಕ್ಕೆ ಬೇರೆದು ಸರ್ವಿಸ್ ಕಂಡೀಷನ್ಸ್ ನಲ್ಲಿ ಅವ್ರನ್ನ ಒಳಗಡೆ ತಗೋಬೇಕಾದ್ರೆ ನಾವು ಏನು ಇದು ಮಾಡ್ತೀವಿ, ಅವ್ರಿಗೆ ಬೇರೆದೇ ಸೆಟ್ ಆಫ್ ರೂಲ್ಸ್ ಬರುತ್ತೆ. ಅವ್ರನ್ನ ಒಳಗಡೆ ತಗೊಂಡಾಗ ಮಿನಿಮಮ್ ಎಷ್ಟು ಪೇ ಸ್ಕೇಲ್ ಹಾಕ್ಬೇಕು, ಏನ್ ಮಾಡ್ಬೇಕು, ಅದಕ್ಕೆ ಒಂದಿದೆ. So now what I am trying to put forth is, your lordship, I'll go through these judgments.
Yes.
Earlier judgments.
Yes.
Which resulted in the enactment.
Yes.
Then we'll come.
Yes.
Just a moment, I interview. All the, what my learned friend is submitting, all the circumstances have been considered by the constitutional courts. It has reached up to Supreme Court level. Subsequently, just to nullify the constitutional court orders, they introduced this legislation.
That is permissible.
That has been passed by the Honorable Learned Single Judge. Now, that only question to be considered by this honorable bench is that whether the Learned Single is right in passing the said legislation in question.
No.
That has to be considered.
Correct. But you can't.
Because already that has been decided by this court.
Therefore, they are here. Yes.
No, we are not in the appeal, as my learned friend has submitted. What we are trying to submit is to show the basis of the judgments which resulted in the enactment. At paragraph 5.
Your submission is substratum of the judgment is altered.
Yes.
That is permissible under the
Yes.
constitutional scheme.
Yes.
Therefore, challenge is not sustainable. And the learned single judges holding to the contra or not right ಅನ್ನೋದು ನಿಮ್ submission.
No, we little differing it. We are only taken away what we are submitting today in the writ appeals is that we are taken away the basis of the judgment which resulted in the enactment.
By act.
Yes. Because that judgments have attained finality. We are not here to nullify that. We are, as earlier occasion your lordship has directed, we are supposed to demonstrate the basis of the judgments, which in the state opinion, that has taken away the basis and resulted in the enactment. That is why I am reading those judgments to point out the legal basis on which that judgment has been passed and how it is rationally connected to new enactment.
Mr. What is the basis of this now? Because what is the implication financially for the state?
Not only financial implication, your lord. It is about 22,000-23,000 crores, your lord. That 22,000 ಕೋಟಿ ಆಗಿದೆ.
5,000 ಕೋಟಿ.
ಇಲ್ಲ ನಾನು ಕೊಡ್ತೀನಿ, ನಾನು ಮಾಡಿದ್ದೀನಿ, ಚಾರ್ಟ್ ಮಾಡಿದ್ದೀನಿ ಕೊಡ್ತೀನಿ.
ನಿಮ್ ಪ್ರಕಾರ ಎಷ್ಟು?
ಅಲ್ಲ ಅವ್ರ ಅವ್ರ ಪ್ರಕಾರ 5,000 ಕೋಟಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಅವ್ರದ್ರಲ್ಲಿ ಅಪೀಲ್ ಅಲ್ಲಿ.
ಅಲ್ಲ
ಒಂದ್ ಸಣ್ಣ ಪ್ರಶ್ನೆ ಕೇಳಿ.
ಅಲ್ಲ ನನ್ನ
ಪ್ರಕಾರ ಎಷ್ಟು ಅಮೌಂಟ್?
ನನ್ನ ಪ್ರಕಾರ ಇಲ್ಲ ಅಂತ.
The Horati committee has given around 350 crores. Horati committee has constituted by government, but they have given a report
that we will submit them all.
ಬಟ್ ಸರ್ಟನ್ಲಿ 25,000 ಕೋಟಿ ಆಗ್ಲಿಕ್ಕೆ ಸಾಧ್ಯ.
ಅಲ್ಲ ಅದೇನಾಗ್ತದೆ, ವೈಡರ್ ಕಂಟಿನ್ಯೂಟಿ ಇರ್ತದೆ.
In the long run.
Yes. Yes. And not only that, now this issue is absolutely, that's what we have discussed. This requires lot of research and look. That is the reason we 3 AGs and our AGs also here. So wider ramification, because this is pertaining to service jurisprudence. Article 14, service conditions at one hand and stretching the equality. Service conditions are there. And at the same time, Article 14 adana stretch mark, and it will absolutely it will have not only to this case, service law mele bala doddu impact agutte. And moreover, and later it has resulted in act also got quashed. So not only, even in the earlier case also, I have not made my ground much on the financial implications. That is one part. In the pension matter also, earlier AG was argued that on the monetary burden on the state, but I didn't took up that stand in that case. I was purely on law. Service conditions, Article 14, creating class among a rational, whether the rationality between the service conditions, laws, whether it is permissible to state. ಯಾಕಂತ ಹೇಳಿದ್ರೆ ಎಲ್ಲರೂ ಸಮಾನ ಮಾಡಕ್ ಆಗೋದಿಲ್ಲ.
But all they are teachers.
No, that is their weird. See, ಈಗ ಏನಾಗಿದೆ, ನಾವು ಅದಕ್ಕೆ ಯಾವ ಸರ್ವಿಸ್ ಕಂಡೀಷನ್ಸ್ ಆಫ್ ದಿ ಗವರ್ಮೆಂಟ್ ಅವರ ರಿಕ್ರೂಟ್ಮೆಂಟ್ ಅದೆಲ್ಲ ಅದ್ರಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ. ರಿಕ್ರೂಟ್ಮೆಂಟ್ ಅದ್ರಲ್ಲಿ ಕೊಡ್ತಕ್ಕಂಥ ಮೀಸಲಾತಿ, ಆ ಎಕ್ಸಾಮಿನೇಷನ್ ಇದು, they come from a different thing. So in the Sainik school, a very recent judgment.
Non-teaching idara idaralli? Idare.
Please.
Sainik.
ಇಲ್ಲಿ ಪ್ರೈವೇಟ್ ಏಡೆಡ್ ಎಜುಕೇಶನಲ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಗಳ ಎಂಪ್ಲಾಯೀಸ್ ಇದ್ದಾರೆ, ಟೀಚಿಂಗ್, ನಾನ್ ಟೀಚಿಂಗ್. ಗವರ್ಮೆಂಟ್ ಎಂಪ್ಲಾಯೀಸ್
ಇಲ್ಲ,
ಯಾರಿಲ್ಲ. ಅವ್ರಿಗೆ ಇದೆಲ್ಲ ಸಿಕ್ಕೇ ಸಿಗ್ತದೆ.
ಅವ್ರದ್ದು
ಇದನ್ನ ಕ್ಲಾಸ್ ಬೇರೆ ಅನ್ನೋದು ನಿಮ್ ಕಂಟೆನ್ಷನ್.
ನಾವು
You have entitled to, you have said it in a tabular form.
Tabular.
All three judgments that are now in balance has stated that the pay parity
On par with them,
on par with them
that could not have happened.
based on any enactment passed cannot be in contravention of Article 4. That is the
Crux of the case. Judgments have been.
Beginning of the single happiness.
So how they are classed by themselves and the legislature then had to classify them.
Well. Yes, Mr. Ahmed.
Para 5 of the judgment, Your Honor. No? Judgment,
Honorable Justice,
Peter, Sabha.
Anu madam's, Anu Shivram
Adala,
madam's.
for the not, I am reverting to this one.
Yeah. Old judgment, Sabha Saber judgment. ನೀವು ಅವ್ರಿಗೆ ಒಂದೊಂದು ಕಾಪಿ ಕೊಡಿ ಪಾಪ.
ಇವತ್ತೆಲ್ಲ ಮಾಡ್ತಿದ್ರು.
ಪಾಪ ignorance ನಲ್ಲಿ ಇರ್ಬೇಡಿ. You are entitled to use entire material, provided you
We'll
show
do it,
them
yes.
to them.
May I ask you, Your Lordship,
Yes.
Your Lordship permit us some time, we will circulate everything with
Yes.
the,
Yes.
with our. ನಿಮಿಷ ಇದೆಲ್ಲ ಕೊಡ್ಬೇಕು. ಬೇರೆ ಬೇರೆ.
Mr. AEG. Kindly come to page 14, internal page 8 of the judgment.
Correct. Your Lord.
And last 3 lines.
Service rendered by the, for that, Your Lordship,
Ah.
I beg Your Lordship, I would start from page 8, Your Lordship.
That's what, 3 lines, last 3 lines.
Last 3 line ಹೋದ್ರೆ ಇಲ್ಲಿಂದ ಶುರು ಮಾಡಿದ್ರೆ ಒಳ್ಳೆ.
I said.
Would clearly show that the said order is passed in June 9th, appointment of petitioner in the 6th respondent institution, which was recognized institution, page number 8, Your Lordship.
Yes.
Which was recognized institution was approved on 1/6/1965, and the said orders does not mention that the period of service rendered from 1/6/1965, the date on which the appointment of writ petitioner was approved to the date of order dated 22/5/1984 could not be taken into account for the purpose of calculating pensionary benefit. And in fact, the benefits of service rendered even prior to the date of admission to the granting court has been granted by the appellant in view of the circular issued, and the order would clearly reveal that the government will not be entitled to pay salary to the writ petition prior to the date of admission of 6 respondent institution to the granting aid court. However, for the purpose of calculating the pensionary benefits, the period of service rendered from 1/6/1965 to 31/3/1984 could not have been excluded. Rule 52 of the rules relied upon by the learned government advocate would not be helpful to him in the present appeal, as the said rules only envisages the service rendered by the retired employees in
one
more than one
aided institution to another aided institution.
That is rule 52 someone. The appellant state though was that. So rule 52 was considered. The basis of the judgment was that rule 52 does not provide anything pertaining to the non-grant period.
Yes. Whether all these employees are still in service or they have been superannuated?
Yeah.
ಎಲ್ಲರೂ ಸರ್ವಿಸ್ ನಲ್ಲಿ ಇದ್ದಾರೆ, ಸೂಪರ್ಯಾನ್ಯುಯೇಷನ್ ಆಗಿದೆ. ಇಬ್ರು ಇದಾರ, ಇಬ್ರು ಇದ್ದಾರೆ.
25% or 30% retired. The rest of them.
And not everybody is before the court. ಇದಲ್ಲದೆ ಬೇರೆ ಎಂಪ್ಲಾಯೀಸ್ ಬರ್ತಾರೆ.
Okay.
And the triple benefit scheme ಅಲ್ಲಿ ಅದ್ ಮುಂದೆ ಓದಿ. At page number 10, your lordship. Definition.
First, we want to know,
Yes, sir.
to my brother's question, ಎಷ್ಟು ಅಮೌಂಟ್ ಇಂಪ್ಲಿಕೇಶನ್ ಇದೆ ಅಂತ ಕೇಳಿದ್ವಿ ನಾವು.
ಹೌದು.
ಎಷ್ಟು ಅವ್ರು 300 crores ಅಂದ್ರು, ನೀವು 25,000 ಕೋಟಿ. ಎನಿವೆ, ಕೈಂಡ್ಲಿ ಬಿ ಡೋಂಟ್ ಡಿಸ್ಟರ್ಬ್. ಅಥವಾ ನಿಮ್ ಹಿಯರ್ ಮಾಡಿ ಮುಗಿಸಿಬಿಡ್ತೇವೆ, ಆಮೇಲೆ ಇವ್ರು ಆರ್ಗ್ಯೂ ಮಾಡ್ಲಿ.
ಹೇಳಿದ್ದಾರೆ ಅಂತ ಅಷ್ಟೇ, ಐ ಆಮ್ ನಾಟ್ ಸೇಯಿಂಗ್.
ನೀವು ಇಂಟರ್ಫಿಯರ್ ಮಾಡಿದ್ರೆ ಏನಾಗ್ತದೆ, ನಮಗ್ ಡಿಸ್ಟರ್ಬ್ ಆಗ್ತದೆ. ಏನೋ ನಿಮ್ ಪರವಾಗಿನೇ ಒಂದ್ ಏನೋ ಕೇಳೋದಿರ್ತದೆ, ನೀವು ಅದನ್ನ ಕೆಡಿಸ್ ಕುತ್ಕೊಂಡ್ಬಿಟ್ರೆ ಆಯ್ತು, ನಿಮ್ಗೆ ಹೆಂಗ್ ಬೇಕು ಹಂಗ್ ಮಾಡ್ರಿ, ನಮಗೆ ಹೆಂಗ್ ಬೇಕು ಹಂಗ್ ಮಾಡ್ತೀವಿ.
ಹೇಳಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ
ಸುಮ್ಮನೆ ಕುತ್ಕೋಬೇಕು, ನಿಮಗ್ ಕೇಳಿದಾಗ ಮಾತಾಡ್ಬೇಕು. ಹಿಂಗ್ ನಮ್ ಕೈಯಿಂದ ಹೇಳ್ಸ್ಕೊಳ್ಬಾರ್ದು ಮತ್ ಎಸ್. ಈಗ
ವಿತೌಟ್ ಇಂಟ್ರೆಸ್ಟ್
ಒಂದೆರಡು ಆಸ್ಪೆಕ್ಟ್ ನಾವು ಹೇಳೋದಿದೆ, ನಿಮ್ಮಿಬ್ಬರಿಗೂ ಹೇಳೋದಿದೆ. ಡ್ಯೂರಿಂಗ್ ಫಸ್ಟ್ ವರ್ಲ್ಡ್ ವಾರ್ ಅಂಡ್ ಸೆಕೆಂಡ್ ವರ್ಲ್ಡ್ ವಾರ್, the salary of all employees came to be reduced in British Empire. ಎಲ್ಲ ಕ್ಲಾಸ್ ಆಫ್ ಎಂಪ್ಲಾಯೀಸ್ ಅವರ ವೇತನವನ್ನ ಕಡಿಮೆ ಮಾಡಿದ್ರು, ಆದ್ರೆ ಟೀಚರ್ಸ್ ವೇತನವನ್ನ ಜಾಸ್ತಿ ಮಾಡಿದ್ರು. ಯಾಕಂದ್ರೆ ನೇಷನ್ ಬಿಲ್ಡಿಂಗ್ ನಲ್ಲಿ ಟೀಚರ್ಸ್ ಕಾಂಟ್ರಿಬ್ಯೂಷನ್ ಏನಿದೆ ಅದು ತುಂಬಾ ಮಹತ್ವದ್ದು ಅನ್ನೋ ಪ್ರಿನ್ಸಿಪಲ್ ಮೇಲೆ ಇದನ್ನು ಮಾಡಿದ್ರು. ಇದನ್ನು ಕಣ್ ಮುಂದೆ ಇಟ್ಕೋಬೇಕು. ನಿಮಗ್ ಬೇರೆ ಯಾವ್ದಾವ್ದಕ್ಕೂ ಸ್ಕೀಮಿಗೆ ದುಡ್ಡು ಖರ್ಚು ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ ಅಂದ್ರೆ ಹಿಂಗ್ ಮಾಡ್ಬೋದು ವಾದ. ಅವರು ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ, ನಿಮ್ಗೆ ಅಲರ್ಟಿಂಗ್ ಯು, ನಮ್ದಲ್ಲ, ಅವ್ರು ಹೇಳಬಹುದು. ಅವ್ರಿಗೆ ನಾವು ಹೇಳೋದ್ ಬೇಡ ಅನ್ನೋದಕ್ಕೆ ಸುಮ್ ಕುತ್ಕೊಂಡ
ಬೇಡ.
ನಾನ್ ನಿಮಗ್ ಕೇಳ್ತಾ ಇದ್ದೆ, ಈ ಟೀಚರ್ಸ್ ಗಳಿಗೆ ಎಜುಕೇಶನಲ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಒಳಗೆ ಒಂದ್ 4 ಕಾಸು ಕೊಡುವಂತ ಪರಿಸ್ಥಿತಿ ಬರ್ತದೆ. ನಾವು ನಿಮ್ಮ ಅಪೀಲ್ ಅನ್ನು ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ರೆ, ನಿಮ್ಮ ವಾದನ ಒಪ್ಪದೇ ಇದ್ರೆ, ಹೌದಾ? ಒಂದು ಗ್ರೌಂಡ್ ಏನು ಅಂದ್ರೆ, ಟು ವಿಚ್ ಯು ಆನ್ಸರ್ಡ್ ಮೈ ಬ್ರದರ್ ದಟ್ ಇಟ್ ಈಸ್ ಒನ್ ಆಫ್ ದ ಗ್ರೌಂಡ್ಸ್ ಇನ್ ಯುವರ್ ಅಪೀಲ್ ಮೆಮೊ.
Yes, sir.
ಒಂದು ಗ್ರೌಂಡ್ ಏನು, ಹೆವಿ
ಫೈನಾನ್ಷಿಯಲ್
ಬಜೆಟರಿ ಇಂಪ್ಲಿಕೇಶನ್ ಇದೆ ಅನ್ನೋದು ಒಂದು ಗ್ರೌಂಡ್. ಹಾಗಾದ್ರೆ ನೀವು ಯಾವ್ದ್ಯಾವುದೋ ವಿಷಯಗಳಿಗೆ ದುಡ್ಡು ಖರ್ಚು ಮಾಡಿದ್ದು ಕೋರ್ಟಿನ ಮುಂದಿದೆ ಅಲ್ಲ, PIL ನಲ್ಲಿ. ನಮ್ಮಲ್ಲಿ PIL ನಾವು ಮಾತಾಡ್ತಾ ಇಲ್ಲ, ಕೋರ್ಟಿನ ಮುಂದಿರೋ ರೆಕಾರ್ಡ್ ಅನ್ನು ಇಟ್ಕೊಂಡು ನಿಮಗೆ ಹೇಳ್ತಾ ಇದ್ದೇವೆ. PIL is pending.
Correct.
I was part of the bench along with Orale Saab.
Yes.
Therefore, it is not that something we are saying out of the blue in ಹೇಳ್ತಾ ಇಲ್ಲ. PIL ಇದೆ ನಮ್ಮ ಮುಂದ್ಗಡೆ.
Now our submission is that humbly,
ಅಂದ್ರೆ ಇದಕ್ಕೂ ರೆಡಿ ಇರ್ಬೇಕು ನೀವು, ನಾವು ಅಲರ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ.
ಮಾಡ್ಬೋದು,
ಅವ್ರು ವಾದ ಮಾಡ್ಬೋದು ಅದನ್ನ. ಲಾಸ್ಟ್ ಟೈಮ್ ಒಬ್ರು ಎತ್ತಿದ್ರು, ಜನಾರ್ದನ್ ಎತ್ತಿದ್ರು, ಎದಕ್ ಬೇಕಾದಕ್ಕೆ ಖರ್ಚು ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ, ಟೀಚರ್ಸ್ಗೆ ಯಾಕೆ ಕೊಡಕ್ ಬರಲ್ಲ ಅಂತ ಕೇಳಿದ್ರು ಅವ್ರು.
Your Lordship,
filed on 21st of April 2022 by the Principal Secretary to Government Department of Education. There it says about 9,349.
349 crores. ಪ್ರಾಥಮಿಕ ಪ್ರೌಢ ಶಿಕ್ಷಣ
This regard would be approximately 9,349.
that is up to 31,322. Not filed.
ಈ ಶಾಸನವನ್ನ ಹಿಂದಿನ ಸರ್ಕಾರ ಮಾಡಿತ್ತು, ನೀವು ಅದನ್ನ ಕಂಟಿನ್ಯೂ ಮಾಡ್ಬೇಕು ಆ ಶಾಸನವನ್ನು ಅಂತ ನಿಮ್ದು ಉದ್ದೇಶ.
ಹೌದು.
ಈ ಎಂಪ್ಲಾಯೀಸ್ ಗಳಿಗೆ ಏನು ಕೊಡಬಾರ್ದು
ಕೊಡಬಾರ್ದು ಅಂತ. See, apart from this financial aspect, Your Lordship, that's what I submitted. This deals with Article 14, equality, service jurisprudence. Adu bala important in my submission. Apart from this, we are a model employee. ಈಗ ತಾವು ಕೂಡ ತಮ್ಮ ಮುಂದೆ ಬಂದಾಗ ಮೊನ್ನೆ ಕೂಡ ತಾವು ಆದೇಶ ಮಾಡಿದ್ರಿ, ವಿ ಫಾಲ್ ಬೇಡ್. ಇಟ್ ಈಸ್ ನಾಟ್ ದಟ್, ಬಟ್ ಅಟ್ ದಿ ಸೇಮ್ ಟೈಮ್ ಎಲ್ಲೋ ಒಂದ್ ಕಡೆ ರೆಗ್ಯುಲೇಟ್ ಆಗಬೇಕು, ಲೆಜಿಸ್ಲೇಷನ್ ಪವರ್ ಇರಬೇಕು, ಅಂಡ್ ಇಟ್ ಹ್ಯಾಸ್ ಟು ಪಾಸ್ ದಿ ಟೆಸ್ಟ್ ಆಫ್ Article 14. And now whether this fits into that or not, whether the government is vested with such a legislative power, whether with its policy decision.
Because just we want to know,
Yes.
when this bill was passed, ಈ ಬಿಲ್ ಪಾಸ್ ಮಾಡಿದ್ರಲ್ಲ, ಈ ಮಸೂದೆಯನ್ನ ಹೌಸ್ ನಲ್ಲಿ ಪಾಸ್ ಮಾಡುವಾಗ ನೀವು ಅಪೋಸಿಷನ್ ದಲ್ಲಿ ಇದ್ರಿ. ಈಗಿನ
Yes.
political dispensation.
ಇಲ್ಲ, same go.
But that's
Same.
same. Don't use party name.
Party ಅಲ್ಲ, government.
Government. ನಿಮ್ ಟೈಮ್ ನಲ್ಲೇ ಆಗಿದ್ದ ಇದು.
Government. 2015, 2 to 2014, 2 to 2014. And later 87 has been amended 2015. 15, ಎರಡು ಕೂಡ. Correct.
ಯಾವ ಇಯರ್ ನಲ್ಲಿ ಅಮೆಂಡ್ ಆಗಿದೆ?
2014, my lord. 5/9/2014.
Was during the same political dispensation or a different dispensation? We want to know.
Yes.
ಇದೇ ಸರ್ಕಾರ ಇದ್ದಾಗ ಆಗಿದೆಯೋ ಹಿಂದಿನ ಸರ್ಕಾರ ಇದ್ದಾಗ ಆಗಿದೆಯೋ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀವಿ.
ಹೌದು.
ಯಾವಾಗ?
ಇದೇ ಸರ್ಕಾರ ಇದೆ.
ಎರಡು ಅಮೆಂಡ್ಮೆಂಟ್ ಇದೇ ಸರ್ಕಾರ ಇದ್ದಾಗ ಆಗಿದೆಯಾ?
ಬಟ್ ಇದು ಹಿಯರಿಂಗ್ ಬೇರೆ ಸರ್ಕಾರ ಇದ್ದಾಗ ಬಂದಿತ್ತು, ಅವ್ರು ಆರ್ಗ್ಯೂ ಮಾಡಿಲ್ಲ, ಮುಗ್ದೋಗಿರುತ್ತೆ, ನಮ್ಗೆ ತಲೆನೋವು ಇರ್ತಿರ್ಲಿಲ್ಲ. ನಮ್ ಗ್ರಾಚಾರ ಆ ಪೆನ್ಷನ್ ಮ್ಯಾಟ್ರು ಹಾಗೆ ಆಯ್ತು, ಇದು ಹಾಗೆ ಆಯ್ತು. ದಟ್ಸ್ ವಾಟ್ ವಿ ವರ್ ಡಿಸ್ಕಸಿಂಗ್. ವಿ ಆರ್ ಮಾಡೆಲ್ ಎಂಪ್ಲಾಯೀಸ್.
ನೀವೇ ಮಾಡಿದ್ರಿ, ಅವ್ರ ಯಾಕೆ ಡಿಫೆಂಡ್
Defend ಮಾಡಿ.
ನೀವೇ ಡಿಫೆಂಡ್ ಮಾಡ್ಕೋಬೇಕು.
So my humble submission is that your lordship, I will share all these things. ಆ ಮೆಡ್ರಾಸ್ ಇದ್ರದ್ದೆಲ್ಲ ಇವ್ರ ಜೊತೆ ಶೇರ್ ಮಾಡ್ತೀವಿ, ಹಾರ್ಡ್ ಕಾಪೀಸ್ ಮಾಡಕ್ ಟೈಮ್, ಆ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಎಲ್ಲ ಮಾಡ್ತೀವಿ. ಅಂಡ್ ಮೋರ್ ದೆನ್ ದಿಸ್ ಕಂಟೆಸ್ಟಿಂಗ್ ದಿಸ್ ರಿಟ್ ಅಪ್, ಇನ್ ಮೈ ಒಪಿನಿಯನ್, ನಾವು ಅವ್ರನ್ನ ವಿರೋಧ ಮಾಡಬೇಕು ನಮ್ದು ಸರಿ ಅನ್ನೋಕ್ಕಿಂತ ಲಾ ಇಸ್ ಟು ಬಿ ಲೇಟ್ ಡೌನ್ ಇರೋದ್ರಿಂದ ನಮ್ದು ಎಲ್ಲರದು ಜವಾಬ್ದಾರಿ ಹೆಚ್ಚು. ಸೊ
ಇದರಲ್ಲಿ ಏನಾದ್ರು teach ಅಂದ್ರೆ just there is
Yes.
a legislation, whether it is valid or not, we will examine.
Yes,
It's our duty.
yes, sir.
Because you have come before us.
Correct.
We have no option than to decide it.
Yes.
But when validity of farm laws were challenged before the apex, we are making very
Correct.
responsible statement. When farm laws were challenged before the apex court had formed a committee where all stakeholders were asked to sit across the table and decide. Why can't you do it?
We will revert back to you and with my.
ಅವ್ರ ಜೊತೆ ಎಲ್ಲರ ಜೊತೆ ಕುತ್ಕೊಂಡು ಅವ್ರ ಲೀಡರ್ಸ್ ಅನ್ನು ಕರೆದು.
Yes, your lord.
Because this is one
Yes.
thing that happened before the apex court.
Absolutely.
So we want to experiment with that model. Why can't you sit with the people?
Yes.
They are not, after all, ನಮ್ಮ enemies ಅಲ್ಲ ಅವರು.
ನಮಗೂ ಪಾಠ
Most of them are teachers.
ನಮಗೂ ಪಾಠ ಹೇಳ್ಕೊಟ್ಟವರು.
ಪಾಠ ಹೇಳ್ಕೊಟ್ಟವ್ರು.
Absolutely.
ಅಲ್ವಾ?
ಈಗ ನಮ್ ಗುರುಗಳು ನಮಸ್ಕಾರ ಮಾಡೇ ನಾವು ಬರ್ಬೇಕು.
ಅಲ್ವಾ?
ಮಾತಾ ಪಿತಾ ಗುರು ದೈವಂ, ದೈವಕ್ಕೆ 4ನೇ ಸ್ಥಾನ.
That's what.
ತಾಯಿ ಜನ್ಮ ಕೊಟ್ಟು ತಾಯಿ ಮೊದಲೇವಳು, ತಂದೆ ನಂತರ ಸ್ಥಾನ. Absolutely it is not that. Our discussion was that. ಇದು ಏನಾಗಿದೆ, as because this is a service law, ನಾಳೆ ಇನ್ನೊಬ್ರು ಬರ್ತಾರೆ. We both came across another judgment.
ಅಲ್ಲ, ನಾವೇನ್
ಅಲ್ಲಿ
ಬೇರೆ
ಇದು ಸರಿ ಇದೆ ತಾವೇ.
ನಾವು ಬೇರೆ ಏನ್ ಹೇಳ್ತಾ ಇದ್ದೀವಿ? ಹೈಯೆಸ್ಟ್ ಕೋರ್ಟ್ ಆಫ್ ದ ಕಂಟ್ರಿ ಏನ್ ಮಾಡ್ತು ಆ ಕೇಸ್ ನಲ್ಲಿ, ಅದನ್ನ ನೀವು ಮಾಡ್ರಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀವಿ.
Yes.
It is not that though it is first time it is done. We want to experiment with that.
Yes.
ನೀವು ಈ ಲೀಡರ್ಸ್ ಅನ್ನೆಲ್ಲ ಕರೆಸ್ರಿ ನಾಳೆ. ಈಗ ಹಂಗೆ ಅನ್ಕೊಂಡು ಸಿಕ್ಕಾಪಟ್ಟೆ ಟೈಮ್ ಕೊಟ್ಟು ಇವನ್ನೆಲ್ಲ ಮಾಡಕ್ಕಾಗಲ್ಲ. ನಿಮಗೆ 8 ರಿಂದ 10 ದಿವಸ ಕೊಡ್ತೇವೆ.
2 weeks ಕೊಡಿ.
ಅವ್ರ ಲೀಡರ್ಸ್ ಅನ್ನೆಲ್ಲ ಆಗ್ಲಿ 2 weeks ಕೊಡ್ತೇವೆ. ಆ ಲೀಡರ್ಸ್ ಅನ್ನೆಲ್ಲ ಕರ್ಕೊಂಡು ನಿಮ್ ಕಡೆಯಿಂದನೂ ಕೂತ್ಕೊಳ್ಳಿ. ಹೌದಾ? ಕೂತ್ಕೊಂಡು ನಮ್ಗೆ ಇರುವಂತ ಡಿಫಿಕಲ್ಟಿ ಇದಿದೆ ನೀವು ಹೇಳ್ತೀವಿ, ನಮಗಿರುವಂತ ಡಿಫಿಕಲ್ಟಿ ಇದು ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ. ಅವರ ಲಾಯರ್ಸ್ ಅನ್ನ, ಅವ್ರ ಯೂನಿಯನ್ ಲೀಡರ್ಸ್ ಅನ್ನ ಕುಡಿಸ್ಕೊಂಡು ಹೆಂಗ್ ಫಾರ್ಮ್ ಲಾದಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಮಾಡ್ತಲ್ಲ, ಅದೇ ರೀತಿ
ಆ ತರದ
ಒಂದ್ ಮಾಡೆಲ್ ನಮ್ಗೆ. ನಾವೇನ್ ಡಿಸಿಷನ್ನೇ ಕೊಡ್ಬೇಕು ಅಂತಲ್ಲ, ಅದನ್ನ ಕೊಡ್ತೇವೆ ನಾವು ಅಲ್ಲಿಗೆ ಬಂದಾಗ. ಬಟ್ ಬಿಫೋರ್ ದ್ಯಾಟ್ ನೀವೆಲ್ಲರೂ ಜೊತೆ ಕೂತ್ಕೊಳ್ಳಿ, ಅವ್ರಿಗೆ ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡಿ, ಹಿಂಗಿದೆ, ನಮಗೆ ತುಂಬಾ ಖರ್ಚಿದೆ, ವೆಚ್ಚ ಇದೆ, ಇಷ್ಟೊಂದು ಕೊಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ, ಒಂದ್ ಸ್ವಲ್ಪ ಕನ್ಸೆಷನ್ ಕೊಡಿ, ಅಥವಾ ನಾವು ಕೊಡೋದೇ ಇಲ್ಲ, ಏನೋ ಹಂಗೂ ಇರ್ಬೋದು. ವಿ ಡೋಂಟ್ ನೋ. ಟಾಕ್ಸಿಕ್ ಕೂತ್ಕೊಳ್ಳಿ ಮೊದಲು. ದಿಸ್ ಇಸ್ ನಾಟ್ ಎ
ಕನ್ನಡ ನಾಡಗೀತೆ ತಾವು ಅದನ್ನೇ ಹೇಳಿ ಸೆಟ್ಲ್ ಆಯ್ತು.
ಆಗ್ಬೇಕು ನೋಡಿ, ಎಷ್ಟು ಈಸಿಲಿ ಆಯ್ತು.
ಸೆಟ್ಲ್ ಆಯ್ತು.
ಈಗೋಕ್ಕಿಂತ ನಾವು ಈಗೋ ಟ್ರಿಪ್ ತಗೊಂಡ್ಬಿಟ್ರೆ ಎಲ್ಲರೂ ಸರ್ಕಾರ, ಸೇವಾಕರ್ತರು ಅವರೆಲ್ಲರೂ ಕುತ್ಕೊಂಡು ಆಯ್ತು ಬನ್ನಿ ಒಂದು ಮರದ ಕೆಳಗಡೆ ಕುತ್ಕೊಳ್ಳೋಣ, ನೆರಳಲ್ಲಿ, ಬೇಸಿಗೆ ಇದೆ, ನೆರಳಲ್ಲಿ ಒಂದ್ ಕಡೆ ಕೂಡೋಣ, ಮಾತಾಡೋಣ, ಅಲ್ಲೇ ಆಗಿ ಹೋಗ್ಬಿಡ್ಬೋದು. ಅವ್ರಿಗೆ ನೀವು ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡಿ ಹೇಳಿದ್ರೆ ದೇ ಮೇ ಅಗ್ರಿ. ಅಥವಾ ಅವರು ತಮಗಿರೋ ಡಿಫಿಕಲ್ಟಿನ ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡಿ ಹೇಳಿದ್ರೆ ನೀವು ಒಪ್ಪು. ಅವಾಗ ಇಷ್ಟೊಂದು ಜನರು ನೀವು ವಿರುದ್ಧ ಹಾಕೋದು ನೋಡಿ ಉಳಿತದೆ. ನಾಳೆ ನಾವು ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಟ್ಟು ಅದು ಹಿಂಗೂ ಆಗ್ಬೋದು ಹಂಗೂ ಆಗ್ಬೋದು, ವಿ ಡೋಂಟ್ ನೋ. ಒಂದ್ಸಾರಿ ಬ್ಯಾಟಲ್ ಲೈನ್ಸ್ ಡ್ರಾ ಆದ್ಮೇಲೆ ಆಪ್ಷನ್ ಇಲ್ಲ, ಯುದ್ಧ ಆಗೋದೆ. ಹೌದಾ? ಅಲ್ಲಿ ಏನೇನಾಗ್ತದೆ ಆಗ್ತದೆ, ಯುದ್ಧ ಭೂಮಿಯಲ್ಲಿ ಏನಾಗತ್ತೆ ಯಾರಿಗ್ ಗೊತ್ತು. ಎನಿಥಿಂಗ್ ಮೇ ಹ್ಯಾಪನ್.
ಅದು ಕೊನೆ ಆಪ್ಷನ್ ಆಗ್ಬೇಕು ನಮ್ಮ ಸಂಸ್ಕೃತಿ ಒಳಗೆ. ನಾವ್ ಹೇಳಿದ್ರಿ ಅದು ಲೆಟ್ ಇಟ್ ಬಿ ಪಾರ್ಟ್ ಆಫ್ ಎ ಡೈರೆಕ್ಷನ್ ಟು ಅಸ್.
ಡೈರೆಕ್ಷನ್ ಅಂದ್ರೆ
ಒಂದು ಪಾಸಿಂಗ್ ರಿಮಾರ್ಕ್.
ದಟ್ ಅಂಡರ್ ದ ಶಾಡೋ ಆಫ್ ದಟ್ ಆರ್ಡರ್ ಯು ವಿಲ್ ಸಿಟ್ ಅಂತ. ಓಕೆ. This is only exploring the person.
That's Article 261.
ಯಾರ್ಯಾರು ಸ್ಟೇಕ್ ಹೋಲ್ಡರ್ಸ್ ಆಗ್ತಾರೆ ಇದರಲ್ಲಿ?
ಪ್ರಿನ್ಸಿಪಲ್ ಸೆಕ್ರೆಟರಿ.
ಡಿಸಿಷನ್ ಮೇಕಿಂಗ್ ಪವರ್ ಯಾರ ತೆಗಿದೆ?
ಡಿಸಿಷನ್ ಮೇಕಿಂಗ್ FD ಬರ್ತದೆ, FD ಫೈನಾನ್ಸ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಬರಬೇಕಾಗ್ತದೆ. And accountant general also required, because to consolidate fund in the
implications.
That is one issue is there. Without authority of law from the consolidated fund hana ತೆಗೆಯೋಕೆ ಆಗೋದಿಲ್ಲ. ಈಗ ಕೋರ್ಟ್ ಆರ್ಡರ್ಸ್ ಅಂತ ಅದು ಡಿಸ್ಪರ್ಸ್ ಆಗ್ತಾರೆ. We discussed with them also, we three. So ಅದು
ಒಂದು ಪ್ರಿನ್ಸಿಪಲ್ ಸೆಕ್ರೆಟರಿ,
primary and secondary.
secondary education.
Principal secretary collegiate education.
ಕಾಲೇಜಿಯೇಟಿವ್ ಇದಾರ ಇಲ್ಲಿ?
Collegiate higher education. Higher education.
ಪ್ರೈಮರಿ ಬರಲ್ಲ. ಪ್ರೈಮರಿ ಅಂಡ್ ಸೆಕೆಂಡರಿ one department. ಹೈಯರ್ ಎಜುಕೇಶನ್ another department.
ಮೂರು commissioner.
ಫೈನಾನ್ಸ್.
Finance principal secretary finance. ACS. ಅಲ್ಲ principal secretary. ಮೂರು
ಅಕೌಂಟೆಂಟ್ ಜನರಲ್ ನಿಂದ
ಅಕೌಂಟ್
ಆಗ್ತಾರಾ?
ಬೇಕಾಗ್ತದೆ.
ಅವ್ರು ಕೇಳಿ ಏನು
ಬೇಕಾಗ್ತದೆ. ಕಮಿಷನರ್ ಕೊಲಿಜಿಯೇಟ್ ಎಜುಕೇಶನ್. ಮೆಡಿಕಲ್ ಎಜುಕೇಶನ್ ಒಂದು
ಅವರು ಇದಾರ?
ಅವರು ಬರಲಿ.
ಮೆಡಿಕಲ್ ಇರ್ಲಿಕ್ಕಿಲ್ಲ. ಟೆಕ್ನಿಕಲ್ ಎಜುಕೇಶನ್. ಟೆಕ್ನಿಕಲ್ ಎಜುಕೇಶನ್ ಈ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಬೇರೆ ಇದೆಯಾ? ಹೈಯರ್ ಎಜುಕೇಶನ್ ಬರುತ್ತೆ. ಬೇಕಾಗ್ಲಿಕ್ಕಿಲ್ಲ, ಬಟ್ ಎನಿವೆ ಅವ್ರಿಗೆ ಇನ್ಪುಟ್ ಸೆಂಟರ್ ಬೇಕಾದ್ರೆ ಅವ್ರು ತಕೊಳ್ಳಿ.
ಒಂದು ರೂಲ್ಸ್ ಇದೆ ಅವ್ರದ್ದು ಅಡಾಪ್ಟಿಂಗ್, ಅದಕ್ಕೆ ಅವ್ರು ಬೇಕಾ?
ನೋ ಇಶ್ಯೂ. ಇದು ನಿಮ್ ಕಡೆ ಇರ್ದಾಯ್ತಾ? ಇದಾದ್ಮೇಲೆ ಡಿಸ್ಕಷನ್ಗೆಲ್ಲ ಕೂತಾಗಿಲ್ಲ ನಾವು ಕನ್ಸರ್ನ್ ಮಿನಿಸ್ಟರ್ ಕೇಳ್ಬೇಕಾಗತ್ತೆ ಅಂತ ಹೇಳೋ ಪಾಸಿಬಿಲಿಟಿ ಇದೆಯಾ?
ಮೇ ಬಿ ಆಸ್ ಪರ್ ಅಲೋಕೇಶನ್ ಆಫ್.
ಮತ್ತೆ ಎಲ್ಲ ಹಂಗಾರೆ ಡಿಸಿಷನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗೋದಿಲ್ಲ.
ಅಲ್ಲ, ವಿ ವಿಲ್.
ಯಾರು ಡಿಸಿಷನ್ ಮೇಕರ್ಸ್ ಯಾರಿದ್ದಾರೆ? ಕ್ಯಾನ್ ಯು ರಿಕ್ವೆಸ್ಟ್ ದ ಮಿನಿಸ್ಟರ್ ಫಾರ್ ಎಜುಕೇಶನ್ ಅಂಡ್
ಅಲ್ಟಿಮೇಟ್ಲಿ ಇದು ಫೈನಾನ್ಸ್ ಇರೋದ್ರಿಂದ ಇಟ್ ಹ್ಯಾಸ್ ಟು ಗೋ ಟು CM.
Honorable CM.
Yes, honorable. Because ultimately it has to go to finance. ಕ್ಯಾಬಿನೆಟ್ ಅಲ್ಲಿ ಇಡ್ಬೇಕು. ಸೊ ವುಡ್ ಐ ರಿವರ್ಟ್ ಬ್ಯಾಕ್, ಇದು ತಾವು ಒಂದು ಹೇಳಿದ್ರೆ ನಾವು ರಿವರ್ಟ್ ಬ್ಯಾಕ್ ಮಾಡ್ತೀವಿ. ಆರ್ಡರ್ ಇದ್ಬಿಡ್ಲಿ ಸರ್, ಒಂದು ಆರ್ಡರ್ ಇದ್ಬಿಡ್ಲಿ.
ಆರ್ಡರ್ ಇದ್ಬಿಡ್ಲಾ?
ಲೆಟ್ ಇಟ್ ಗೆಟ್ ಸ್ಟಾರ್ಟ್, ಸ್ಪೀಕ್ ವಿತ್ ದೆಮ್ ಅಂಡ್ ಟು ಪೂಲ್ ದೆಮ್.
ನಿಮ್ ಕಡೆಯಿಂದ ಯಾರು ಹೋಗ್ತೀರಿ? ಅವ್ರ ಕಡೆಯಿಂದ ಮತ್ತೆ ನಿಮ್ ಸೈಡ್ ಯಾವ ಲಾಯರ್ಸ್ ಎಲ್ಲ ಹೋಗ್ತೀರಿ ಅಲ್ಲಿ?
ಕಿರಣ್
ಇಲ್ಲಿ ಆರ್ಗ್ಯೂ ಮಾಡಿದವ್ರು ಯಾರ್ಯಾರು ಇದ್ದೀರಿ ಅವ್ರೆಲ್ರೂ ಹೋಗ್ಬೇಕು. ಯಾಕಂದ್ರೆ ನಮ್ಗೆ ಏನಾದ್ರು ತಿಳ್ಕೊಳ್ಳೋದಿದ್ರೆ. ವಿಜಯ್ ಕುಮಾರ್,
ನಾವು 5 ಜನ ಇದ್ದೀವಿ.
ಎಂಟೈರ್ legal intellectual property of the government is here now.
ನಾನ್ ಕಡಿಮೆ ಬುದ್ಧಿವಂತ ಇರೋದ್ರಲ್ಲಿ.
That's very good. ಇವ್ರ ಕಡೆಯಿಂದ ಯಾರ್ಯಾರು ಕರ್ಕೋಬೇಕು ನೀವು? ನಿಮ್ ಕಡೆಯಿಂದ ಯಾರ್ಯಾರು ಹೋಗ್ಬೋದು ಹೇಳಿ, ಮಾತಾಡಿ, ಈಗ ಮಾತಾಡಿ. ಹಾ, ಈ ಪ್ರಪೋಸಲ್ ನಿಮ್ಗೆ ಒಪ್ಪಿಗೆ ಇದೆಯಾ?
ಅವ್ರು ಪಾಸಿಟಿವ್ ಆಗಿದ್ರೆ ನಾವು
ಅಲ್ಲ, ಹಾಗಲ್ಲ, ನಾವು ನಿಮ್ಗೆ ಕೇಳ್ತಾ ಇದ್ದೀವಿ.
ನಾವು ಪಾಸಿಟಿವ್ ಆಗಿದ್ರೆ
ಪಾಸಿಟಿವ್ ಆಗಿದ್ರೆ ಅಂದ್ರೆ ಈಗ ನೋಡಿದ್ರಿ ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಎಲ್ಲ,
ಆಲ್ಸೋ ಪಾರ್ಟಿಸಿಪೇಟ್.
ನಿಮ್ಮ ಕ್ಲೈಂಟ್ಸ್ ಕೇಳ್ಕೊಳ್ಳಿ ಏನಂತಾರೆ.
Simultaneously, before the matter is pending, before consideration before this honorable court, simultaneously the respondent employees are regularly keeping touch with the concerned officials as well as concerned minister and as well as honorable chief minister. They are all, what they are conveying to us is that you court matter is pending consideration.
Court itself will tell that. ಅದು ಬಿಡಿ, ಕೋರ್ಟ್ ಹೇಳ್ತಾ ಇದೆ ಈಗ.
ಕೋರ್ಟ್ ಹೇಳ್ತಾ ಇದೆ ಈಗ.
ಅವಾಗ ಹಂಗ ಅನ್ನೋದಿಲ್ಲ ಅವರು.
ದಟ್ ಈಸ್ ದಿ ಆರ್ಡರ್ ಆಫ್ ದಿ ಡೇ. ಯಾರು ಟಚ್ ಮಾಡಿ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಸಬ್ಜುಡಿಸ್ ಇದ್ದಾಗ ಹೇಳ್ತಾರೆ ಹಾಗೆ. ನಾವು ದಿ ಆಸ್ ಬಿಕಾಸ್ ದಿ ಆನರಬಲ್ ಕೋರ್ಟ್ ಡೈರೆಕ್ಟಿವ್.
ಈಗ ನೋಡಿ, ಆ ಫಾರ್ಮುಲಾಸ್ ಅನ್ನ ಕಮಿಟಿ ಅವ್ರು ರೆಕಮೆಂಡ್ ಎಂತದ ಮಾಡ್ಲಿ, ಕಮಿಟಿ ಅಥವಾ ರೆಕಮೆಂಡೇಶನ್ ಆಗ್ತಾ ಅನ್ನೋದಕ್ಕೆ ಫಾರ್ಮುಲಾಸ್ ವಿಡ್ರಾ ಮಾಡಿಬಿಡ್ತು ಪಾರ್ಲಿಮೆಂಟ್.
ಕರೆಕ್ಟ್.
That may happen. Nothing is impossible, provided how persuasive you are in your discussion. ಒಳ್ಳೆ ಪವರ್ಫುಲ್ ಆಗಿ ಪ್ರೆಸೆಂಟ್ ಮಾಡುವಂತ, ದಾನ್ಲಿ ಮಾಡೋ ಬದ್ಲಿ ವೆರಿ ಪವರ್ಫುಲಿ ಬಜೆಟರಿ ಎಕನಾಮಿಕ್ಸ್ ಗೊತ್ತಿರೋರು, ಸರ್ವಿಸ್ ಜೂರಿಸ್ಪ್ರುಡೆನ್ಸ್ ಗೊತ್ತಿರುವಂತವ್ರು, ಗವರ್ಮೆಂಟಲ್ ಪ್ರೊಸೆಸ್ ಗೊತ್ತಿರುವಂತ ಲೀಗಲ್ ಬ್ರೇನ್ ಅನ್ನ ಕರ್ಕೊಂಡು ಹೋಗ್ಬೇಕು. ಅಲ್ಲಿ ದಾನ್ಲಿ ಮಾಡಿ ಯೂನಿಯನ್ ಲೀಡರ್ ಮಾಡಕ್ ಮಾಡಲ್ಲ ಅಂದ್ಬಿಡ್ತಾರೆ ಗವರ್ಮೆಂಟ್ನವರು. ಅದ್ರ ಬದ್ಲಿ ಹೆಚ್ಚು ಬಹಳ ಒಂದು ಸಕಾರಾತ್ಮಕವಾಗಿ ನಿಮ್ಮ ವಾದವನ್ನ ಗವರ್ಮೆಂಟ್ ಮುಂದೆ ಮಂಡಿಸುವಂಥ ವಿದ್ಯೆ, ಬುದ್ಧಿ, ಜ್ಞಾನ, ಅನುಭವ ಇರುವಂಥ ಎತ್ತರದ ವ್ಯಕ್ತಿತ್ವಗಳನ್ನ ಕರ್ಕೊಂಡು ಹೋದ್ರೆ ಇಫೆಕ್ಟಿವ್ ಆಗ್ತದೆ ಕಮ್ಯುನಿಕೇಶನ್. ಅನೇಕ ಯುದ್ಧಗಳು ನಿಂತಾವ್ ಹಂಗೆಲ್ಲ ಮಾಡಿದಾಗ. ಅದಕ್ಕೆ ಅನೇಕ ಯುದ್ಧಗಳು ಆಗಿದಾವ. ಮತ್ ಬೇರೆ ಲೀಗಲ್ ಬ್ಯಾಟಲ್ ಇದು. ಹೌದು, sit together.
We are ready.
ಹಾ, ಅವ್ರ ಕಡೆಯಿಂದ ರೆಡಿ ಅಂತ. ನೀವು ರೆಡಿ ಇದ್ರೆ ವೆಲ್ ಅಂಡ್ ಗುಡ್. ಇಲ್ಲ ಇದು ಸುಮ್ಮನೆ ವೇಸ್ಟ್ಫುಲ್ ಎಕ್ಸರ್ಸೈಸ್, ನಾವು ಆರ್ಗ್ಯೂ ಮಾಡ್ತೀವಿ, ನೀವೇನ್ ತೀರ್ಮಾನ ಮಾಡ್ತೀರಿ ಅಂದ್ರೆ ನಾವು ತಪ್ಪು ತಿಳ್ಕೊಳ್ಳಲ್ಲ. ನಾವು ನಿಜವಾಗಿಯೂ ತೀರ್ಮಾನ ಮಾಡ್ತೀವಿ. ನಿಮ್ ಕನ್ಸಲ್ಟ್ ಮಾಡಿಕೊಡ್ರಿ ನಿಮ್ ಕ್ಲೈಂಟ್ ಅನ್ನ. ಪದ್ಮನಾಭ ಕನ್ಸಲ್ಟ್ ಮಾಡಿಕೊಳ್ಳಿ. ನಿಮ್ ಕ್ಲೈಂಟ್ಸ್ ಎಲ್ಲ ಇದಾರೆ ಇಲ್ಲಿ, ಅವರೆಲ್ಲ ಎಜುಕೇಶನ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ನಿಂದ ಬಂದಾರೆ.
Section 87 is very clear. Section 87 is very clear. We are entitled for the service benefits prior to grant period.
ಅದಕ್ಕೆ ಮಾತಾಡೋದು ಬೇಡ ಅಂತನಾ? ನಾವ್ ಹೇಳೋದು ಅರ್ಥ ಮಾಡಿಕೊಳ್ಳಿ, ಅದು ಲೀಗಲ್ ಆಯ್ತು.
Section 180.
ಬಿಡಿ, ನಮಗ್ ಗೊತ್ತಿದೆ ಸೆಕ್ಷನ್.
My lord, it was in accordance with Article 14.
ಆಲ್ ರೈಟ್. ಈಗ ನಾವು
ಅದನ್ನ ಬದಲಿಸ್ಬಿಟ್ಟು ನಮಗ್ ತೊಂದರೆ ಕೊಡ್ತಾ ಇದ್ದಾರೆ.
ನಾವು ಸ್ವಲ್ಪ ಅರ್ಥ ಮಾಡಿಕೊಳ್ಳಿ. ನಾವು ಬಹಳ ಅಂಬಲ್ ಆಗಿ ಹೇಳ್ತಾ ಇದ್ದೇವೆ, ನಿಮ್ಗಿಂತ ಅತಿ ಹೆಚ್ಚು ಕೇಸುಗಳನ್ನ ತೀರ್ಮಾನ ಮಾಡೇವಿ ನಾವು. ಹಾಗಾಗಿ ನಿಮ್ಮ ಲಾಯರ್ಗಳು ಇದ್ದಿರಲ್ಲ, ನಿಮ್ಗಿಂತನೂ ಅತಿ ಹೆಚ್ಚು ಸಂಖ್ಯೆಯಲ್ಲಿ ನಾವು ತೀರ್ಮಾನ ಮಾಡಿದೀವಿ. ನಮ್ಮ ರೆಕಾರ್ಡ್ಸ್ ನೋಡ್ಕೊಳ್ಳಿ ಹೋಗಿ. ಹಾಗಾಗಿ ನಮ್ಮಲ್ಲಿರುವ ಅನುಭವದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ನಾವು ನಿಮಗೆ ಕೇಳ್ತಾ ಇದ್ದೇವೆ, ನೀವು ರೆಡಿ ಇದ್ದೀರಾ? ಆರ್ಗ್ಯುಮೆಂಟ್ ಬಿಡಿ, 10 ಆರ್ಗ್ಯುಮೆಂಟ್ ಇದೆ ನಮ್ಮ ಹತ್ರ. ನಿಮ್ ಪರವಾಗಿನೂ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ, ಅವ್ರ ಅಗೇನೆಸ್ಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ, ನಿಮ್ಮ ಅಗೇನೆಸ್ಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ. ನಾವು ನಿಮಗೆ ಕೇಳ್ತಾ ಇದ್ದೇವೆ, ನೀವು ಒಂದ್ ಕಡೆ ಕುತ್ಕೊಂಡು ಮಾತಾಡಿ. ಈಗ ಅವರೇ ಹೇಳ್ತಾ ಇದ್ದಾರೆ, ನಾವು ಮಾತಾಡ್ಲಿಕ್ಕೆ ರೆಡಿ ಇದ್ದೇವಿ ಅಂತ.
ನಾವು ಏನು ಮಾತಾಡ್ಬೋದು ಅಂದ್ರೆ ಪೆನ್ಷನ್ ಸ್ವಲ್ಪ ಕಮ್ಮಿ
ಅದನ್ನ
ಕರೆಕ್ಟ್
ಅದ್ ಮಾಡ್ಬೋದು.
ಹಾ, ಅದನ್ನ ಅವ್ರು ಒಪ್ಪೋದು. ಆಯ್ತಪ್ಪ, ನಿಮ್ಗೆ ಇಷ್ಟ ಆಗ್ತದಲ್ಲಪ್ಪ, ಇಷ್ಟ ಬೇಡ. ಏನ್ ಹೇಳ್ತದೆ ಸ್ಮೃತಿಕಾರರು ಮೇಲಿನ ಮೇಲೆ ನಾವು ಕೋಟ್ ಮಾಡ್ತಿರ್ತೀವಿ. ಪೂರ ಕೇಳ್ಕೊಳ್ಳಿ,
ಇದೇ ಒಂದು ನಿಮಿಷ.
ಕೇಳ್ಕೊಳ್ಳಿ ಒಂದ್ ಸ್ವಲ್ಪ. ಮಿಸ್ಟರ್ ಪದ್ಮನಾಭ, ಕೋರ್ಟ್ ಹೇಳುವಾಗ ಕೇಳ್ಕೊಳ್ಬೇಕು. ನೀವು ಒಪ್ಪೋದು ಬೇಡ, ಕೇಳ್ಕೊಳ್ಬೇಕು ಅಲ್ವಾ? ಏನ್ ಕೇಳೋದು ಬೇಡ,
ಇಲ್ಲ ನೀವ್ ಹೇಳ್ತಾ ಇದ್ದಲ್ಲ ನಾವು ಹೇಳಬೇಕು.
ಕೇಳಲೇಬೇಕು. ವಿನಾಶಕಾಲೇ ಸಮುತ್ಪನ್ನೇ ಅರ್ಧಂ ತ್ಯಜಿತ ಪಂಡಿತಃ ಅಂತ ಹೇಳ್ತದೆ ಸುಭಾಷಿತ ಮಂಜರಿ. ಪೂರ ಕಳ್ಕೊಳ್ಳುವಾಗ ಯಾವನು ಅರ್ಧವನ್ನು ಉಳಿಸಿಕೊಳ್ಳುವನೋ ಅವನೇ ಪಂಡಿತ ಅಂತ ಹೇಳ್ತದೆ. ಹಾಗಾಗಿ ದಯಮಾಡಿ ಅವ್ರ ಜೊತೆ ಕುತ್ಕೊಳ್ಳಿ, ಆಮೇಲೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ. ನಮ್ಗೆ ಗೊತ್ತಿದೆ ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್, ನೀವು ಮಾಡಿ, ಅವರು ಮಾಡಿ, ನಮ್ಮ ಮುಂದೆ ನಾವು ಮಾಡೇ ಮಾಡ್ತೀವಿ.
ಕಡೆಯಿಂದ ಸಜೆಷನ್ ಬರ್ತಾ ಇರೋ ಸಂತೋಷ. ಯಾಕಂದ್ರೆ ಸ್ಟೇಟ್ ಗೌರ್ಮೆಂಟ್ಗೂ ಬರ್ಡನ್ ಆಗೋದು ನಮಗೂ ಅನ್ಯಾಯ ಆಗುತ್ತೆ. ಆ ದೃಷ್ಟಿಯಿಂದ
ಕರೆಕ್ಟ್.
ನಾವು ಒಪ್ಕೋತೀವಿ ಅದಕ್ಕೆ.
ಆಮೇಲೆ ಅಲ್ಲಿ ಹೋದ್ಮೇಲೆ ನಮಗೆ ಬಜೆಟರಿ ಕನ್ಸ್ಟೆಂಟ್ ಇದೆ, ನಮ್ಗೆ ಆ ಪ್ರಾಬ್ಲಮ್ ಇದೆ, ಈ ಪ್ರಾಬ್ಲಮ್ ಇದೆ ಹೇಳಲ್ಲ. ಮಿಸ್ಟರ್
Suggestion.
Your Lordship.
Past petition also, my lord.
all the panel of additional sorry is here now. ಅಲ್ಲಿ ಬಹಳ ಸ್ವಲ್ಪ ಸಮಾಧಾನವಾಗಿ, ಯಾವುದೋ ಒಬ್ಬ ಇಂಡಸ್ಟ್ರಿಯಲಿಸ್ಟ್ ತನ್ನ ಲೇಬರ್ ಕ್ಲಾಸ್ ಅನ್ನು ಟ್ರೀಟ್ ಮಾಡ್ತಾನಲ್ಲ, ಆ ರೀತಿ ಮಾಡಾಗಲ್ಲ. ಅವರೆಲ್ಲ ಟೀಚರ್ಸ್, ನಾವು ಹೇಳಿವಿ ಅನ್ಕೊಂಡು ನಿಮ್ಮ ಮತಿ ಗೌರವಯುತವಾಗಿ ಬರ್ತಾ ಇದ್ದಾರೆ, ಅವರನ್ನು ಗೌರವಯುತವಾಗಿ ನಡೆಸ್ಕೋಬೇಕು. ಹಂಗ ಅನ್ಕೊಂಡು ಬಂದವರಿಗೆಲ್ಲ ನೀವು ಮಲ್ಲಿಗೆ ಹಾರ ಹಾಕಿ ಮುಂದೆ ಏನೂ ಮಾಡಂಗಿಲ್ಲ. ಬಹಳ ಗೌರವಯುತವಾಗಿ ನಡ್ಕೊಂಡಿವಿ ಸ್ವಾಮಿ ಅವರಿಗೆ. ಅವ್ರು ವಾಪಸ್ ಹೋಗುವಾಗ ಅವ್ರಿಗೆ ಜೋಬ್ನಲ್ಲಿ 5 ರೂಪಾಯಿ ಕಾಯಿನೂ ಹಾಕಿದ್ದೇವೆ ನಾವು ಅಂತ ಹೇಳಿ. ಹಂಗಲ್ಲ, ಒಂದು ವೆಲ್ಫೇರ್ ಗವರ್ಮೆಂಟ್ ಇದು. ಒಂದು ಹೊಸ ಒಂದು ಸಂಪ್ರದಾಯವನ್ನು ಹಾಕ್ತಂಗ ಆಗ್ತದೆ. ಅವಾಗ ನಿಮ್ ಸರ್ಕಾರಕ್ಕೂ ಹೆಸರು ಬರ್ತದೆ. ಆಮೇಲೆ ನೀವೆಲ್ಲ ಇಲೆಕ್ಷನ್ನಿಗೂ ಸಹಿತ ಈ ಟೀಚರ್ಸ್ ಅನ್ನೇ ಉಪಯೋಗಿಸ್ತೀರಿ ನೋಡಿ. ಅಲ್ಲ ಹಂಗೆಲ್ಲ ಮಾಡ್ಬಾರ್ದು, ಇರಿ ಹಾಗೆ ಮಾಡ್ಬಾರ್ದು. ಅವರು ನಾಳೆ ಬರುವಂತ ಚುನಾವಣೆಗಳಲ್ಲಿ ಅವರನ್ನು ಉಪೇಕ್ಷಿಸ್ಕೊಳ್ತಾ ಇದ್ದೀರಿ ನೀವು ಅಲ್ವಾ? ಇದೆ ಅಲ್ಲ, ನಮ್ಮ ಜಜ್ಮೆಂಟ್ ಇದೆ ಅಲ್ಲ. ನೀವೆಲ್ಲ ಚುನಾವಣೆ ಕೆಲಸಕ್ಕೆ ಕರೆಸಿದ್ರೆ ಹೋಗ್ಬೇಕು ಅಂತ ಹೊರಡು ಮಾಡೇವು ನಾವು. ಸೆಕ್ಷನ್ 153 ಕ್ಯಾಪಿಟಲ್ ಏನೋ ಯಾವ್ದೋ ಒಂದು ಸೆಕ್ಷನ್ ಇದೆ, ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಆಫ್ ಪೀಪಲ್ ಆಕ್ಟ್. ಎಲ್ಲದಕ್ಕೂ ಅವರನ್ನು ಉಪೇಕ್ಷಿಸಿ. ಜನಗಣತಿ, ಸೆನ್ಸಸ್ಸಿಗೆ ಉಪೇಕ್ಷತೆ, ಕೋವಿಡ್ ಟೈಮ್ನಾಗ ಅವರನ್ನು ಉಪೇಕ್ಷಿಸಿಕೊಂಡಿದ್ವಿ, ಸ್ಕೂಲುಗಳನ್ನು ನಡೆಸ್ಕೊಂಡಿದ್ವಿ. ನಿಮ್ಮ ಮಕ್ಕಳೆಲ್ಲ ಸರಿಯಾಗಿ ಡಾಕ್ಟರ್ಸು, ಇಂಜಿನಿಯರ್ಸು, ಲಾಯರ್ಸು, ಚಾರ್ಟರ್ಡ್ ಅಕೌಂಟೆಂಟು, ಪೈಲಟ್ಸು ಎಲ್ಲರನ್ನೂ ಮಾಡ್ಯಾರ ಅವ್ರು ಅಲ್ವಾ? ಅವ್ರನ್ನ ನೀವು ಒಂದು ಸ್ವಲ್ಪ ಕರೆದು ಕೂತ್ಕೊಂಡು ನೋಡ್ರಿ ಈ ರೀತಿ ಇದೆ, ಆ ರೀತಿ ನೀವು ಮಾಡಿದ್ರೆ, ನೀವು ಅದಕ್ಕೆ ಒಪ್ಪಿದ್ರೆ ನಾವು ಅವ್ರಿಗೆ ಕಳಿಸ್ಬೇಕು. ನೀವು ಅದು ಬಿಟ್ಕೊಂಡು ನಾವು ಇಂಡಸ್ಟ್ರಿ, ನೀವು ಲೇಬರ್ ಅಂದ್ಕೊಂಡು ಹೋದ್ರೆ ನಾವು ಕಳ್ಸಲ್ಲ.
ಹಾಗಿಲ್ಲ
ಇಲ್ಲ,
ಇನ್ನೊಂದು ಅದರವೇ ತಮಗೊಂದು
ಗೌರವಯುತವಾಗಿ, ಜವಾಬ್ದಾರಿಯುತವಾಗಿ ಮತ್ತು ಹಾರ್ಟಿಲಿ ಅವ್ರ ಜೊತೆ ನೀವು ಇಂಟರಾಕ್ಟ್ ಮಾಡ್ಬೇಕು.
May I just make one suggestion? Now that this.
ನೀವು ಆಲ್ರೆಡಿ ಒಂದು ಎಕ್ಸ್ಪೆರಿಮೆಂಟ್ ಮಾಡಿರಿ ಈಗ.
Please, that's going on. That's fifth, we have one.
That hope did one experiment in our matter.
Please, my lord, my suggestion is this, since the suggestion has fallen from the court, my lords, just now. And my lords, there are individual, my lords, original petitioners, my lords, who are represented here. But we have what is called as service associations also, recognized service associations. Maybe they are not before this court. If my lords may maybe take it up tomorrow with regard to the modalities of how to go about this, because they also maybe who will participate in the meeting, because there are large number of people there, and some are represented, some are not represented. Most of them, my lords, are represented, but it also affects, my lords, people who are not before the court. Who are not before the court, because our liability, my lords, I am told, my lords, is around 16,000 crores totally, in total.
9,000 ಎಲ್ಲರೂ
ಇಲ್ಲ ಅವಾಗ ಅಷ್ಟಿತ್ತು.
ನೀವು ಬರೆದು ಕೊಟ್ಟಿರಿ ಅದರಲ್ಲಿ.
ಇಲ್ಲ, last time 9,000 that was there.
ಆಲ್ರೆಡಿ ಅಷ್ಟಾಗಿ ಬಿಡ್ತಾ
ಆಗಿದೆ. In fact, that was the
ಯಾವ ಸ್ಕೀಮ್ ರೀ ಅದು? ನಾವು ಸ್ವಲ್ಪ ದುಡ್ಡು ನಮ್ಗೆ ಲಾಭ ಆಗಿದ್ರೆ.
Lords, 4 years back, when my lords had heard it earlier, my lords had asked for a statement, I am told, where my lords that was filed.
9,047 9,000 40,000 47 crores ಏನೋ ಹೇಳಿದ್ರು.
Please, my lords.
ಈಗಾಗಲೇ 15,000 ಕೋಟಿ ಆಗ್ತದೆ.
ಇಲ್ಲ, 6 we had not. We had the figure that we had given, my lords, in other context, my lords, was around 16,000. I'll verify that. Lords,
we understand.
Lords, for the suggestion that fell from the court, my lords, to in fact, my lords, to fructify into some solution, I would respectfully submit. Maybe they're also, my lords, still thinking whom to send, and they have to consult their clients. And we have what is called as aided service associations. Maybe they're not represented in these petitions, but if we have them also sit, and we will also find out how many recognized service associations are there, so that it will be a meaningful dialogue tomorrow. Because service associations are recognized service associations under the rules itself. And they're also entitled, my lords.
ಬರ್ದು ಬಿಡ್ತೇವೆ ಅವ್ರಿಗೆ.
ಅಲ್ಲ ಅದು ಯಾರ್ಯಾರು ಅಂತ ನಾವು ಫೈಂಡ್ ಔಟ್ ಮಾಡ್ಬೇಕು.
ಅಲ್ಲ ಯಾರಿದ್ದಾರೋ ಅವ್ರನ್ನ ಕರ್ಕೊಂಬಿಡಿ, ಅದೇ ಸಲುವಾಗಿ ಮತ್ತೊಂದು ಡೇಟ್ ಕೊಡೋದೇನು? ಅದರ್ವೈಸ್ ನಾವು ಹಿಯರ್ ಮಾಡ್ಕೊಂಡಂಗೆ ಆಗ್ತದೆ. ಏನ್ ಗೊತ್ತಾ, ಆಲ್ರೆಡಿ ಅವರಿಗೆ ಫುಲ್ ಕಾನ್ಫಿಡೆನ್ಸ್ ಬರ್ತಾ ಇಲ್ಲ ಗವರ್ಮೆಂಟ್ ಮೇಲೆ.
I get it.
ಫಾರ್ ಮೆನಿ ರೀಸನ್.
For many reasons, please.
ಹೆಂಗೆ ಅಂತ, ಯಾಕಂದ್ರೆ ಗವರ್ಮೆಂಟ್ ತಮ್ಮ ಮೇಲೆ ನಂಬಿಕೆ ಬರುವ ರೀತಿ ನಡ್ಕೋಬೇಕು.
Please.
ಈಗ ಹಂಗ ಅನ್ಸಲ್ಲ. ಗವರ್ಮೆಂಟ್ ಈಸ್ ಅವರ್ ಫಸ್ಟ್ ಎನಿಮಿ ಅನ್ನೋದೇ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ಲಾದಲ್ಲಿ ಫಸ್ಟ್ ಲೆಸನ್. ಹಂಗಾಗೋದು ಬೇಡ. ಗವರ್ಮೆಂಟ್ ನೋಡಿ, ನಮ್ಮ ರಾಷ್ಟ್ರದ ಇತಿಹಾಸವನ್ನೆಲ್ಲ ನೋಡಿದ್ರೆ, ರಾಜಾಹ ಪ್ರತ್ಯಕ್ಷ ದೇವತಾಹ. ರಾಜ ಅಂದ್ರೆ ಪ್ರತ್ಯಕ್ಷ ದೇವತೆ ಅವನು. ಹಂಗಾಗಿ ಕಿಂಗ್ ಕ್ಯಾನ್ ಡೂ ನೋ ರಾಂಗ್, ಇವೆಲ್ಲ ಇಂಗ್ಲೆಂಡ್ ನಲ್ಲಿ ಇದಾವಲ್ಲ, ಅದೇ ಪ್ರಿನ್ಸಿಪಲ್ ಮೇಲಿದೆ. ಹಾಗಾಗಿ ನಿಮ್ಮ ಮೇಲೆ ನಂಬಿಕೆ ಬರೋ ರೀತಿ ಒಬ್ರು ಎತ್ತರದ ಒಬ್ಬ ಅಧಿಕಾರಿ ಅಥವಾ ಒಬ್ಬ ಸಚಿವರು ಅವ್ರನ್ನ ಇಟ್ಕೊಂಡು ಅವ್ರ ಜೊತೆ ನೀವು ಮಾತಾಡಿ, ಹಿಂಗಾಗಿದೆ ಈ ರೀತಿ, ನೀವು ಯಾವ್ದಾವುದಕ್ಕೂ ಖರ್ಚು ಮಾಡ್ತೀರಿ ಅಂದ್ರೆ ಅವ್ರು ಹಂಗೆ ಹೇಳ್ಬೋದು. ನಾವು ಅದನ್ನ ಹೇಳಲ್ಲ. ನೀವು ಯಾವ್ದಾವುದಕ್ಕೂ ಏನೋ ಖರ್ಚು ಮಾಡ್ತೀರ, ನಾವು ದುಡ್ದಂಥವ್ರಿಗೆ ನಮಗೆ ಕೊಡಿ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀವಿ. ಎಷ್ಟೋ ಜನ ಈಗಾಗಲೇ ರಿಟೈರ್ ಆಗಿದ್ದೇವೆ, ಈವ್ನಿಂಗ್ ಆಫ್ ಲೈಫ್ ನಲ್ಲಿ ಮುಸ್ಸಂಜೆಯಲ್ಲಿದ್ದೇವೆ, ಜೀವನದ ಮುಸ್ಸಂಜೆಯಲ್ಲಿದ್ದೇವೆ, ನಮ್ಗೆ ಅನುಕೂಲ ಮಾಡಿಕೊಡಿ.
ಬಹಳಷ್ಟು ಕಡೆ ಸಮಸ್ಯೆ
ಆ ರೀತಿ
ಒಂದು ಬಹಳಷ್ಟು ಕಡೆ ವಿ ಆರ್ ಸೋ ಸಿಂಪಥೆಟಿಕ್. ಅದ್ರ ಬಗ್ಗೆ ಯಾವುದೇ ಎರಡು ಅಭಿಪ್ರಾಯ ಇಲ್ಲ.
ಸಿಂಪತಿ ಬೇಡ ಅವರಿಗೆ,
ಅಲ್ಲ
ದುಡ್ಡು
ಅವ್ರ
ಬೇಕಾಗಿದೆ.
ಬಗ್ಗೆ ಅಲ್ಲ,
ಸಿಂಪತಿ ಬೇಡ,
ಇಲ್ಲಿ
ದುಡ್ಡು
ಏನಾಗಿದೆ,
ಬೇಕಾಗಿದೆ, ದುಡ್ಡು ಕೊಡ್ತೀರಾ?
ವೈ ದಟ್ ಅವತ್ತು ಅಡ್ಮಿಟಿಂಗ್ ದೆಮ್ ಇನ್ ಟು ಗ್ರಾಂಟ್ ಇನ್ ಏಡ್ ಅಂತಕ್ಕಂಥ ಒಂದು ಪಾಯಿಂಟ್ ಆಫ್ ಎಬಿನೇಷನ್ ಇದೆಯಲ್ಲ, ಇದರಲ್ಲಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ವೆರಿಫಿಕೇಶನ್, ಅರ್ಲಿಯರ್ ಸರ್ವಿಸಸ್, ಇವೆಲ್ಲ ದೊಡ್ಡ ತಮ್ಮ ಗಮನಕ್ಕೆ
ಆರ್ಗ್ಯುಮೆಂಟ್ ಬಂದಾಗ ಬ್ಯಾಟಲ್ ಫೀಲ್ಡ್ ಅದು.
ಎಸ್,
ಅಲ್ಲಿ ಬ್ಯಾಟಲ್ ಲೈನ್ಸ್ ಆರ್ ಡ್ರಾನ್ ಅಪ್ ಅಂಡ್ ಯು ವಿಲ್ ಹೋಲ್ಡ್ ಯುವರ್ ಸ್ವೋರ್ಡ್, ದೇ ವಿಲ್ ಹೋಲ್ಡ್ ದೇರ್ ಸ್ವೋರ್ಡ್, ಯು ಮೇ ಹ್ಯಾವ್ ಯುವರ್ ಶೀಲ್ಡ್, ದೇ ಮೇ ಹ್ಯಾವ್ ದೇರ್ ಶೀಲ್ಡ್. ಅದು ಬೇರೆ, ಕತ್ತಿ ಗುರಾಣಿ ಎಲ್ಲ ಬರ್ತದೆ ಆ ಟೈಮ್ನಲ್ಲಿ. ಅವಾಗ ನೋಡೋಣ. ಅದಕ್ಕಿಂತ ಪೂರ್ವದಲ್ಲಿ ಕೃಷ್ಣ ಸಂಧಾನ ಆಯ್ತಲ್ಲ ಮಹಾಭಾರತದಲ್ಲಿ, ಆ ಸಂಧಾನಕ್ಕೆ ಒಪ್ಪಲೇದಕ್ಕೆ 18 ಅಕ್ಷೋಹಿಣಿ ಸೈನ್ಯ ಸತ್ತೋತು ಅಲ್ವಾ? ಆ ಕಾರಣಕ್ಕೆ ಒಂದು ಸಂಧಾನ ಮಾಡಿ ಅವರು ಕಡೆಗೆ ನಾವು 5 ಗ್ರಾಮಗಳನ್ನು ಕೇಳಿದ್ವಿ, ಅಥವಾ ಏನು
10 ಗ್ರಾಮಕ್ಕೆ
ಅದೆಂಥದ್ದು ಇದೆಯಲ್ಲ, ಒಂದು ಪೋಯಮ್ ಯಾವುದೋ ಒಂದು ಬರ್ತದೆ, ಎಂತದಪ್ಪ ಅದು ಹಿಂದಿದ್ದು, ಸುಯಿ ನೋಕ ಭರ ಭೂಕೆ ಪೀಛೆ ಮಹಾಭಾರತ ಹುವಾ ಹೈ. ಸೂಜಿ ಮಣ್ಣಿನ ಇಷ್ಟೇ, ಸೂಜಿ ಒಳಗೆ ಹೋಗುವಂತ ಮಣ್ಣಿನ ಸಲುವಾಗಿ ಮಹಾಭಾರತ ಯುದ್ಧ ಆಯ್ತು ಅಂತ ಅನ್ಕೊಂಡು ವಾಜಪೇಯಿ ಅವರು ಒಂದು ಪೋಯಮ್ ನಲ್ಲಿ ಬರೆದಾರೆ. ಇಸಿ ದೇಶಕ್ಕೆ ಪುತ್ರಿ ಕೆ ಕಾರಣ ಭಸ್ಮ ಹುಯಿ ಲಂಕಾ ಸಾರಿ, ಸುಯಿ ನೋಕ ಭರ ಭೂಕೆ ಪೀಚೆ ಹುವ ಮಹಾಭಾರತ ಭಾರಿ. ಆ ರೀತಿ ಮಾಡ್ಕೋಬೇಡಿ, ಕೂತ್ಕೊಳ್ಳಿ ಮಾತಾಡ್ಲಿಕ್ಕೆ, ಏನೋ ಒಂದ್ ಮಾಡ್ಕೊಂಡ್ ಬನ್ನಿ, ಆಯ್ತು ಒಳ್ಳೇದು, ಇಲ್ಲಪ್ಪ ನಾವು ಡಿಸೈಡ್ ಮಾಡ್ತೀವಿ.
ಅವರು ಸ್ವಲ್ಪ ದೊಡ್ಡ ಮನಸ್ಸಿಲ್ಲ,
ಅವರು ದೊಡ್ಡ ಮನಸ್ಸು,
ಅವ್ರಿಗಿಂತಲೂ ಹೆಚ್ಚು ಅವ್ರ ಬಗ್ಗೆ ತಪ್ಪು ಹೇಳ್ತಲ್ಲ, ಬಹಳಷ್ಟು ಜನ ಅದಕ್ಕಿಂತಲೂ ಕಡಿಮೆ ಅಂತ ಜನ ನಮ್ಮಲ್ಲಿ.
ಅದು ಯಾವಾಗೂ ಇದೆ, ಅದು ಯಾವಾಗ್ಲೂ ಇದೆ. ಆದ್ರೆ ಬೇರೆ ಎಂಪ್ಲಾಯೀಸ್ ಆದ್ರೆ ನೀವು
ಇಲ್ಲ, ನಾವು
ಟೀಚರ್ಸ್ ಇದೆ, ಅವ್ರು ನಮ್ಮ ದೇಶದ ಭವಿಷ್ಯವನ್ನ ನಿರ್ಮಾಣ ಮಾಡುವಂತ. ಹಾಗಾಗಿ
ನಾವ್ ಇವತ್ತು ಮಾತಾಡ್ತಕ್ಕಂಥದ್ದು ಅವರಿಂದ,
ಅದಕ್ಕೆ ಅವರಿಂದ ಅಲ್ವಾ, ನಮ್ಗೆಲ್ಲ ಕಲಿಸ್ತಂತೆ ಅವರು. ಅವ್ರು ಕಲಿಸಿದ್ದಾರೆ ಅನ್ಕೊಂಡು ನಾವು ನಿಮ್ಮಂತ ಮಹಾನ್ ಅಡ್ವೊಕೇಟ್ಸ್ ಜನರಲ್ಸು ಇವರೆಲ್ಲ ಆಗಿದ್ದಾರೆ, ನಮ್ಮಂತ ಚಿಕ್ಕ ಜಡ್ಜ್ಗಳಾಗಿದ್ದೇವೆ, ಎಲ್ಲ ಆಗಿದೆ ಅಲ್ವಾ. ಒಂದೇನೋ ವಿದ್ಯೆ ದಾನ ಮಾಡಿರ್ತಾರ. ವಿದ್ಯೆ ಎಷ್ಟು ಇಂಪಾರ್ಟೆಂಟ್ ಮನುಷ್ಯನಿಗೆ, ಅದನ್ನೆಲ್ಲ ಮಾಡ್ಯಾರ ಅವರು. ಹಾಗಾಗಿ ನೀವು ಯಾವುದೋ ಒಂದು ಸಾದಾ ಒಂದು ಕೋಆಪರೇಟಿವ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಎಂಪ್ಲಾಯಿ ಜೊತೆ ಬಿಹೇವ್ ಮಾಡ್ದಂಗೆ ಮಾಡಂಗಿಲ್ಲ. ಎಜುಕೇಶನ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅದ ಎಂಪ್ಲಾಯೀಸ್ ಇರ್ತಾರೆ, ಅವರು ಟೀಚರ್ಸ್ ಇರ್ಬೋದು, ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ದಲ್ಲಿ ಗಂಟಿ ಬಾರಿಸುವಂಥವ್ರು ಇರ್ಬೋದು, ಯಾರೇ ಇರ್ಬೋದು, ಅವರಿಂದ ಎಲ್ಲರಿಂದನೂ ಸರ್ವಿಸ್ ಆಗ್ತದೆ. ನಮ್ಮ ಮಕ್ಕಳೆಲ್ಲ ದೊಡ್ಡವರಾಗ್ತದೆ, ಅವ್ರಿಗೆ ಇನ್ನೂ ಪ್ರೀತಿ ಬರ್ತದೆ. ಅಡ್ಡಿಲ್ಲಪ್ಪ ಸರ್ಕಾರ ಏನೋ ಒಂದು ಮಾಡಿಕೊಡ್ತವೆ, ಆಸೆ ಜಾಸ್ತಿ ಇರ್ಬೋದು, ಆದ್ರೆ ಅಟ್ಲೀಸ್ಟ್ ಹಂಗೆ ಅನ್ಕೊಂಡು ನಾವು ಏನೂ ಕೊಡೋದಿಲ್ಲ ಅಂತ ಹೇಳೋದು ಹೆಂಗೆ?
ವಿಲ್ ಫೈಂಡ್ ಸಮ್ ವೇ.
ಮಾಡ್ಕೊಳ್ಳಿ, ಬರ್ಕೊಳ್ಳಿ. ಹಾ, ಏಜಿನ ಇನ್ವಾಲ್ವ್ ಮಾಡ್ಕೋತೀರಾ? ಏಜಿ ಆಯ್ತು, ಅದನ್ನು ಮಾಡೋಣ. The correct. The matter, the hearing of the matter again started. First, a battery of advocates, additional advocates general, made some submission. First off, there is much to be submitted comma, is true. First, at this stage, the court felt that both the sides duly represented by the responsible persons having power to take decision shall sit together and try to work out an amicable settlement. First, to this, both the sides willingly agreed. First, there is also a broad consensus as to who all should participate in the parley. From the government side, comma, the following officials or their higher-ups shall be there. Principal Secretary, Department of Finance. Any order of the department of the order hengide. Finance first,
Finance first.
Department of
Chief
Finance.
Secretary.
But Varna,
So.
that was first, the Chief Secretary of the Government of Karnataka. One. The Principal Secretary, Department of Finance. The Principal Secretary, Department of Higher Education. The Principal Secretary, Department of Primary and Secondary Education. Accountant General for the State of Karnataka. Commissioner of Collegiate Education, Government of Karnataka. One set. Second, this is capital A. Capital B dalli. ನೀವೆಲ್ಲರೂ ಇರಬೇಕಾದ್ರೆ. The following learned additional advocates general shall also be present. Barkalama. Avರೆಲ್ಲರದು advocate general and government AGAs. ಅವರೆಲ್ಲರ ಹೆಸರು ಬರ್ಕೊಂಡ್ಬಿಡ್ಬೇಕು.
Yes, sir.
SA Multaf, Kiran Drone, Aditya, Vijay Kumar.
ಎಲ್ಲರೂ
ಬರ್ಬೇಕು. Government advocates.
ವಿಕಾಸ್.
Yes.
ಅದರಲ್ಲಿ ಒಂದು ಲಾರ್ಡ್ಶಿಪ್ ಚೀಫ್ ಸೆಕ್ರೆಟರಿ ಇದ್ರೆ ಅವರು ಮೀಟಿಂಗ್ಸ್ ಬಹಳ ಓವರ್ ಬರ್ಡನ್ ಆಗ್ತದೆ. ಇಫ್ ಇಟ್ ರಿಕ್ವೈರ್ಸ್ ವಿಲ್ ಟೇಕ್ ಅಪ್ ಚೀಫ್ ಸೆಕ್ರೆಟರಿ ಬೇಡ ಇವ್ರು ಸಾಕು ಅಂತ.
ಚೀಫ್ ಸೆಕ್ರೆಟರಿ ತೆಗೆದ್ಬಿಡಮ್ಮ. ಅಲ್ಲಿ ಒಂದು ಕೆಳಗಡೆ ಒಂದು ಸೆಂಟೆನ್ಸ್ ಬರಿ. It is open to the Chief Secretary, Government of Karnataka, if he is ready and willing to chair the meeting. ಈ ರೀತಿ ಆಪ್ಷನ್ ಇಟ್ಕೊಳ್ಳಿ. ಅವ್ರಿಗೆ ಸಾಧ್ಯ ಬರಲಿ. A, B, I. C. From the side of employees, the following persons shall participate. Head.
Clients ಜೊತೆ ಮಾತಾಡಿ ಅದು will disclose. Give the names, furnish the.
ಹೇಳ್ಕೊಳ್ಳಿ ಮತ್ತೆ ಅದಕ್ಕೊಂದು ಡೇಟ್ ಹೋತು ಅಂದ್ರೆ ಮತ್ತೆ 2 weeks ಆಗ್ತದೆ.
ಇವಾಗಲೇ
ಆಯ್ತು 2 weeks ಹಾಕೊಳ್ಳಿ. ಕಾಲ್ ಆಫ್ಟರ್ 2 weeks ಮಾಡ್ತೀವಿ.
ಇವಾಗಲೇ ಹೇಳ್ತೀವಿ.
ಹೇಳಿ ಬೇಗ ಹೇಳ್ಬೇಕು. ಯಾಕಂದ್ರೆ ನಾವು ಬೆಂಚು ಯಾವಾಗ ಕೂಡುತ್ತೆ ಅಂತ ಗೊತ್ತಿಲ್ಲ ನಮಗೆ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಇಲ್ಲ, ಅದ್ರ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಇಲ್ಲ, ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಹೋಗ್ತದೆ. ಇದನ್ನೇ ಡಿಸೈಡ್ ಮಾಡ್ಲಿಕ್ಕೆ ಈಗಲೇ ಹೇಳಂಗಿದ್ರೆ ಹೇಳ್ಬಿಡಿ, ಆಮೇಲೆ ನಮ್ಮ ಮೇಲೆ ಮುನಿಸ್ ಮಾಡ್ಕೋಬೇಡಿ.
Lordships may indicate not the counsels, lords who represent the parties, because
all the advocates on record for the petitioner, the employees.
And lords, if there is any other names, lords will provide subject.
ಈಗ ನಾನು ಆರ್ಡರ್ ಬರಿಬೇಕಲ್ಲ, ಈಗಿಂದ ಈಗಲೇ ಬರೆದು ನಾವು ಹೋಗ್ಬೇಕು.
In between, my mediator is also required. Any retired judge, Like mediator, my lord, any retired judge may
Mediator.
supervision of that.
ನಿಮ್ ನಡುವೆ ಮಾಡ್ಕೊಳ್ಳಿ. ಮಿಡಿಯೇಷನ್ ಬೇಡ. ನೀವೆಲ್ಲ ಮೆಚೂರ್ಡ್ ಪೀಪಲ್, ಟೀಚರ್ಸ್ ಎಲ್ಲ
Association
ಇದ್ದೀರಿ.
leaders, may say, will say,
ಎಷ್ಟು ಜನ ಲೀಡರ್ಸ್?
at least 5,
5 ಲೀಡರ್ಸ್.
at least, minimum.
ಅವ್ರನ್ನ ಹೆಂಗ್ ಡಿಸೈಡ್ ಮಾಡೋದು?
ನಾವು ಹೇಳ್ತೀವಿ ಸರ್, ಇಲ್ಲೇ ಹೇಳ್ತೀವಿ. ಯಾಕೆಂದ್ರೆ
Any 5 representatives as may be consensually nominated by the advocates on record. ನೀವ್ ಯಾರನ್ನ ಡಿಸೈಡ್, 5 ಜನರು. Then I must have said the union leaders of their association and
Yes,
ಯಾರು ಹೇಳಿದ್ರು?
Even the
Ruben.
association members also.
ಯಾರನ್ನ ಹಾಕು?
Technical Education Board, one associate education. Technical Education Board, one associate education. The
ಟೀಚರ್ಸ್ ಅಸೋಸಿಯೇಷನ್ ಇದೆಯಾ ಸಪರೇಟ್ ಆಗಿ?
please,
ಇದೆಯಾ?
please, please,
The-
one Mr. Badger is representing that association.
The lordship,
ಅದು ಉಪಯೋಗ ಮುಟ್ಟೋದಿಲ್ಲ.
My side, my lord,
ಗ್ಯಾದರಿಂಗ್ ಆಗ್ತದೆ, ಎಫೆಕ್ಟಿವ್ ಆಗಿ ಕಮ್ಯುನಿಕೇಶನ್ ಆಗಲ್ಲ. ತುಂಬಾ ತುಂಬಾ ದೊಡ್ಡ ಆರ್ಮಿ ತಗೊಂಡು ಹೋದ್ರೆ ಉಪಯೋಗ ಮುಟ್ಟಲ್ಲ.
no, my lord. They are express their opinion, my lord.
lordship,
The sum of the employees, my lord, they are asking from the date of initial appointment, they are
ಬರ್ಕೊಳ್ಳಿ.
get the.
5 presidents or general secretaries of registered ಅಲ್ಲಿ presidents stroke or general secretaries or such other officer not exceeding 5 in number of registered association of teachers.
private aided.
Private aided institutions, teachers of private aided institutions.
Leader of the aided institution.
Last week. ಯಾವತ್ತು ಮೀಟಿಂಗ್ ಮಾಡ್ತೀರಿ? ಎಲ್ಲಿ ಮಾಡ್ತೀರಿ? ಬರ್ದು ಬಿಡ್ತೇವೆ ಈಗ ನಾವು. ಎಲ್ಲ ಡೀಟೇಲ್ ಮತ್ ಆ ಗ್ರೌಂಡ್ ಮೇಲೆ ಮುಂದೆ ಹೋಗೋದು, ಮತ್ ಕೇಸ್ ನಡೆಸೋದು,
Please also mention.
ಆರ್ಗ್ಯುಮೆಂಟ್ ಅಷ್ಟೇ ಮಾಡ್ತಕ್ಕದ್ದು, ಬೇರೆ ಏನಿಲ್ಲ. ಎಲ್ಲಿ ಮಾಡ್ತೀರಿ, ಯಾವತ್ ಮಾಡ್ತೀರಿ ಕೇಳ್ಕೊಳ್ಳಿ, ಫೋನ್ ಮಾಡಿ ಇಲ್ಲಿಂದಾನೆ. ನಿಮ್ ಫೋನ್ ತೊಳಿ, ಇಲ್ಲೇ ಮಾತಾಡಿ, ನಮಗೂ ಗೊತ್ತಾಗ್ಲಿ. ಇಲ್ಲೇ ಮಾಡ್ರಿ, ಫೋನ್ ಮಾಡ್ರಿ. ಮಾತಾಡಿ, ಇಲ್ಲೇ ಮಾತಾಡಿ, ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ. ಇದು ಅಫಿಷಿಯಲ್ ವರ್ಕ್ ನಲ್ಲಿ ಮಾತಾಡ್ತಾ ಇದೆ, ನಾವೇನ್ ಚಾಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ. ಮಾತಾಡಿ. ಭಜಂತ್ರಿ ಮಾಡ್ಬೋದಾ ಈ ರೀತಿ?
ಮಾಡ್ಬೋದು.
ಮಾತಾಡಿ, ಫೋನ್ ನಲ್ಲಿ ಮಾತಾಡ್ಕೊಳ್ಳಿ, ಕುತ್ಕೊಂಡು ಮಾತಾಡಿ.
ಒಂದು ನಿಮಿಷ.
ಆಯ್ತು, ಹೋಗ್ಬನ್ನಿ. ಡಿಸೈಡ್ ಮಾಡಿ. ನಮ್ಮನ್ನು ಬಿಯರು ಮಾಡಿ ನೀವು ನಿಮ್ಮ ಕಮಿಟಿ ಕಳಿಸಿದ್ರೆ ಪ್ರೊಸೀಜರ್ ಮಾಡ್ತೀವಿ. They should come before the court. They should have come in time before the court. Don't final aspect of them. I will come when I retire. My cause of action by this operation. All these missing. Success ಆಗಿದೆ ಇನ್ನೊಂದು ಮಾಡಿದ್ ನಾವು ಒಂದು ಹಾ, ವಿಜಯ್ ಕುಮಾರ್. ಹಾ.
ಆಯ್ತು, ಅನ್ಲಿಮಿಟೆಡ್ ಸರ್.
ಅಲ್ವಾ, ಈ ರೀತಿ ಮಾಡ್ಬೋದು ನಾವು. ನಮ್ಗೆ ಆಫ್ಟರ್ ಆಲ್ ಏನ್ ನಮ್ ದೇಶ ಕಟ್ಟೋರು ಜಡ್ಜ್ಗಳೆಲ್ಲ ಲಾಯರ್ ಅಲ್ಲ, ನಾವು ಹೊಲಾನು ಹೊಡೆಯಲ್ಲ, 1 kg ಅಕ್ಕಿ ಬೆಳೆಯಲ್ಲ, ಬಟ್ ಅವರು ನಮ್ಮ ಮಕ್ಕಳನ್ನೆಲ್ಲ ಬೆಳೆಸಿರ್ತಾರೆ ಅಲ್ವಾ. ಅವ್ರನ್ನ ನಾವು ಟ್ರೀಟ್ ಮಾಡುವಾಗ ಬಹಳ ಗೌರವಪೂರ್ಣವಾಗಿ ಟ್ರೀಟ್ ಮಾಡ್ಬೇಕು. ಯಾವ್ದೋ ಫ್ಯಾಕ್ಟ್ರಿ ಎಂಪ್ಲಾಯೀಸ್ ಟೈಪ್ ಅವ್ರಿಗೂ ಎಲ್ಲರಿಗೂ ಗೌರವವಾಗಿ ಕೊಡ್ಬೇಕು. ಅದರ ಟೀಚಿಂಗ್ ಕ್ಲಾಸ್ ಇದೆ, ಗುರುಭ್ಯೋ ನಮಃ. ಅಹಮದ್ ಹಗಲೆಲ್ಲ ಹೇಳ್ತಿರ್ತಾರೆ ನಂಗೆ, ಗುರುಭ್ಯೋ ನಮಃ. ನಮ್ಮ ದೇಶದ ಈಥೋ ಏನು? ಗುರುವಿಗೆ ನಮಸ್ಕಾರ. ಗುರುವಿನ ಗುಲಾಮನಾಗದ ಹೊರತು ಸಿಗುವುದಣ್ಣ ಮುಕ್ತಿ. ಮುಕ್ತಿ ಬೇಕು ಅಂದ್ರೆ ಗುರುವಿನ ಗುಲಾಮ ಆಗ್ಬೇಕು.
ನೈ ಜ್ಞಾನೇನ ಸದೃಶ್ಯಂ ನಾವು ಹಾಕೊಂಡಿದ್ ನಮ್ ಶಾಲೆ
ಗುರು ಮತ್ತು ಜ್ಞಾನ. ಅದರಿಂದ
ಈಗ ನಾವು ಇದು ಸ್ವಲ್ಪ
ಮಾಡಿ, ಆದ್ರೆ ಆನೆಸ್ಟ್ಲಿ ಮಾಡಿ. ಏನೋ ಕೋರ್ಟ್ ಹೇಳ್ತು, ಕೋರ್ಟ್ ನಾವು ವಿರುದ್ಧ ಮಾಡ್ಕೊಳ್ಳಿಕ್ ಬರಲ್ಲ, ಆ ಕಾರಣಕ್ಕೆ
ಲಾರ್ಡ್ಶಿಪ್
ಬಹಳ ಪ್ರೀತಿಯಿಂದ ಅವ್ರನ್ನ ಕೂಡಿಸ್ಕೊಂಡು
ವಿಲ್ ಪುಟ್ ಅವರ್ ಬೆಸ್ಟ್
ಎಫರ್ಟ್ಸ್
ಬೈ ಹಾರ್ಟ್ ಹಾಕ್ತಿವಿ. ಅವ್ರ ಕಡೆಯಿಂದಲೂ ಕೂಡ ಸೇಮ್ ಇದು
ಅವರು ಹಂಗೆ ಮಾಡಿ.
ಅವರು
ಅಶ್ಯೂರೆನ್ಸ್ ಕೊಟ್ಟಿದಾರಲ್ಲ, ಅವರು ಅಶ್ಯೂರೆನ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಏನೋ ನೀವು ಬಹಳ ಚಿಂತಾಕ್ರಾಂತವಾಗಿ ಕೂತೀರಿ, ಹಂಗ್ ಮಾಡ್ಬೇಡಿ. ಏನೋ ಒಂದು ಉಪಯೋಗ ಆಗ್ಬೋದು. ನೀವು ದೊಡ್ಡ ಲಾಯರ್ಸು, ನಿಮ್ದೆಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಕೇಳ್ತೇವೆ ನಾವು, ಆದ್ರೆ ಓಪನ್ ಹಾರ್ಟ್ ನಿಂದ ಇದು ನೋಡಿ. ಓಪನ್ ಹಾರ್ಟ್ ನಿಂದ ಹೋದ್ರೆ ಎನಿಥಿಂಗ್ ಈಸ್ ಪಾಸಿಬಲ್. ಸಿದ್ದೇಶ್ವರ ಸ್ವಾಮೀಜಿ ಹಾಗೆ ಹೇಳ್ತಿದ್ರು, ಎನಿಥಿಂಗ್ ಈಸ್ ಪಾಸಿಬಲ್ ಅಂತ. ಪಾಸಿಟಿವ್ ಆಗಿ ಹೋಗಿ
ಅದಕ್ಕೆ ಯಾಕೆ ಕಾರಣ ಹೇಳ್ತೀನಿ.
ಇವಾಗ ಅರಿಯರ್ ಜಾಸ್ತಿ ಆಗಿದೆ ಅವರಿಂದ.
ಇಲ್ಲ, ಈಗ ಕಾರಣ ಹೇಳ್ತೀವಿ.
ಅದು ನಿಜ ಇದೆ.
ಅಲ್ಲ, 29ನೇ ತಾರೀಕಿಗೆ ಈ 29ನೇ ತಾರೀಕಿಗೆ ಶನಿ 8ರಿಂದ ಹೊರಗಡೆ ಹೋಗ್ತಾರೆ. ಈಗ 29ಕ್ಕೆ ಅದು ಕಟಕ ರಾಶಿ ಪುನರ್ವಸುದವರೆಗೆ ಯೋಗ. ಈಗ ಅದು
ಜನ ಅವರೇ ಇದ್ದಂಗೆ ಕಾಣ್ತಾರೆ.
ನಾನು ಕಟಕ ರಾಶಿ ಪುನರ್ವಸು, ಶ್ರೀರಾಮಚಂದ್ರ ನಕ್ಷತ್ರ. ಈಗ ಅದಕ್ಕೆ ಅಲ್ಲೇ ಶಾಪ ವಿಮೋಚನೆ ಆಗ್ಬೇಕಲ್ಲ, ಯಾರ್ಯಾರು ಬರ್ಬೇಕು ಅಂತ ಇರ್ತದೆ,
ಅವಾಗೆ ಆಗೋದು.
ಅವಾಗ ಆಗೋದು.
ಈಗ ಆಗ್ಲಿ, ನೀವು ಏನಾರ ಮಾಡಿ ಶಾಪ ವಿಮೋಚನೆ ಮಾಡಿ.
ಅವರು ಕೂಡ ಅಷ್ಟೇ ಜವಾಬ್ದಾರಿಯುತವಾಗಿ
ಅವರು ಮಾಡಿ, ನಿಮ್ ಕಡೆಯಿಂದನೂ
ಅದಕ್ಕೋಸ್ಕರ ಆಗ್ಬಾರ್ದು.
ಅಲ್ಲಿ
ಸರ್ವಿಸ್ ರೀಸನಬಲ್
ಅಲ್ಲಿ ಏನಿರಲ್ಲ ಅಂತ ಹಂಗಿರಲ್ಲ. ವಾದ ಬೇರೆ. ಅಲ್ಲಿ ಮಾತಾಡ್ಬೇಡಿ. ನೋಡೋಣ, we decide. No, you are not the judge. We are judges. You are not appointed as judges. You have appointed us as judges. We know what is what. Okay? But we know you have appointed us as judges to decide, to judge this case. We will do that. But ಅಲ್ಲಿ ಹೋಗ್ಕೊಂಡು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಬೇಡಿ. ವಾದದಿಂದ ಉಪಯೋಗವಿಲ್ಲ. ಹೌದಾ? ಕುತ್ಕೊಂಡು ನೀವೊಂದು ಒಂದು ಇಂಗ್ಲಿಷ್ ನಲ್ಲಿ ಪಾರ್ಲೆ ಅಂತಾರೆ, ಕುತ್ಕೊಂಡು ಸಭ್ಯವಾಗಿ ಕುತ್ಕೊಂಡು ಮಾತಾಡಿ. ಏನೇನ್ ಪ್ರಾಬ್ಲಮ್ ಇದೆ, ಏನಿದೆ, ಎಷ್ಟು ಖರ್ಚಾಗಿದೆ,
ಏನ್ ಮಾಡ್ಬೇಕು, ಹೇಗೆ
ಮಾಡ್ಬೇಕು.
In fact, my lord, this exercise was carried out earlier. In fact, my lords, the learned member of Legislative Council, my lords, as on that day, my lords were approached, and my lord, they had, my lords, a lengthy discussion with, my lord, the authorities and also the government. Lord, what the misconception, my lords, which is being given by the authorities concerned, not that I'm putting it to them. They think that, my lords, we are asking, my lords, if any person who is appointed to unaided institution, which gets into granting it subsequently, that they are asking arrears of salary for the non-grant period also. It is not so, my lords. They are asking for salary only.
Clear ಮಾಡಿ ಅವರಿಗೆ. ನೀವು ಹಂಗೆ ಇಟ್ಕೋಬೇಡಿ ಅಂತ ನೀವು ಹೇಳಿ ಹೋಗಿ.
Only from that date. And, my lords, only fixation, my lords, they are asking for. Notional fixation, my lords, financial benefits from the date, my lord, the institution is admitted to granting it, my lords, as like other employees of the institution. That's all, my lords, they are asking for. And, my lord, the financial implications also is not that, my lords. What they are
ಮಾಡಿ. ಈಗ ನಿಮ್ಮಲ್ಲಿ ಒಬ್ರು ಬಜೆಟ್ ಎಕನಾಮಿಕ್ಸ್ ಕರ್ಕೊಂಡು ಹೋಗಿ, ಬರೀ ಲಾಯರ್ ಕೇಳ್ಕೊಂಡು ಅಷ್ಟಿಲ್ಲ ಹಿಂಗೆ ಹೇಳಿದ್ರೆ ಆಗಲ್ಲ. ಸ್ವಲ್ಪ ಫೈನಾನ್ಸ್ ಬಗ್ಗೆ ಗೊತ್ತಿರ್ಬೇಕು.
ಆ ಫೈನಾನ್ಸ್ ಯಾತಕ್ ಬಂತು
ಹಾ.
ಅಂದ್ರೆ ಇನ್ಫ್ಯಾಕ್ಟ್ my lord, rules are already there in place. They did
ಅಲ್ಲ.
not comply with the rules. That's why my lord, there is a arrears.
ಅಲ್ಲಿ
They had my lords agreed, my lords.
ಅಲ್ಲಿ ಸೆಕ್ಷನ್ 7 ಆಫ್ ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ಸ್ ಆಕ್ಟ್ ಗೊತ್ತಾ ನಿಮ್ಗೆ? ಲಾಯರ್ಸ್ ನೇರವಾಗಿ ಅಪಿಯರ್ ಆಗೋ ಪರ್ಮಿಷನ್ ಇಲ್ಲ, ಪರ್ಮಿಷನ್ ತಗೊಂಡು ಅಪಿಯರ್ ಆಗ್ಬೇಕು.
ಹೌದು.
ಯಾಕೆ ಹಂಗಾಗ್ತಾ ಇದೆ? ಅನೇಕ ಕೇಸ್ಗಳು ಪಾರ್ಲಿಮೆಂಟರಿ ಲೆಜಿಸ್ಲೇಷನ್, ಲ್ಯಾಂಡ್ ರಿಫಾರ್ಮ್ಸ್ ಆಕ್ಟ್ ನಲ್ಲಿ
LRF
ಲಾಯರ್ಸ್ ಆರ್ ನಾಟ್ ಪರ್ಮಿಟೆಡ್. ಸೆಕ್ಷನ್ ಹಂಗಿತ್ತು, 87 ದಲ್ಲಿ ಸೆಟ್ ಅಸೈಡ್ ಮಾಡಿದೆ. ಇದೆ ಯಾಕೆ ಅಂದ್ರೆ ಲಾಯರ್ ಅಲ್ಲಿ ಹೋದ ಕ್ಷಣ ಅಂದ್ರೆ ಆ ಕಾನ್ಸೆಪ್ಷನ್ ಇದೆ, ಲಾಯರ್ಸ್ ಇನ್ವಾಲ್ವ್ ಆದಾಗನೇ ಮುಗಿಯಲ್ಲ ಅನ್ನುವಂತ ಒಂದು ಅಸಂಪ್ಷನ್. ದಟ್ ಈಸ್ ನಾಟ್ ಕರೆಕ್ಟ್. ದಟ್ ಈಸ್ ನಾಟ್ ಕರೆಕ್ಟ್. ಅದಕ್ಕೆ ನಿಮ್ಗೆ ಎಲ್ಲದಕ್ಕೂ ಲಾಯರ್ ಬೇಕು, ಎಲ್ಲದಕ್ಕೂ ಈ ವಾಟರ್ ಡಿಸ್ಪ್ಯೂಟಿಗೆ ಬೇಕು, ಇಂಟರ್ ಸ್ಟೇಟ್ ವಾಟರ್ ಡಿಸ್ಪ್ಯೂಟಿಗೆ ಬೇಕು, ಪೆನ್ಷನ್ ಫಿಕ್ಸ್ ಆಗಿದ್ರೆ ಬೇಕು, ಎಲ್ಲದಕ್ಕೂ ಲಾಯರ್ ಬೇಕಾಗ್ತಾರೆ. ಗೌರ್ಮೆಂಟ್ ಕೇಸ್ಗಳಿದ್ರೆ ನೀವೆಲ್ಲ ಲಾಯರ್ಸ್ ಲಾಯರ್ಸ್ ಬೇಡವಾ ಗೌರ್ಮೆಂಟ್? ಮತ್ತೆ ನೀವು ಲಾಯರ್ಸೇ ಅಲ್ಲ. ಹಾಗಾಗಿ ಅದನ್ನೆಲ್ಲ ಬಿಟ್ಟು ಹಾಕಿ ಒಂದ್ ಕಡೆ ಕೂತ್ಕೊಳ್ಳಿ, ಮಾತಾಡಿ. ನಂಗೆ ಹೇಳಿ, ಯಾವತ್ ಮೀಟಿಂಗ್ ಮಾಡ್ತೀರಾ?
15th, between 15th and 17th, any day, I'm thinking.
15th and 17th.
15th to 17th.
ಅಲ್ಲ ಒಂದ್ ಡೇಟ್ ಹೇಳ್ಬೇಕು, ಅವತ್ತು ಅವ್ರು ಬರ್ತಾರೆ ಎಲ್ಲರೂ.
ಅಲ್ಲ 15th ಇಟ್ಕೋ. 16th
ಎಲ್ಲಿ ಮೀಟಿಂಗ್?
ವಿಧಾನಸೌಧ ಬ್ಯಾಂಕ್.
ಎಷ್ಟು ಗಂಟೆಯಿಂದ ಎಷ್ಟು ಗಂಟೆ? ಇದನ್ನೆಲ್ಲ ವಿಡಿಯೋಗ್ರಾಫ್ ಮಾಡ್ಬೇಕು
ಇವರು ಅಲ್ಲ, ಅದನ್ನೇ ದಟ್ಸ್ ವಾಟ್ ಐ ಆಮ್ ಸಪೋಸ್.
ಇಲ್ಲ, ವಿಡಿಯೋಗ್ರಾಫ್ ಬೇಕು. ಯಾಕಂದ್ರೆ ಯಾರು ಹೆಂಗ್ ನೋಡ್ಕೊಂಡ್ರೆ ಇಷ್ಟಿದೆ,
ಹೊರಗಡೆ ಸರ್ಕ್ಯುಲೇಟ್ ಮಾಡಿ
ಮಾಡಂಗಿಲ್ಲ.
ಹೊರಗಡೆ ಸರ್ಕ್ಯುಲೇಟ್ ಮಾಡಿ ನಾನು ಇಲ್ಲ, ವಿ ವಿಲ್ ಪ್ಲೇಸ್ ದಿ ಮಿನಿಟ್ಸ್. ಇವತ್ತು ಸಮಸ್ಯೆ
ಏನಾದ್ರ ಅದ್ರಲ್ಲಿ ಕದ್ದು ಮುಚ್ಚಿ ಹೊರಗೆ ಸರ್ಕ್ಯುಲೇಟ್ ಆತು ಅಂತ ತಿಳ್ಕೊಳ್ಳಿ, ಆವಾಗ ಇದು ನಿಮಗೆ ಉಪಯೋಗ ಆಗ್ಬೋದು. ಗೌರ್ಮೆಂಟ್ ಎಷ್ಟು ರೀಸನೇಬಲ್ ಇದ್ರು ಇವ್ರ ಎಂಪ್ಲಾಯೀಸ್ ಒಪ್ಪಲಿಲ್ಲ ಅಂತ.
ಇಲ್ಲ, ಬೇಡ ಸ್ವಾಮಿ, ನನ್ನ ಹಂಬಲ್
ಯಾಕೆ ಅಂತ
ನಾನು ಈ ಪಬ್ಲಿಕ್ ಲೈಫ್ ನಲ್ಲಿ ನೋಡಿ, ಬೇಡ ಸ್ವಾಮಿ. ನಾನು ವಿ ವಿಲ್ ಅಬ್ಸಲ್ಯೂಟ್ಲಿ, ದಿಸ್ ಇಸ್ ಅವರ್ ಅಂಡರ್ಟೇಕಿಂಗ್. ವಿಲ್ ವಿತ್ ಅವರ್ ಕಾನ್ಶಿಯಸ್ ಆತ್ಮಸಾಕ್ಷಿ ಪೂರ್ವಕವಾಗಿ ಪ್ರಯತ್ನ ಮಾಡ್ತೀವಿ. ಅದು ನೋಡಿ
ವಿಡಿಯೋಗ್ರಾಫ್ ಆಗ್ಲಿ, ಬಟ್ ನಿಮ್ಮ ಮುಂದೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ.
ಅಲ್ಲ, ಹಂಗಾಗಲ್ಲ. ಒಂದ್ಸರಿ ಮಾಡಿದಾಗನೇ ಅಲ್ಲ, 1,000 ಕಡೆ ಹೋಗ್ತದೆ. ಈ ನಮ್ ವಿಡಿಯೋಗಳೇ ನಾವೇ ಸಾಕಾಗಿ, ಹಂಗಾಗಿ ಎಲ್ಲಾ ಕಡೆ ಹೋಗ್ತದೆ. ಬೇಡ, ಬಟ್ ಅವ್ರನ್ನ ನೀವು ಗೌರವಿತವಾಗಿ ನಡೆಸಿ.
ಖಂಡಿತವಾಗಿ ಅದು ಮಾಡ್ತೀವಿ.
ಯಾರಲ್ಲ ಆಫೀಸರ್ ಏನೋ ಈಗ ಬ್ರಿಟಿಷ್ ಗವರ್ಮೆಂಟ್ ಇದ್ದಾಗ
ಅದೆಲ್ಲ
ಹಂಗೆಲ್ಲ ಇಲ್ಲ.
ಖಂಡಿತವಾಗಿ
ಒಂದೇ ಪೆಡಸ್ಟಲ್ ದಲ್ಲಿ ಕುತ್ಕೋಬೇಕು ಎಲ್ಲಾರು. ಎಲ್ಲರೂ ಒಂದೇ ಕಡೆ ಕುತ್ಕೋಬೇಕು, ಮ್ಯಾಲ ಕೆಳಗೆ ಅನ್ನಂಗೆಲ್ಲ. ಕಮಿಷನರ್ ಸೆಕ್ರೆಟರಿ ಎಲ್ಲರ ಜೊತೆ ಒಂದೇ ಕಡೆ ಚೇರ್ ಹಾಕೊಂಡು ಒಂದೇ ನಮೂನೆ ಚೇರ್ ಹಾಕೊಂಡು ಕುತ್ಕೋಬೇಕು.
ಬ್ಯೂರೋಕ್ರಸಿ ಶುಡ್ ನಾಟ್ ಬಿ ಹ್ಯಾವಿಂಗ್ ಮೈಂಡ್. ಬ್ಯೂರೋಕ್ರಸಿ ಮೈಂಡ್
ನಾವ್ ಅದನ್ನ ಒಪ್ಪೋದೇ ಇಲ್ಲ. ಒಂದೇ ರೀತಿಯ ಚೇರ್ ನಲ್ಲಿ ಕುತ್ಕೋಬೇಕು. ಎಲ್ಲರೂ ಬಂದಂತವ್ರೆಲ್ಲರೂ ಒಂದೇ ರೀತಿಯ ಚೇರ್ ನಲ್ಲಿ ಕೂತ್ಕೋಬೇಕು. ಅದು ಫಸ್ಟ್ ರಿಕ್ವೈರ್ಮೆಂಟ್. ಲೆವೆಲ್ ಪ್ಲೇಯಿಂಗ್ ಫೀಲ್ಡ್ ಅಂತಾರಲ್ಲ, ಲೆವೆಲ್ ಪ್ಲೇ. ನಿಮ್ ಬ್ಯೂರೋಕ್ರಾಟ್ಸ್ ಮೊದ್ಲಿಗೆ ಕೆಳಗೆ ಇಳ್ಕೋಬೇಕು. ಫಸ್ಟ್ ಕೆಲಸ ಅದು. ಅವ್ರ ಜೊತೆ ಕುತ್ಕೋಬೇಕು. ಅವ್ರ ಜೊತೆ ಕುತ್ಕೊಂಡು ಟೀ ಕುಡಿದು ಅವ್ರ ಮಾತನ್ನ ನೀವು ಕೇಳಿದ್ರೆ ಎಷ್ಟೋ ಸಾರಿ ನಿಮ್ಗೆ ಉಪಯೋಗ ಆಗ್ತದೆ. ಅವ್ರೊಂದು ಮೇಲ್ಗಡೆ ಕುತ್ಕೊಳ್ಳೋದು, ಇವ್ರು ಕೆಳಗೆ ಕುತ್ಕೊಂಡು ಸ್ವಾಮಿ ಜಮೀನ್ದಾರಿ ಸಿಸ್ಟಮ್ ಇದೆ, ಅದೆಲ್ಲ ನಮ್ಗೆ ನಡೆಯಲ್ಲ.
ಕನೆಕ್ಟಿವಿಟಿ ಬರಲ್ಲ.
ಕನೆಕ್ಟಿವಿಟಿ ಬರಲ್ಲ. ನಂತರ ನೀವು ಬ್ಯೂರೋಕ್ರಸಿ ಅಂದ್ರೆ ನಮ್ಮ ಮ್ಯಾಲಿಂದ ಇಳಿದು ಬಂದಿಲ್ಲ ಅವರು. ಅವ್ರೇನು ಪಬ್ಲಿಕ್ ಸರ್ವೆಂಟ್ಸ್ ಅವ್ರು. ಹಂಗಾಗಿ ಇವ್ರ ಜೊತೆನೇ ಕುತ್ಕೋಬೇಕು. ಹೇಳೋದನ್ನ ಅರ್ಥ ಮಾಡ್ಕೋಬೇಕು.
ಖಂಡಿತವಾಗಿ ಮಾಡಿಸ್.
ಒಂದೇ ರೀತಿಯ ಚೇರ್ ನಲ್ಲಿ ಕುತ್ಕೋಬೇಕು ಎಲ್ಲರೂ, ಬಂದಂಥವ್ರೆಲ್ಲರೂ. ಫಸ್ಟ್ ಅಲ್ಲಿ ಆ ಈಕ್ವಾಲಿಟಿ ಬಂದ್ರೆ ಮುಂದೆ ಲೆವೆಲ್ ಪ್ಲೇಯಿಂಗ್ ಫೀಲ್ಡ್ ಆಗ್ತದೆ. ಇಲ್ಲಪ್ಪ ಅಂದ್ರೆ ಸ್ವಾಮಿ ನಿಮ್ಮ ಪರಿಸ್ಥಿತಿಯಲ್ಲಿ ನಾವಿದೆ, ಅವ್ರ ಅದಕ್ಕಿಲ್ಲ, ಅವ್ರ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ರೈಟ್ ಇದೆ, ಬಂದಾರ ಇಲ್ಲ ಅವ್ರು. ಹಾಗಾಗಿ ಆ ರೀತಿ
ದಟ್ ವಿ ವಿಲ್ ಡೂ ಇಟ್.
ಇದ್ರ ಮೇಲೆ ಆರ್ಡರ್ ಎಲ್ಲ ಬರೆಯೋದು ಬೇಡ.
ಇದು ವಿಡಿಯೋ ರೆಕಾರ್ಡಿಂಗ್
ಬರ್ಕೊಳ್ಳಿ. ದ ಮೀಟಿಂಗ್ ಶಾಲ್ ಬಿ ಹೆಲ್ಡ್ ಯಾವ ಹಾಲ್ನಲ್ಲಿ? ಬಹಳ ಅವಸರ ಇಲ್ಲಿ ಬಹಳ ಅವಸರ ಮಾಡೋದು ಬೇಡ. ವೆಕೇಶನ್ಗಿಂತ ಪೂರ್ವದಲ್ಲಿ ಹಿಯರ್ ಮಾಡಿ, ರಜೆಯಲ್ಲಿ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಬರೆದು ಹಾಕಿಬಿಡ್ತೀವಿ. ಹೌದು, ಆ ರೀತಿ ವಿಲ್ ಮೇಕ್ ಎಫರ್ಟ್ಸ್. ಈಗ ಏನೋ ಒಂದು ಡೇಟ್ ಹೇಳ್ಯಾರ ಅವ್ರು ಪಾಪ ಏನೇನೋ ಇರ್ತಾರೆ. ಮೀಟಿಂಗ್ ಶಾಲ್ ಬಿ ಹೆಲ್ಡ್ ಆನ್ 16 April 2025.
16th Sunday. 15th ಅಂತ ಹೇಳಿ
ಅವ್ರು ಚೂಸ್ ಮಾಡಿ.
ವೆಡ್ನೆಸ್ಡೇ, ಟ್ಯೂಸ್ಡೇ, 16 ವೆಡ್ನೆಸ್ಡೇ.
ಯಾವತ್ತು?
ಏಪ್ರಿಲ್
16. ಏಪ್ರಿಲ್ 16. ಮತ್ತೆ ಅವರು ಇಲ್ಲ ಮಿನಿಸ್ಟ್ರಿ ಮೀಟಿಂಗ್ ಹೋದ್ರು, ಆಗ್ಲಿಲ್ಲ. ನೇರವಾಗಿ ವಾಪಸ್ ಬಂದ್ಬಿಡ್ಬೇಕು ಅವಾಗ. ಎಷ್ಟು ಗಂಟೆಗೆ?
2 o'clock. We will intimate.
ಇಲ್ಲಿ ಹೇಳಿ, ನಮಗೆ ಇಂಟಿಮೇಟ್
3 o'clock ಅಂತ. 3 o'clock.
2 ತಾಸ್ನಾಗ ಆಗಿ ಹೋಗ್ತದಾ?
ಅಥವಾ ಅಲ್ಲ
11 o'clock ಇಟ್ಕೊಳ್ಳಿ.
11 o'clock
ಮಾರ್ನಿಂಗ್ ನೋಡಮ್ಮ. at 11 o'clock. ಎಲ್ಲಿ?
At Vidhan Sauda or Vikas Sauda. We will fix it.
At Vidhan Sauda or Vidhan Sauda or Vikas Sauda. as may be chosen by the officials. ಯಾರಿಗೆ ಇಂಟಿಮೇಟ್ ಮಾಡ್ತೀರಿ? ಅವ್ರು ಎಲ್ಲಿ ಬರ್ಬೇಕು? ಇಲ್ಲಿ ವಿಧಾನಸೌಧಕ್ಕೆ ಬರ್ತಾರೆ, ಇಲ್ಲ ಅಲ್ಲಿ ವಿಕಾಸಸೌಧ ಬರ್ರಿ ಅಂತ ಹುಯ್ಯನ್ ಹತ್ಲಾಗ್ ಹೋಗ್ಬೇಕು.
Anybody,
ಅದ್ ಹೇಳ್ರಿ, ನೀವು ಯಾರು ಹೇಳ್ತೀರಿ? ನಮ್ಗೆ ಹೇಳಿ, ಎಲ್ಲ ಮೊಡಲಿಟಿ ಹೇಳ್ಬಿಡಿ.
ಯಾರಿಗೆ?
ಡಿಸ್ಕ್ರಿಷನ್ ಬೇಡ ಯಾವುದು.
Srikanth, to the council, sir.
ಬರ್ಕೊಳ್ಳಿ.
ಯಾರೋ ಒಬ್ರಿಗೆ ಹೇಳ್ಬಿಟ್ರೆ ಅವ್ರಿಗೆ
Information about venue shall be conveyed to all the advocates appearing for the respondents on record.
ಇದು ಕೆಲವೊಬ್ರು ದೂರದಿಂದ ಬರೋದ್ರಿಂದ ಅವರು ಕೂಡ ಇನ್ಸ್ಟೆಡ್ ಆಫ್ 11 o'clock ವಾಟ್ ಮೈ ಆಫೀಸರ್ ಇಸ್ ಸಜೆಸ್ಟಿಂಗ್, ಮಧ್ಯಾಹ್ನಕ್ಕಾದ್ರೆ ಅವರು ಬಹಳ ಹಳ್ಳಿಯಿಂದಲ್ಲ ದೂರದಿಂದ
ಇಲ್ಲ, ಅವ್ರು ಒಂದ್ ದಿವ್ಸ ಮೊದಲೇ ಇದ್ಬಿಡ್ತಾರೆ. ಅದೇ ಪ್ರಾಬ್ಲಮ್ ಇಲ್ಲ, ನಿಮ್ಮವ್ರು ರೆಡಿ ಇರ್ಬೇಕು ಅಷ್ಟೇ. ಅವ್ರು ಪಾಪ ರೆಡಿ ಇರ್ತಾರೆ. 11ಕ್ಕೆ ಇಟ್ಕೊಳ್ಳಿ, ಟೈಮ್ ಬೇಕಾಗ್ತದೆ ಅದಕ್ಕೆ ಹಾಗಂತ. ಇದೊಂದು ಎಕ್ಸರ್ಸೈಸ್, ಒಂದು ಆಪ್ಷನ್ ಇದು.
ಎಸ್ ಯು ಲಾರ್ಡ್,
ಇಬ್ಬರಿಗೂ ಒಂದೊಂದು ಆಪ್ಷನ್ ಇದು. ಓಕೆ, ನೆಕ್ಸ್ಟ್ ಬರ್ಕೊಳಮ್ಮ. All the stakeholders attending the meeting shall conduct themselves very honorably without giving any room for any complaint or the like. First off, if any untoward incident happens, that shall be one of the factors that would enter the decision-making process of these petitions, appeals. First, the proceedings of the meeting shall be formally drawn and shared with the stakeholders present in the meeting and with the court on the next date of hearing. Ali kama kottu, and with the court on the next date of hearing. ಅವತ್ತೇ ನೀವು ಡ್ರಾ ಮಾಡಬೇಕು, ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅನ್ನ ಡ್ರಾ ಮಾಡಿ ಕೊಡ್ಬೇಕು. ಅಲ್ಲಿ ನಮ್ಗೆ ಸ್ವಲ್ಪ ಡೌಟ್ ಇದೆ ಗವರ್ಮೆಂಟ್ ಮೇಲೆ. ಹೌದು ಹೌದು, ಅಲ್ಲಿ ದಿ presence, the attendance register shall be signed by all the participants along with their mobile numbers and employee numbers. Enra irtada?
Yes.
Aided school alli enu? Aided school alli enu iralla?
Every employee as well.
ಅಲ್ಲ, ಎಂಪ್ಲಾಯ್ ನಂಬರ್ ಇದ್ರೆ ಆಗೋದು. ದಟ್ ಈಸ್ ದಿ ರೀಸನ್. ಎಂಪ್ಲಾಯ್ ನಂಬರ್ ಬೇಕು.
ಗವರ್ಮೆಂಟ್ ನವರಿಗೆ ಇರ್ತದೆ, ಇವ್ರಿಗೆ ಇರಲ್ಲ ಅಂತ.
ಅಲ್ಲ, ಅವ್ರಿಗೂ ಒಂದು ಅವ್ರು ಗ್ರಾಂಟ್ ಇನ್ ಏಡ್
with employee number if any.
Grant in aid,
and they shall register their Aadhaar number as well.
ಎಂಪ್ಲಾಯ್ ನಂಬರ್ ಕೊಡ್ತಾರೆ.
ಎಂಪ್ಲಾಯ್ ಎಲ್ಲರಿಗೂ ಇರ್ಲಿದ್ರೆ ಈಗ ಆಧಾರ್ನಾಗ ಎಲ್ಲ ಬಂದ್ಬಿಡುತ್ತೆ. ಏಡೆಡ್ ನವ್ರಿಗೆ ಇರ್ಲಿಕ್ಕಿಲ್ಲ ಅಲ್ಲ. ಇಫ್ ಎನಿ, ವಿ ಹ್ಯಾವ್ ಸೆಡ್
ಎಸ್,
ಇಫ್ ಎನಿ ಇತ್ತು ಅಂತ. ಓಕೆ, ಅದನ್ನ ಇದನ್ನು ಡ್ರಾ ಮಾಡ್ಬೇಕು, ಪ್ರೊಸೀಡಿಂಗ್ ಶೀಟ್ ಡ್ರಾ ಮಾಡ್ಬೇಕು.
Senior citizens are there, my lord. All are senior citizens, my lord. All are cities, yes, almost senior citizens are there, my lord. There is a difficulty to approach the meeting.
ಯಾರಿಗೆ ನಾವು ಎಲ್ಲರಿಗೂ ಅಲೋ ಮಾಡಿಲ್ಲ, ಎಂಪ್ಲಾಯೀಸ್ ಅಲೋ ಮಾಡಿಲ್ಲ. ನಾವು ಬರೀ 5 ಜನರ ಅವ್ರೇನ್ ಚೂಸ್ ಮಾಡ್ತಾರೆ, ಯುನಾನಿಮಸ್ಲಿ ನೀವು ಚೂಸ್ ಮಾಡಿಕೊಂಡು ನೀವು ಕೊಡ್ಬೇಕು ಅವ್ರಿಗೆ. ಎಲ್ಲ ಅಷ್ಟು ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಎಲ್ಲ ಆನ್ಲೈನ್ ಇರೋದಕ್ಕೆ ನೀವು ನೋಡ್ಕೋಬಹುದು. ಓಕೆ,
The pertaining to Kannada increment case, my lord. The pertaining to Kannada increment case, my lord. Only one additional increment is there, my lord. It's not
call this matter on ಯಾವತ್ತು? ನೋ ನೋ ನೋ, ಮೊದಲಲ್ಲಿ ಡೇಟ್, ಯಾವ ಡೇಟ್ ಸಿಟ್ಟಿಂಗ್ ಇದೆ ನೋಡಿ. ನೆಕ್ಸ್ಟ್ ಸಿಟ್ಟಿಂಗ್ ಡೇಟ್ ಇದು ಏಪ್ರಿಲ್ ನಲ್ಲಿ. ಅದು ಮಾಡ್ಕೊ ಒಂದ್ 2 ದಿವಸ, ಏನೋ 1 ದಿವಸ 2 ದಿವಸ ಹಿಯರಿಂಗ್ ಮಾಡಿ ನಿಮ್ಮ ನೋಟ್ಸ್ ತೊಗೊಂಬಂದ್ಬಿಡಿ. ಓದಕ್ಕೆ ಹಿಯರಿಂಗ್ ಮಾಡ್ಕೊತ ಹೋಗಲ್ಲ, ನಾವೆಲ್ಲ ಓದಿದ್ದೇವೆ ಪೇಪರ್ಸ್. ನೋಟ್ಸ್ ತೊಗೊಂಬನ್ನಿ, ನಿಮ್ಗೊಂದ್ ತಾಸು, ಇವ್ರಿಗೊಂದ್ ತಾಸು ಮುಗಿಸ್ಬಿಡ್ಬೇಕು.
Kannada increment in case different ಆಗುತ್ತೆ ಸರ್.
ನೆಕ್ಸ್ಟ್ ಅವ್ರ ಹಂಗೆ ಹೇಳ್ಕೊತ ಹೋಗ್ತಾರ, ಅದೆಲ್ಲ ಉಪಯೋಗ ಇಲ್ಲ. ಕಾಲ್ ದಿಸ್ ಮ್ಯಾಟರ್ 14th and 18th.
ಅಲ್ಲ, ಇದು ಯಾವತ್ತು? This is on 16th.
ಅದರ 15th ಹಾಕೊಳ್ಳಿ. ಮೀಟಿಂಗ್ ಮಾಡಿ 16, 17 ನೀವು ಹೋಗ್ತಾ ತೊಗೊಂಡೋಗಿ 15th 11th ಮಾಡ್ಕೊಂಡು ನೋಡಿ 50 ಆಗಲ್ಲ, ಅದು 16th ಆಗಲ್ಲ, 11th ಮಾಡ್ಕೋಬೇಕು ಮೀಟಿಂಗು, 11th ಮಾಡ್ಕೋಬೇಕು, 16th ಮ್ಯಾಟರ್ 15th ಮ್ಯಾಟರ್ ಪೋಸ್ಟ್ ಮಾಡ್ತೀವಿ. ಓಕೆ, ಹಾ ಅಲ್ಲ ನಾವು ತಯಾರಿ ಮಾಡ್ಬೇಕಲ್ಲ ಜಡ್ಜ್ಮೆಂಟ್, ವೆಕೇಶನ್ ನಾವು ಜಡ್ಜ್ಮೆಂಟ್ ರೆಡಿ ಮಾಡಕ್ಕಾಗ್ತದೆ. ಅದಕ್ಕೆ ಹಂಗಾಗಿ 15th ಬರ್ಬೇಕು ನೀವು. 15, 16, 17 3 ದಿವಸ ಇದೆ. ಅರ್ಧ ದಿವಸ ಎಲ್ಲರಿಗೂ ಒಂದೊಂದು ತಾಸು ಕೊಡ್ತೇವೆ ನಾವು. ನಿಮ್ಮ ನೋಟ್ಸ್ ತರಬೇಕು, ಉದ್ದಕ್ಕೆ ಹೇಳ್ಕೊತ್ ಕೊಡಂಗಿಲ್ಲ, ನಾವೆಲ್ಲ ಓದ್ಕೊಂಡ್ ಬಂದ್ಬಿಡ್ತೇವಿ, ನೀವು ಓದ್ಕೊಂಡ್ ಬರ್ಬೇಕು.
Submission, my lordship, I'm permitted.
Call this man. ಅಲ್ಲಿ ನೋಡಮ್ಮ 15th 8th of April. 8th of April ಅಟೆಂಡ್ ಮಾಡ್ಬೇಕು ಮುಂದೆ, ಯಾಕಂದ್ರೆ ಹಿಯರಿಂಗ್ ಡೇಟ್ ಬೇಕಾಗತ್ತೆ ನಮ್ಗೆ ಅದಕ್ಕೆ. ಓಕೆ, and brother is traveling abroad also, that's the reason. 15th ನಾವು ಲಿಸ್ಟ್ ಮಾಡ್ತೀವಿ. 15th ಟೈಮ್ ಕೊಡಲ್ಲ, ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬೇಕು 15th ತೊಳಿ. ಆಮೇಲೆ ಇನ್ನೊಂದು ಮೀಟಿಂಗ್ ಡೇಟ್ ಇದೆಲ್ಲ ಏನಿಲ್ಲ. ಓಕೆ, ಕಾಲ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಫಾರ್ ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಆನ್ 15/4.
My lords, one submission. My lords, they indicated that, my lord, there need not be, my lords, any video recording as such. But what I submit, my lords, CCTV footage, my lord, can be filed before the court.
ನೀವು ಹೇಳಿದಲ್ಲ ವಿಧಾನಸೌಧ ಇದು ಅಂತ ಹೇಳಿದ್ವಲ್ಲ.
8th,
9th ತೋಳು
ವೆಲ್ ಇನ್ ಅಡ್ವಾನ್ಸ್. ಆಲ್ ರೈಟ್ ಮುಗಿಸ್ಕೊಂಡ್ ಬರ್ಬೇಕು, ರಿಪೋರ್ಟ್ ಮಾಡ್ಬೇಕು, ಸೆಟಲ್ಮೆಂಟ್ ರಿಪೋರ್ಟ್ ಮಾಡ್ಬೇಕು.
Brother.